The audio clear ಇದೆಯಾ ಕೋಟ್ವಾಲ್ 18? The audio clear ಇದೆಯಾ? The ಕೋಟ್ವಾಲ್ 18 ಇಂದ audio clear ಇದೆಯಾ? Hello. Krishnan sir, audio clear ಇದೆಯಾ?
ಇದೆ ಮೇಡಮ್.
Hello, court officer. Hello. Court officer. Madam, adjournments starting page wise ಕರೀತೀರಾ madam?
Page.
Okay, thank you.
ನಾನು ಅದೇ ಹೇಳ್ತಾರೆ ಉಳಿಸ್ಕೊಂಡಿದ್ದೀರಾ
Remove your mask and make submission. Remove your mask and make submission, counsel. ಏನಾಗ್ಬೇಕು ವೇಟ್ ಮಾಡ್ಬೇಕು. ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಅಲ್ಲ ನೋಡೋಣ. ನಾವು ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ ಪೇಜ್ ವೈಸ್ ಕರಿತೀವಿ, ಆಗ ಮೆನ್ಷನ್ ಮಾಡಿ. ಆಯ್ತು ಫೈಲ್ ಮಾಡಿ ಬರುತ್ತೆ ರೋಸ್ಟರ್ ಪ್ರಕಾರ ಅಷ್ಟೇ. ತಗೊಳ್ಳಿ 26 to 31. ಹೇಳಿ ಏನಾಗ್ತದೆ?
Serial number 30, my lord. Serial number 30. I pray for 2 weeks. Senior is not well, my lord.
ಹೇಳಿದಿರಾ ನೀವು? ಇಂಟಿಮೇಟ್ ಮಾಡಿದಿರಾ ಅದರ್ ಸೈಡ್ ಗೆ?
I'll intimate, my lord. Senior is not well.
ಹೇಳ್ಬಿಟ್ಟು ಮಾಡಿ. ಕನೆಕ್ಟೆಡ್ 2 ಮ್ಯಾಟರ್ಸ್ ಇದೆ. ಎಸ್ ಕೌನ್ಸಿಲ್ ಹೇಳ್ರಿ.
30, my lord. Senior is not well, my lord.
Junior is enough. Junior is enough.
I'm out of station, my lord. That is it.
Petitioner counsel 6 time. This matter. Yav madam? 8th of April.
Lordship, serial number 26.
26. Counsel.
Oh no, I just want to ask whether the PP took time, Your Lordship.
No. PP is not here.
The respondent said the
respondent side is not PP.
Yes, Your
No.
Lordship.
Matter is pending. No one moved any adjournment. 32 to 40. ಹೇಳಿ 33. Petitioner counsel 6 time. List this matter on 8th April. Yes. What's your good name? JN Pavitra N for JN Naveen submits that they have received NOC Wakalat Akidira Wakalat and going to file the Wakalat, and if Wakalat is filed, show the name and list this matter. Yavaga, when do you want? 8th of April. 37 S council ಹೇಳಿ. ಹೇಳಿ. ಆಯ್ತು, petitioner council 6 time. List this matter on 8th April. 41 to 50.
But serial number 49, my lord.
49 S council. Balraj ಹೇಳಿ.
ಇದರಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ.
Petitioner council 6 time on the ground. There is a settlement proposal. And hence list this matter on 8th April.
8th ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸ್ವಲ್ಪ 15th or 16th ಮೇಲೆ.
15 days ಕೊಟ್ಟಿರೋದು. 2 weeks ಕೊಟ್ಟಿದೀವಿ ನೋಡಿ ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Yes, yes.
51 to 59. 51 to 59.
Serial number 51, Your Honor.
Serial number
51.
51. What do you want, madam? This matter on 8th April.
Lordship, serial number 75.
Serial number
Oblige, Your Honor.
75.
75. Wait ಮಾಡಬೇಕು.
2 weeks time be
Wait ಮಾಡ್ರಿ ಕೌನ್ಸಿಲ್. Page wise ಕರ್ದಾಗ ಮೆನ್ಷನ್ ಮಾಡಿ. 60 to 69.
Milord, 62 Milord, 62 Milord.
Yes, council.
May I undergone the cadet operation Milord?
The petitioner council 6 time list this matter on 2012 matter.
Yes Milord, I do understand.
8th April.
Much obliged Milord, much obliged.
70 to 80.
Not serial number
72, madam. Senior? Junior counsel submits that senior. Have you informed other side? Already informed. Petitioner junior counsel submits that senior counsel not keeping well, and also submits that already informed R2 to R4 counsel. New idea urgent ಆಗ್ತಾ ಇದೆ. This matter on 8th April.
Not serial number 76, my lords.
76, yes, counsel.
Notes, I pay for the petition. The other side is state notes. I'm just seeking a week's time to ascertain. I'm not able to communicate the petitioner notes. Just
Petitioner counsel 6 time list this matter on 8th April.
Please, notes.
Other side respondent state.
Serial number 75. Lordship.
75, yes, counsel.
1 week's time be granted, Lordship.
Matthew, 2013 matter. Petitioner counsel 6 time list this matter on 8th April. 81 to 89.
Not serial number 82, my lords. 138 proceedings. Respondent has died. I have to bring the errors, my lords. A week's time, my lords.
Who is no more? Respondent.
Respondent, yes, my lords.
Petitioner counsel submits that respondent is no more and
Wants to bring
intend to file a necessary application to bring the LRs and 6 time. Have you informed other side?
Lords, I shall inform, my lords. But the fact remains he has died, my lords.
8th April.
Please, my lords.
Serial number 86, my lord.
86, yes, counsel.
Appear for petition. Kindly 1 week time granted, my lord.
Why?
The senior person inquiries ಮೇಲೆ out of station ಇದ್ದಾರೆ. On next week ಅಲ್ಲಿ any date ಆಗಬಹುದು.
Have you informed other side?
ಹೇಳಿದ್ರಿ ಜಗದೀಶ್ ಸರ್ ಹೇಳಿದ್ರಿ ಸರ್.
ಹೇಳಿದಿರಿ. Counsel 6 time and also submits that already informed the special counsel Sri Jagdish and has this matter on 8th April.
Please, my lord.
90 to 100. 90 to 100. ಯಾರಿಲ್ಲ. ಈ ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ ಅಂದ್ರಲ್ಲ ನೀವು. ಆಯ್ತು. ರೋಸ್ಟರ ನಾಳೆ ಕೊಡಕ್ಕಾಗಲ್ಲ. ನಾಳೆಗೆ ಯಾಕೆ ಕೊಡ್ಬೇಕು? ವಾಟ್ ಇಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ ಫಾರ್ ಟುಮಾರೋ? ಆಯ್ತು. You file an application before the trial court bringing LRs. ಮತ್ತೆ ಆಯ್ತ್ರಿ, ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನಂದೆ ನಾಳೆಗೆ? ಯಾವ್ದಾದ್ರು ಅಷ್ಟೇ, ನೋ ಅರ್ಜೆನ್ಸಿ. ನೆಕ್ಸ್ಟ್ ನಾಳೆ ಮಾಡ್ತೀರಾ? Petitioner counsel seeks 2 days time to comply with office objection. If complied, post the matter before court. If complied, post the matter as per roster. Serial number 2, Praveen C. Absent 2 weeks. Madam, regarding maintainability. Concurrent finding. Concurrent finding revision ಲೈಸ್ ಆಗುತ್ತೆ. ಯಾಕೆ ಮೇಡಮ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನೋಡಿ? ಹೌದು, ಓನ್ಲಿ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ ನೋಡಿ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಮೇಡಮ್? ಕನ್ಕರೆಂಟ್ ಅಥವಾ ಏನು? ಓನ್ಲಿ ಯು ಆರ್ ಸೀಕಿಂಗ್ ಫಾರ್ ರಿಲೀಫ್ ಆಫ್ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ದಿ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಆರ್ಡರ್. ಕೊಡಿ ಮೇಡಮ್, ನಂಗೆ ಫೈಲ್ ಕೊಟ್ಬಿಡಿ, ನಾನೇ ನೋಡ್ಬಿಡಿ. Hereby occurred acquitted, confirmed, revision license. Acquittal ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ, ಅಪೀಲ್ ಆಲ್ಸೋ ಡಿಸ್ಮಿಸ್ಡ್, ರಿವಿಷನ್ ಲೈಸ್ ಅಲ್ವಾ? ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ಕೇಳಿ ನೋಡಿ ಆಫೀಸ್ನವ್ರು. ಡೈವರ್ಜೆಂಟ್ ಇಲ್ಲ ಮೇಡಮ್, ಅದಕ್ಕೆ ನಾನು ನೋಡಿದ್ದು. ಅಕ್ವಿಟಲ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್, ಡೈವರ್ಜೆಂಟ್ ಹೆಂಗ ನೋಡಿ? ಪಾಸ್ ಓವರ್ ವೆರಿಫೈ ಮಾಡಿಸಿ ಅದೇನು ಆಫೀಸಲ್ಲಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 4, ಪ್ರಸನ್ನ ಕುಮಾರ್ ಪಿ ದರೋಜಿ, ಆಬ್ಸೆಂಟ್ 2 weeks. ಅಕ್ರಮ್ ಪಾಷಾ, ಆಬ್ಸೆಂಟ್ 2 weeks. ಮುದುಕಣ್ಣ ಗೌಡ A2, ಆಬ್ಸೆಂಟ್ 2 weeks time. ಮಹೇಶ್ ಬಿಜೆ, ಆಬ್ಸೆಂಟ್ 2 weeks. ಅವಿನಾಶ್ AP, absent 2 weeks. Manjunath PR, absent 2 weeks. Krishnan,
I am for petitioner, my lord.
Counsel.
It's a diverse. It is not a concurrent file, my lord. There is the appeal is
Counsel
partly
compliance. Compliance.
1 week may be granted, my lord.
Petitioner counsel seeks 1 week time granted. Non-compliance second time. Serial number 11, Approach Pasha, absent 1 week time granted. Counsel seeks 1 week time granted. Counsel seeks 1 week time granted. Chalke, Satnarayan Chalke, absent 2 weeks. Third time Babu. This matter is listed third time, no representation today also. And hence urgent on cost of ₹500 payable at registry and 1 week time granted. If cost not paid and if not complied, is this matter on? Oh, madam. 6th of April. Jitendra. Petitioner counsel seeks 1 week time, urgent on cost of ₹500 payable at registry. 1 week time granted. 7th time RB Sadashivappa. Memo for conversion ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಪಾಸ್ ಓವರ್ ಮಾಡಿ, ಕಾಸ್ಟ್ ಎಲ್ಲ ಕಟ್ಟಿದ್ದಾರೆ ನೋಡಿ. 7th ಟೈಮ್ ಅಂದ್ರೆ ಕಾಸ್ಟ್ ಹಾಕಿರ್ತಾರೆ. ಪಾಸ್ ಓವರ್ ವೆರಿಫೈ ಮಾಡಿ. ಆರ್ಡರ್ಸ್ ಫಸ್ಟ್ ಟೈಮ್ HEGP is directed to take notice and file objections if any. List this matter. ನೋಟಿಸ್ ಆಗಿದೆಯಾ? ಮತ್ತೆ ಫಸ್ಟ್ ಟೈಮ್ ಅಂತಾರ ಅವರು. ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. HEGP directed to take notice ಅಂತ 28(2) ನಲ್ಲೇ ಹಾಕಿದೆ. And to file objections if any ಅಂತಿದೆ. Learned counsel for the petitioner seeks time for compliance of office objection. Post the matter after compliance ಅಂತಿದೆ. ಆಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಲಿಲ್ವಾ ನೀವು? ಮತ್ತೆ ಈಗೇನ್ ನಿಮ್ಗೆ ಟೈಮ್ ಬೇಕಾ? ಆಯ್ತು, petitioner counsel seeks 1 week time. This matter on next Monday. ಎಷ್ಟು ಮೇಡಮ್? 4th April. K. Ravishankar. Then quantity and 350 grams of what? MDMA. This is a manufactured drug. This is a manufactured drug. Where is the earlier order? This is by A2, na? Now, why this is listed again before me? If it is not before me earlier, madam, why it is listed before me? Crime ಹಂಗಾಗೋದಿಲ್ಲ. ನನ್ನ ಮುಂದೆ ಯಾವ್ದಾದ್ರು ಅಕ್ಯೂಸ್ ಏನಾದ್ರು ಅರ್ಲಿಯರ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ರೆ ಮಾತ್ರ ನಮ್ಮ ಮುಂದೆ ಬರ್ಬೇಕು. ಒಂದ್ ಕ್ರೈಮ್ಗೆ ಎಲ್ಲದಕ್ಕೂ ನಮ್ಗೆ ನಮ್ಮ ಮುಂದೆನೆ ಬರ್ಬೇಕು ಅಂತಿಲ್ಲ. ವೈ ಇಟ್ ಇಸ್ ಲಿಸ್ಟೆಡ್? ಇವ್ರದ್ದೇ ಡಿಸ್ಮಿಸ್ ಮಾಡಿಸ್ಕೊಂಡಿದಾರಾ? ಮತ್ತೆ ನಿಮ್ದೆ ಆಗಿದೆ ರೀ. Criminal petition number 4683 of 21, which is dismissed before Honorable Justice. ನಿನ್ನ ಹೆಸರೇನು? ರೋಹಿತ್ ಕ್ರಿಸ್ಟಫರ? ಹಾಗೆ ಅರ್ಲಿಯರ್ ಹಾಕಿದಾನೆ ನೋಡಿ. ನಾಟ್ ವಿಡ್ರು. ಆರ್ಡರ್ ಕಾಪಿ ಇಟ್ಟಿದಾರ ಮೇಡಮ್ ಆಫೀಸ್ನವರು? ಕಾಪಿ ಇಡಲ್ವಾ? ಯಾಕೆ ಇದೆಯಾ ನೋಡಿ. ಏನ್ ರೀಸನ್ ವಿಡ್ರಾ ಮಾಡಿದಾರ ಅಥವಾ ಏನು? ನಿಮ್ ಕ್ಲೈಂಟ್ ನಿಮ್ಗೆ ಕೊಡುವಾಗ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಡ್ಬೇಕಲ್ವಾ? ವಿಡ್ರಾನ್ ಇದೆಯಾ? ಅದ ಇದೆಯಲ್ಲ. Memo seeking permission to withdraw the petition on the ground that charge sheet has already been filed and the petitioner is intent to pursue the matter before the trial court in lieu of filing of the charge sheet. Right. Alla, why your client has not brought to notice of this court earlier petition was dismissed anta? In petition alli helidira? ಆಯ್ತು ಹೇಳಿದೀರಾ ಅಂದೆ. earlier petition was filed and ಹೇಳ್ಬೇಕಲ್ವಾ ಅದು? ಮತ್ತೆ in each and every case this is happening. That's why last Friday I gave a direction. It is nothing but fraud on the court anta. You should mention it. ಒಂದ್ ಕಾಲಮ್ ಯಾವ ಕೋರ್ಟಲ್ಲೂ ಹಾಕಿಲ್ಲ ಅಂತ ಎಲ್ಲೂ ನೀವು ಹಾಕೇ ಇಲ್ಲ. ಅದನ್ನ ಆ ಕಾಲಮ್ಮೇ ನೀವು ಬರ್ದಿಲ್ಲ. ಹೆಂಗಿದು ಪಾಸ್ ಆಯ್ತು ಮೇಡಮ್? ಇದು ಪಿಟಿಷನ್ ಹೆಂಗ್ ಪಾಸ್ ಆಯ್ತು? ಯಾವ 3 ನಲ್ಲಿ? Petitioner has not filed any other bail petition on same cause of action before this court or pending before any other court on the same cause of action. Is it not false, Amarman? Custodial ಇದ್ರೇನು? You should give all details. Why happening this ಅಂತಂದ್ರೆ ಅಲ್ವಾ? ನಮಗೆಲ್ಲ ಅದಕ್ಕೆ ಒಂದು I have given directions to the registry to evolve a modern mechanism. Once crime number ಹೊಡೆದ ತಕ್ಷಣ ಎಲ್ಲ ಬರ್ಬೇಕು. ಎಲ್ಲೆಲ್ಲ ಹಾಕಿದಾನೆ ಇಡೀ ಥ್ರೂಔಟ್ ಸ್ಟೇಟ್. ಯಾಕೆಂದ್ರೆ ಮೊನ್ನೆ what we noticed here also they filed petition and also approached the Tumkur court, Mysore court. Everywhere went and filed several petitions suppressing all this. ಆಮೇಲೆ 3 petition ಫೈಲ್ ಮಾಡೋದು. ಬೆಂಚ್ ಹಂಟಿಂಗ್. ಯಾರು ಸ್ವಲ್ಪ ಯಾವ ಜಡ್ಜ್ ಏನಾರು ಲಿಬರಲ್ ಇರುತ್ತೋ ಅಲ್ಲಿ ಹೋಗಿ ಪಿಟಿಷನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು, ಬೇರೆವೆಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋದು. ದಿಸ್ ಇಸ್ ನಾಟ್ ದಿ ಕಾಂಡಕ್ಟ್ ಆಫ್ ಅನ್ ಅಡ್ವೊಕೇಟ್ ಅಲ್ವಾ? ಅವನ ಹಣೆ ಬರ, ಪಾರ್ಟಿ ಹಣೆ ಬರ. ಅವ್ನ್ ಏನ್ ಮಾಡಿರ್ತಾನ ಅವ್ನ್ಗೆ ಹಂಗ ಆಗ್ತದೆ. ರಿಲೀಫ್ ಸಿಗುತ್ತೋ ಸಿಗಲ್ವೋ ಅವ್ನ ಹಣೆ ಬರ, ಅವ್ನ್ ಏನ್ ಮಾಡಿರ್ತಾನ ಅವನದು. ಬಟ್ ಅಡ್ವೊಕೇಟ್ ಶುಡ್ ನಾಟ್ stoop to this level. That's why I have given directions last week. They should mention properly. ಹೇಳಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ. ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
He has got on 28/2021. Complaint is important. Standing is upon road. And on the time information that the police have read it. And from the food sticky. That is based upon the voluntary statement of accused number 1, stating that he has got from Nigeria. this petitioner is also involved in that case.
But both were together. Ah. ಹೌದು. Now counsel law is very clear. NDPS, if it is a commercial quantity under section 37 of NDPS Act, court should satisfy that they have not committed the offense. Then you have to make this court to believe that they have not committed guilty of the offense. Is a reverse burden on the not on the prosecution. It is reverse burden on the accused. Test report is negative. Page number 36.
NDMA is negative. Some other which positive, non-positive.
So that is what is that?
NDMA has been done with negative.
The sample found in article 1 has responded positive for methamphetamine.
NDMA has been done negative.
Negative for
NDMA. Their specific case is NDMA.
Then if it is methamphetamine, what is the commercial quantity? Total ಎಷ್ಟು ಮೇಡಮ್? ನೋಟಿಫಿಕೇಶನ್ ನೋಡಿ, ಇದರಲ್ಲಿ ಇರುತ್ತೆ, NDPS Act ಅಲ್ಲಿ ಇರುತ್ತೆ ನೋಡಿ.
Standing order 1/80.
Two-wheeler belongs to A1 ಡೇಟು ಆರೋಪಿಗಳು KA ಸೌಂಡ್ಸು ನೋಂದಣಿ ಸಂಖ್ಯೆ TVS ಜುಪಿಟರ್ ಸ್ಕೂಟರ್ ನಿಲ್ಲಿಸಿಕೊಂಡು ಇರುವುದು ಕಂಡು ಬಂದು ಭಾರತದ ಮಾಹಿತಿಯನ್ನು ಖಚಿತಪಡಿಸಿಕೊಂಡು ಸ್ಥಳಕ್ಕೆ ಬಂದ ಸಾಕ್ಷಿ 2 ರವರ ಸಮಕ್ಷದಲ್ಲಿ ಸ್ಕೂಟರ್ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿ ಸ್ಕೂಟರ್ನ ಡಿಕ್ಕಿಯಲ್ಲಿ ಒಂದು ಪ್ಲಾಸ್ಟಿಕ್ ಕವರ್ ನಲ್ಲಿ ಆರೋಪಿ ಹೊಸದಿಂದ ಒಂದು ಚಿಕ್ಕ ವೇಯಿಂಗ್ ಮೆಷಿನ್ ಮತ್ತು ಚಿಕ್ಕ ಪ್ಲಾಸ್ಟಿಕ್ ವೇಯಿಂಗ್ ಮೆಷಿನ್ ಎಲ್ಲ ಇದೆಯಲ್ಲ, ಮಾದಕ ವಸ್ತು ವೇಯಿಂಗ್ ಮೆಷಿನ್ ಮತ್ತು ಚಿಕ್ಕ ಪ್ಲಾಸ್ಟಿಕ್ ಜಿಪ್ಲಾಕ್ ಕವರ್ಗಳು, ಒಂದು ಸ್ಯಾಮ್ಸಂಗ್ ಮೊಬೈಲ್ ಫೋನು ಹಾಗೂ A2 ಆರೋಪಿಯ ವಶದಿಂದ ಒಂದು ವಿವೋ ಕಂಪನಿಯ ಮೊಬೈಲ್ ಫೋನು ಮತ್ತು A1 A2 ಕೃತ್ಯಕ್ಕೆ ಬಳಸಿದ್ದ TVS ಜುಪಿಟರ್ ಸ್ಕೂಟರ್ ನಂಬರ್ ಸೋನ್ಸೋ ಇವುಗಳನ್ನು ಪಂಚನಾಮೆ ಮುಖ್ಯನ ವಶಪಡಿಸಿಕೊಂಡಿದ್ದು. ವೆಹಿಕಲ್ ಬಿಲಾಂಗ್ಸ್ ಟು whom ಮೇಡಮ್? ಟೂ ವೀಲರ್. ನಂತರ A1 ಆರೋಪಿತನ ಮಾಹಿತಿ ಮೇರೆಗೆ ಆತನ ವಾಸವಿದ್ದ ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ ಆರೋಪಿತನ ಹೆಸರಿನಲ್ಲಿದ್ದ ಭಾರತ ದೇಶದ ನಕಲಿ ವೀಸಾ ಜೆರಾಕ್ಸ್ A1 ಆರೋಪಿತನ ವಿವಿಧ ವ್ಯಕ್ತಿಗಳ ಹೆಸರಿನಲ್ಲಿ ಬ್ಯಾಂಕ್ ಖಾತೆಗಳಿಗೆ ವಿವಿಧ ದಿನಾಂಕಗಳನ್ನು ಹಣವನ್ನು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದ ಮನಿ ಟ್ರಾನ್ಸ್ಫರ್ ಸ್ಲಿಪ್ಗಳು, ನಗದು ಹಣ, all technicalities cannot be decided when considering that is the judgment of the apex court. ಕೊಡಿ. Ganja is different from MDMA or methamphetamine. That is whether this order is passed referring the section 37 of the not my judgment. This is not my judgment.
Also record for constructive
Union of India, that is Nawaz Khan judgment. Nawaz Khan judgment. 50 kg of 200 grams. Maybe a commercial quantity. It is only a narcotic substance, not manufactured drug. Different. There is a difference between manufactured drug as well as ಇದೆಯಾ ಮೇಡಮ್? criminal antecedents ಏನಾರು ಇದೆಯಾ ಮೇಡಮ್? Why you have not verified till date? Why you have not verified till date, madam? Third in part. HCP seeks time to verify with regard to the criminal antecedents of this petitioner. Please this matter on Monday date ಕೊಡಿ. Monday date 4th of April. Verify ಮಾಡಿ madam. ಆಮೇಲೆ ನೋಡಿ MDMA ಅಲ್ಲ, the report is negative with regard to the MDMA. ಮೆಟಾಫೆಟಮೈನ್ ಏನೋ ಇದ್ದಂಗಿದೆ ನೋಡಿ, ಅದ್ರ ಕ್ವಾಂಟಿಟಿ ಏನು ಅಂತೆಲ್ಲ ನೋಡ್ಕೊಳ್ಳಿ. 20 ರುದ್ರಭೂಷಣ್ CB. Yes, counsel. 30th ಇದೆಯಾ? Petitioner counsel submits that connected matter is posted on 30th and hence this also may be listed on 30th. Yes, counsel. Return to trial court ಏನಂತ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆಗಿದೆ. ಮೀಡಿಯೇಷನ್ ರಿಪೋರ್ಟ್ ಏನಾಯ್ತ್ರಿ? ಹಾ ಹ್ಮ್ ಹ್ಮ್ ಹಾ ಹಾ ಏನ್ ಬೈ ವೈ ಯು ನಾಟ್ ಕಂಪ್ಲೈಂಟ್? 1 week ಟೈಮ್ ಆಮೇಲೆ ನೋಡೋಣ. ಹ್ಯಾವ್ ಯು ಕಂಪ್ಲೈಂಟ್ ದಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್? ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಅಷ್ಟು ಹೇಳಿ ಫಸ್ಟ್. ಆರ್ಡರ್ ಕೊಡಿ ಮೇಡಮ್. ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ಸ್ಟೇ ತಗೊಂಡ್ಮೇಲೆ ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಇಲ್ಲ, ಕಂಡೀಷನಲ್ ಆರ್ಡರ್ನ 20 lakhs ಮಾತ್ರ. ಎಷ್ಟು ಬರ್ಬೇಕು ಅದು? 50%. Generally heard on IA3 the operation and so 2016. Subject to the petitioner depositing. Already you can proceed with if they have not paid the amount, 50% of the amount. Order is very clear. Suspended subject to the petitioner depositing 50% of the fine amount before the trial court, less the amount already deposited within 4 weeks from today. If they are not deposited, you proceed with the order is very specific. Subject to depositing of 50%. You can take coercive steps. That's all. Third, respondent counsel would submit that. How ಕೊಡೋದಿಲ್ಲ 2016 ಇಸ್ವಿ ಆರ್ಡರ್ ರೀ. Now we are in 2022 after 6 years. ಏನ್ ವೀಕ್ ಟೈಮ್ ಅಂತ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ತೀರಾ? ಏನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 313 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಆಯ್ತು. Petitioner counsel seeks 1 week time to make the payment. ಹೌದಾ? The counsel appearing for respondent would submit that even the directions of this court dated 16/12/2016 is not complied with. In view of the submission of petitioner counsel is this matter on 5th of April, next Tuesday. Connected to same 5th April. 22.
Affair for the respondent number 4 in this matter.
Other side ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಡಿ. The counsel would submit that he has already served the copy of petition appearing for R1. The counsel appearing for R1 is present before the court. You are appearing for R1, and that he has received the copy. Again, PF can list ಆಗಿತ್ತಾ ಇದು? The office is new. ಹಾಕಿದ್ರೇನ್ರಿ R1? ಹಾಕಿಲ್ಲಲ್ಲ? ಯಾವ ಹಾಕದ್ ನೀವು? ಏನ್ ನಾಯಕ್? Srinivasa SN for R4.
Affair for the respondent number 4, my lord.
R1 ಗೆನಾ ನೀವು? ಆಯ್ತು ತಗೊಳ್ಳಿ. ದಿ ಕೌನ್ಸಿಲ್ ಏನು ಪ್ರವೀಣ್ ಪ್ರದೀಪ್ ನಾಯಕ್ 6 time to file ವಕಾಲತ್ for R1. ಇದೇನು ಆರ್ಪಿನ? Now we view of change of law. Change of law, whether court can again go back to the proceedings? No, counsel. That is not admitted. That is not the law. The change of law ಅಂತ ಹೇಳಿ ಬಿಡಿ 20 ವರ್ಷದಿಂದ ಎಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಡಿಗ್ರಿ ಎಲ್ಲ ಆಗಿರುತ್ತವೆಲ್ಲ ವಾಪಸ್ ಆರ್ಡರ್ whatever it may be this court you can move on the RP ಯಾವಾಗ ಹಾಕದ್ರಿ if mistake on apparent on record not on account of subsequent to the change of law. You see 47. Why I don't know why you people are coming to RP. You go to section 47 explanation. Is it any change of law? See, madam, it a ground dismiss why we have to keep this. You read explanation. Last week also we heard the similar circumstances in division bench also. That is immaterial last time. Any written file objections? Change of law is not a ground, counsel. Then you can go there. That's all. Now we cannot exercise the review jurisdiction. Review jurisdiction can, any material is not considered. If mistake is apparent on record, the court can invoke review scope or otherwise no. But explanation itself is very clear. Change of law is not a ground for review. Nodi. ಓದ್ಕೊಂಡು ಬನ್ನಿ ನೀವು ಆಯ್ತು ಡಿಸ್ಕಸ್ ಮಾಡೋಣ ಯಾವಾಗ ಇನ್ಫಾರ್ಮೇಶನ್ ಮುಗಿಸ್ಕೊಂಡು ಯಾವಾಗ ನೋಡಿ ಎಷ್ಟು ದಿವಸ ಬೇಕು 11th April. Arun Kumar BR.
My lord, this is Arun Kumar, my lord. Last time I had requested for the time. I had my eldest son had expired. So,
you are an advocate or
no, my lord, I am a petitioner, my lord.
Petitioner?
I'm a petitioner.
Why you want time now again?
Actually, yeah, just again I want a little time account.
Petitioner counsel seeks time. How much time you require?
2 weeks time, my lord.
Petitioner counsel appeared through petitioner appeared through VC and seeks time. And hence this matter on 8th April.
Thank you, my lord.
8th April. Lakshmikant. Password. Rahul S. Reddy. RP. Yes, madam. Why? Petitioner counsel seeks time. This matter on 8th April. Again RP. What is the ground for RP, madam? What is the ground? Anyhow, let your senior come. 8th April. Serial number 26. Prasad BS. Chinmay Prasad Ranjan Kumar.
For respondent, your lordship.
Respondent, yes.
Yes.
Yes, Prasad. Special case. Discharge application was rejected or allowed? What is the ground for allowing the discharge application? Appointment by commissioner only. What is the basis for government?
In this case, the commissioner is the appointing.
Only that is the only ground.
There is only ground is remaining ground is
Where is the finding of the trial court? Around 11. 11 or 13? 13. Learned counsel for the accused submit his written argument contending that the accused comes under Group A. And Karnataka Municipal Corporation Act applies to BBMP officials. The accused and the commissioner both come under Group A category. As per Rule 4.2 of the Karnataka Municipal Corporation Common Recruitment since 2010, although it is the state government who is the appointing authority for Group A officials, since the accused is not appointed by the state but being appointed by BBMP and has been promoted to the present post. BBMP has adopted the Karnataka Civil Services rules as per 8 of the Karnataka Civil Services rules 1986 and the authority to empower to impose penalty for Group A category is the government. Hence, the government alone is the competent authority to accord sanction of Group A officials and Exhibit T1 is not issued by the competent authority. Admittedly, the accused was joined as assistant registrar of BBMP and he was promoted as executive engineer and presently working in the capacity of executive engineer. Commissioner of BBMP, PW1 himself has admitted that the commissioner of BBMP and the accused comes under the Group A category. And the corporation adopted the KCS rules 1957. On reading of the conduct rules 1966 discloses that government is the competent authority in respect of A and B officers. The department are empowered to impose penalty on the government servants belonging to Group A and B officers. In such cases, government servants belonging to A and B may appeal to the government against the order of minority penalty imposed by the authority. Neither PW1 nor the prosecution has placed any material to prove that Commissioner BBMP was removal authority of Group A official in BBMP. Further, the prosecution has not placed any material to show that BBMP has empowered, appoint, and promote to the post of executive engineer to BBMP without approval of the government. The government
is appointed as promoted as a grade employee. This appointment is by the commissioner.
Appointment which grade?
Appointment is not a grade category.
Assistant engineer. What is his degree? B grade officer. B grade officer.
And the 69 rule is concerned, is only appointed with the appointed as a grade A officers. The promoted officers is not.
ಯಾವುದು ರೂಲ್?
Rule 4.2 of Karnataka Gazette dated 21/4/2011.
ಕೊಟ್ಟಿದ್ದೀರಾ? ಇಲ್ಲ ಹಾಕ್ತಿದ್ದೀರಾ? ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡಿ ಒಂದು. ನೆಕ್ಸ್ಟ್ ಅದರ್ ಗ್ರೌಂಡ್ ಅದು. ವಾಟ್ ಆರ್ ಅದರ್ ಗ್ರೌಂಡ್ಸ್? But they are not touched on merits. Only on technicality, discharge application was allowed, not on merits. ಯಾವ್ದಾದ್ರು 369 ಏನೋ ಹೇಳಿದ್ರಲ್ರಿ ಏನದು ಪೇಜ್ 369 ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್. Yes, counsel.
Milord, here my colleague Milord, he is producing your lordship the memo of authorities. Milord, containing Milord is Karnataka Civil Service Rules, Milord, conditions of service rules.
Oh, before that, have you applied have you adopted the KCR rules or not?
It's available 8 officers.
Adopt ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
We adopted that 8 officers. And only in this case, it is applicable who is appointed as an 8 officers. By promotion, it's
Right, promotion only given as executive engineer. That is your argument. Two line of argument is, one is that he was appointed by BBMP commissioner, that to the post of B grade officer, not A grade officer. He only on promotion he became the executive engineer. And then so in terms of the notification 4(2) of Karnataka Gazette notification, it is not applicable to the responding. Yes. Yes, counsel.
Milord, here. Milord,
before suggestions, with regard to the factual aspects, you first argue.
Milord,
Then we consider the citations.
if your lordship permits, Milord, it may
He
be.
was appointed as assistant engineer as B grade officer or not?
No, that fact is true, Milord. Appointment was as
Who appointed this man?
the commissioner of
Commissioner only.
BBMP, Milord.
No dispute.
Milord, thereafter, Milord, he was promoted as executive engineer by the government.
By the government?
Yes. And he is group A employee as on the date of according sanction. As on the date of offense, Milord.
As on the date of.
And pay scale, Milord, is also important. Pay scale, Milord, he was drawing, Milord, more than 36,000 to above 36,000 pay scale, Milord, is also the criteria for deciding who is the removing authority. For section 19, Milord, 19 of Prevention of Corruption Act, Milord, it is not the appointing authority, Milord, is relevant. It is the removing authority. The sanction from the removing authority. He could not have been removed by the commissioner himself. He is of equivalent rank. Executive engineer and commissioner of BBMP, Milord, they come under group A employee. The commissioner of BBMP cannot remove him.
Yes.
Milord, therefore, the government is the authority, Milord, to impose penalty as per rule 3, Milord, that we are producing it. You will kindly permit my colleague, Milord. Rule 3 of the Karnataka City Corporation Employees Conditions of Service Rules 1991. Milord, as per this, Milord, Schedule 2, Your Lordship. Schedule 2, Milord, Group A, the authority empowered to impose penalties which he may impose is government. For Group B employee, Milord, it is the commissioner. But, Milord, the respondent, Milord, was discharging duty as a Group A employee.
Yes.
The pay scale of above 36,000.
Yes.
36,300 to 53,850, Milord. That group. Under that group, Milord, he was coming. Yes. Therefore, government is the authority to impose penalty, and removal authority, Milord, is the government. You Lordship may kindly see, Milord, both page
have you supplied the copies to the other side? Yes.
Page, Milord, Schedule 2, you Lordship may kindly. Page 4, you Lordship. Milord, once he has been promoted, Milord, his cadre, Milord, is Group A. Admittedly, he was a Group A employee.
Page 4 of compilement file today, compilation?
Today, Your Lordship, today. Today.
Schedule 1.
Schedule 2, Your Lordship, Schedule 2. Page 2, Milord, Schedule 2,
government.
Schedule 2A also.
Appellate authority, government.
Government, Milord. And Milord, Schedule 2A, the pay scale, Your Lordship, Schedule 2A, even if the pay scale, my lord, Group A post, my lord, carrying pay scale of above rupees 10,620 to 14,960. My lord,
Yes.
this respondent, my lord, his pay scale was about 36,000.
Yes.
36,300 to 53,000. As per these rules, my lord, that it is the government which is the removing authority, not the commissioner.
Yes.
The payment authority is the government. And similarly, your lordship, another rule, my lord, it is at page 25, your lordship. Again, it is. He is of the cadre of Group A post, my lord, the government, my lord, that is page 25, your lordship.
25.
Yes.
Page
for all
26.
people- Yes. For
26.
all, yes, 26 also, my lord.
Serial number 4.
Serial number 4, my lord, it is again, the government is the removing authority. My lord, when the pay scale is of above 10,000 and add. And this is the law laid down by this honorable, this is the decision taken by this honorable court, my lord, at page 29, your lordship. My lord, in a similar circumstance, my lord, page 29, paragraph 4, your lordship. My lord, in this decision, my lord, it is under the Prevention of Corruption Act 1988, chapter 5, section 19, which requires that previous sanction is necessary for prosecution. The court shall not take cognizance an offense punishable under section so and so. The appellant is a Group A officer from whom the government is an appointing authority. And under subclass C of section 19(1), it put a rider, namely that the authority who has got power to remove the government servant only can approve for sanction. A Group A servant of the government and state government for whom the government is the appointing authority and removing authority and also discipline authority only has got power to issue such sanction. In the instant case, no such sanction has been obtained from the government of Karnataka. Hence, there is no valid sanction. My lord, this is based on the decision of 1999 Supreme Court, my lord. Here, most relevant, my lord, after he was initial appointment as an assistant engineer, another appointment has taken place. He was promoted and
That is by
government
promotion that has been approved by the
that is again another appointment by government. With the approval of government, my lord, he was promoted to the post. Thereby, his cadre was higher. And Group A higher cadre, it is the government which takes. Otherwise, my lord, equivalent rank, my lord, if the power of removal is given, they behave, my lord, arbitrarily. That is not the object of provisions. And similar decision, my lord, at page 47, my lord, this honorable court, my lord, has taken a view. Competent authority, my lord, as per section of the Karnataka rules, government of Karnataka is page 47, your lordship. And the relevant portion, your lordship, kindly, the same schedule 2 is relied, my lord, at page 55. Paragraph 8, my lord. Paragraph 8, my lord. It is apparent from a plain reading of the above that insofar as Group A employee of the corporation, this is directly, my lord, this office, this petitioner also was, my lord, an employee of a corporation, BBM. Corporation. My lord, municipal corporation rules, my lord, was applied, and for them, my lord, equivalent parameter CCR rules also applied. My lord, in such cases, my lord, the decision, my lord, of this honorable court, in respect of so far as Group A employees of the corporation are concerned, the authority competent to impose any punishment is the government. As regards Group B employees, such penalties can be imposed by the Commission of Corporation. The expression government has been defined by Rule 2.2 to be government in any housing and urban development department. It follows that the punishment imposed upon the petitioner in terms of Rule 8.5 of CCA rules could have been imposed upon the petitioner only by the government in the light of the provisions of aforementioned rules. For it is not in dispute that the petitioner is a Group A employee of the corporation. In the circumstances, the government need not have made a reference to the commissioner. Even if such a reference was made, the commissioner ought to have sent it back to the government for appropriate orders in the light of the provision of rules aforementioned. The order passed by the commissioner demoting the petitioner to the next lower post is therefore clearly beyond his jurisdiction, hence unsustainable. And next edition, my lord, is at page 57, your lordship. There also, my lord, this Karnataka city Corporation Employees Condition of Service Rules, my lord, what I have produced at page 4, my lord, is relied Schedule 2A as per the paragraph 3, your lordship. My lord, that Karnataka City Corporation Employees Condition of Service Rules Amendment Rules have come into force from 2005. And my lord, in respect of Bangalore City Corporation employees is concerned, the pay scale, my lord, 10,620 to 14,000 is a group A post admitted by them. Therefore, the removing authority is the government. And the order passed by the special court, my lord, that the sanction is not valid is exactly, my lord, as per the rules it is. The relevancy, my lord, that removing authority.
Even liberty is given to you also.
Yes,
it is ordered to return the charge sheet to the investigating officer to place before the competent authority and obtain and valid sanction order in accordance with law by placing entire prosecution papers, including schedule. It is ordered that investigators are liberty to submit the charge sheet after obtaining the valid sanction from the competent authority. Whether promotion is approved by the government or not. And also the judgments which have been relied upon by them covers this aspect also. Promotion is, according to him, promotion is approved by the government. Third in part, the counsel appearing for the petitioner wants to clarify whether promotion is approved by the government or not, while promoting him as A grade officer. Yavag? Monday. Is this matter on 4th April? On his notes, madam? 4th April.
Please.
You have let the defense evidence and also mark the documents also. Told him, madam. Heard the petitioner counsel on IA 1/2019 for suspension of sentence. The counsel would submit that the defense which was taken before the trial court is that
it was a partnership company.
It was a partnership company.
The liability was the partnership company.
And debt and liability.
All the complaint and notice was issued in the name of the partnership company, but complaint is filed in person of the partnership.
But whether he is also a partner?
He was a partner.
He was a partner.
Yes, he was a partner.
The defense which is taken before the trial court
is that the petitioner herein was the partner. And he was a partner. Partnership between whom?
Even the petitioners were partners. It was a partnership firm. Entered a partnership, entered an agreement with purchase of some hotel, which belonged to a partnership firm. The partnership firm who sold this particular hotel was actually a partnership transaction. But the check is being misused by a company who was the partner of that firm, and the notice which is being sent to the petitioners is a partnership firm notice. But complaint is filed individually. So this is the defense what I have taken before.
The defense which was taken before the trial court is that?
Trial court is that the transaction between the firm
Sonakshi Nati Halimale and the Varavinayak Ventures.
Sonakshi
Nati Halimale, complainants.
Nati Halimane, but complainant is there a Rajesh Sharma there.
Instead of Sonakshi Nati Halimale, Rajesh Sharma was the partner of Sonakshi Nati Halimale.
The defense which is taken before the trial court is that the transaction between
the partnership firm and Sonakshi. Yeah? Nati Halimane and the complainant is nowhere connected to the complainant.
Complainant was connected to Sonakshi Nati
Complainant was connected to Sonakshi Nati Halimane. But the complaint, the checks which have been given
to Sonakshi Nati Halimane.
to Sonakshi Nati Halimane was misused by the complainant, and there was no any transaction between the petitioner and the complainant. And to that effect, the petitioner also examined as DW1 and also got marked document exhibit D1 to D17. Both the courts have not committed, not considered the defense and committed an error in convicting, and the appellate court also committed an error in confirming the judgment of conviction. And hence it requires interference. In view of the submission and also the grounds which have been urged before this court, and taking into note of the rebuttal evidence has been laid before the trial court, matter requires to be considered in the revisional, in exercising the revisional jurisdiction, and hence the sentence is suspended subject to following conditions and backward. Payment 50% within 4 weeks. 50. ಅದೆಲ್ಲ ನೋಡೋಣ ಆಮೇಲೆ ನೋಡಿ. ಫಸ್ಟ್ concurrent pending ಇದೆ, you deposit 50% within 4 weeks, issue notice against respondent and suspended subject to executing a bond before the trial court for an amount of rupees 2 lakhs securities. ಎಷ್ಟಿದೆ ಅಮೌಂಟ್ ಎಷ್ಟಿದೆ? 2 ಲಕ್ಷ. 1 lakh with 1 security. 1 lakh with 1 security. Call for records. Records ಕಾಲ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಹೇಳ್ರಿ ಪ್ರಕಾಶ್ PS ಹೇಳಿ. ಏನ್ರಿ ಇದು ಮ್ಯಾಟರ್? 304A heard admit. ಕಾಲ್ ಬಂದಿ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಮೇಡಮ್? ಬಂದಿದೆ. ಪೋಸ್ಟಿಂಗ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್. ಹೇಳ್ರಿ ಅದ್ ಯಾರ ಟೈಮ್ ಕೇಳಿರಿ ಬೆಳಗ್ಗೆ ಯಾವ್ದಾರ ಸೈಡ್ ಇದಾರ? Out of station. Petitioner counsel. Are you a proxy counsel or proxy counsel? Proxy counsel Sri. What's your good name? Abhit? Tukaram Rao submits that the petitioner counsel had been to Ballari to attend cremation of his relative and seeks time. List this matter on short date only. I will give date. Is this matter ಯಾವ ಕೊಡ್ತೀರಾ ಮೇಡಮ್? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ 4th of April, next Monday. Respondent counsel also present in that. Next 31, serial number 31. Anil Babu Praveen Kumar. Have you filed wakalat? Have you filed wakalat? Today you are filing. File ಮಾಡಿದಿರೇನ್ರಿ? ಇವತ್ತು ಮಾಡ್ತೀರಾ? ತಗೊಳ್ಳಿ. What is your good name? Counsel Vijay Kumar submits that he is going to file wakalat on behalf of petitioner with NOC, with NOC, and hence if wakalat is filed, office is directed to put up the wakalat and list this matter on tomorrow. Okay? Yeah. The court has to pass an order to the 40%. Right. Appellate court is deposit immediately they were admitted the court when they are admitted. Right. Have you deposited the amount? Have you deposited the amount in terms of the order passed by this court? Have you complied the order of this court? No. Then why court has to take up your matter tomorrow? Ready to court any mansi bandak kodakalla. Time court has directed you to deposit the amount within 4 weeks or 6 weeks. Have you complied it? Time extend application ಹಾಕಿಲ್ಲ ನೋಡೋಣ. We'll see. ಏನಾಯ್ತು put up the application ಅದು ವಕಾಲತ್. List this matter on 8th April. 8th April. 32. Vinay S. R2 regarding office objection ಏನ್ ಮೇಡಮ್ ಅದು? And office note 2 regarding office objection ಅಂತೇನೋ ಇದೆ. Sorry, petitioner counsel is absent and also, ಹೌದಾ petitioner counsel is absent. ಮತ್ತೆ ಯಾಕೆ post date ಕೊಟ್ಟಿದೀವಾ? Post this matter after compliance of office objections. ಸುಮ್ನೆ ಯಾಕೆ ನಾವು ಡೇಟ್ ಕೊಟ್ಕೊಂಡು ಇದು ಮಾಡೋದು? 34. ಶಶಿವರ್ಧನ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಆಯ್ತು. petitioner counsel is absent. ಮೋಸ್ಟ್ಲಿ ಅದೇನು ಏನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನು ಮಾಡಿರಲ್ಲ, ಅದಕ್ಕೆ ನಮ್ಮ ಮುಂದೆ ಬರಲ್ಲ. ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಏನು ಮಾಡಿರಲ್ಲ, ನೋ ಡಿಫೆನ್ಸ್ ಅಟ್ ಆಲ್, ರಿವಿಷನ್ ಅಲ್ಲಿ ಬರಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಏನಿದು ಒಂದೇ ಸೆಕೆಂಡ್. ದಿಸ್ ಇಸ್ ದಿ ಮೋಡಸ್ ಅಪರೆಂಡಿ. ಹೇಳಿದ್ನಲ್ಲ, ಆರೋಪಿ ಪರ ವಿಚಾರಣೆ ಮಾಡಲ್ಪಟ್ಟ ಸಾಕ್ಷಿಗಳು ಇಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ ಮೇಡಮ್? 6 ಟೈಮ್ ಜಾಯಿಂಟ್ ಮೆಮೋನಾ ಏನ್ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡವ್ರ? ನೋಡೋಣ, ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಆಗತ್ತೆ ನೋಡಿ.
Milord.
36 Gopal Singh.
For the petitioner hearing.
Yes, counsel.
Is NI Act, Milord. In this case, the respondent has demised, Milord. The respondent is the complainant, Milord.
Respondent
is the complainant before the trial court. He is no more. He has died recently after filing of this revision.
Yeah, now you are telling that company. How company is no more?
No, complainant, Milord. Not company.
Complainant.
Yes.
Not company.
Not company.
He
is died.
Then you have to make necessary application.
Legal
bring the LRs of complainant.
We are not known to me, Milord.
What do you want now?
Now the suspension of sentence, Milord.
Suspension of sentence.
Yes, Milord.
According to your respondent is not alive.
Yes, Milord.
Is it not your duty to bring the LRs of the
we checked
complainant?
Out, but we are unable to find any legal heads of the respondent, Milord.
Then how this court can give a relief against the dead person?
No, but the warrant
that is the case. Whether this court can suspend the sentence?
Because the threat of warrant from the police is there, Milord.
Threat of warrant in according to you.
Yes,
you verify and take steps, that's all.
Yes, all.
Petitioner counsel seeks time to bring the LRs of complainant / respondent. And then list this matter on 8th April. Murli Babu, Madhukar Nadik. Yes. Last time ಏನಾಗಿದೆ ನೋಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. Petitioner absent, respondent present. ಹೇಳಿ counsel, ಹೇಳಿ. You remove your mask and make submission, counsel. Court is unable to hear your submission. Now, what is your defense? Why you have not let the rebuttal evidence before the trial court for having made the payment? If that is the case that you have made payment, why you have not let any defense evidence before the trial court? Who has to prove your defense? According to you, made some payment. Why you have not let the evidence? Mere taking of defense is enough? Is there any admission in the cross-examination that you have made the payment? Is there any effective cross-examination before the trial court? Cross ಮಾಡಿದಿರ ಇಲ್ಲ? ಹೋಗ್ಲಿ, cross ಮಾಡಿದಿರ ಇಲ್ಲ? ಮಾಡಿದಿರಿ. Any answer? Funds insufficient. Oral evidence of PW1. This court comes to conclusion. Complainant bank established the check bearing number so-and-so. Dishonored. Funds insufficient. Society and name submit that so-and-so encashment to execute the endorsement stick the check was dishonored. Within the unpaid. As such, for full, the 130 complaint bank has and so also issued legal notice. Close to complaint issued legal notice to the accused and so also. Postal receipt. Acknowledgement at exhibit P6. Notice was duly served and the same is undisputed. Under these circumstances, court comes to conclusion the company has issued the notice to the accused and served on him. Contemplated. Provisions of an act corrected. Thus, the complaint bank established that issuance of no demand notice were checked within 40 days. So, complaint society has established that accused has failed to make the payment of the loan amount even after receiving the information regarding dishonor of check. Forward the sum of rupees. For the due loan, you have admitted even for availing the loan also. And further, there is no dispute as such loan account still is continued. Moreover, the accused has not been issued a decline notice to the complainant society. And the accused has not chosen to defend the evidence. Thus, there is no rebuttal evidence. Under these circumstances, this court has drawn the presumption in favor of so-and-so. What is the wrong in the order? What is the wrong in the order? Then you would have applied for copy of the statement of account and placed before the court if you have made the payment. Got right to prosecute the case and so on so. Then you would have summoned the document by leading. If you have made the payment, you would have placed the document for having paid the amount. You ದುಡ್ಡು ಕಟ್ಟಿದಿರಿ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಇದೆ ರೀ? ದುಡ್ಡು ಕಟ್ಟಿದಾಗ ನಿಮ್ಗೆ ರಸೀದಿ ಇರಲ್ಲನ್ರಿ? Why you have not produced those documents before the trial court if you have made the payment? Then why you have not placed those documents before the trial court? Why you have not laid your evidence? Hello, I am application ಹಾಕಿಲ್ಲ. Contention ಆಯ್ತು ರೀ, ನೀವೇನ have you placed any document, additional documents ಹಾಕಿದ್ದೀರಾ appellate court ಅಲ್ಲಿ for having paid the amount? You have also contested the matter before the appellate court. ಹೌದಲ್ಲ, ನಿಮ್ದೇ appeal. So why you have not filed any application for to allow you to produce the additional documents? PW1 accused cross-examined PW1 in a specific case of the accused that he made repayment on several loan installments. He is not liable to pay so and so. That is your statement. Admitted fact that bounce check belongs to the bank account of the accused. Signature appeared exhibit P2 is also said. Only disputes from the accused or the complaint comes. However, accused failed to elicit such admissions in the cross-examination of PW1 to show that he is not liable to pay any amount as well so and so. No such admissions elicited. No such admissions. He is not liable to pay any debt or complaint amount. Shows that discharge debt. There is no such admissions in the cross-examination of PW1 was not issued to so and so. Accused not examined any witness on his behalf. He is not liable to pay any amount mentioned in check so and so. 3,37,000. ಏನು ಹಾಕಿಲ್ಲ ನೀವು. Even appellate court ಅಲ್ಲಿ your contention is that you have made some payment. No document is placed. Alva. The person who asserts, he has to prove. ಅವ್ರ ಹತ್ರ ಮೂರಿಲ್ಲಿ ಇದ್ರದ್ದು ಮಾತ್ರ ಹೇಳಿ. ನೀವೇನು ಕೌನ್ಸಿಲ್ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಷ್ಟ, ನೀವು ಪೇಮೆಂಟ್ ಮಾಡಿದೀನಿ ದುಡ್ಡು ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ? ಏನು ಇಲ್ಲ. ತಗೊಳ್ಳಿ ಮೇಡಮ್, ತಗೊಳ್ಳಿ. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ, ನೀವೇ ಹೇಳಿ. ಏನ್ ಮಾಡ್ಬೇಕು, ಏನ್ ರಿಲೀಫ್ ಕೊಡ್ಬೇಕು ನೀವೇ ಹೇಳಿ. ಯಾಕೆಂದ್ರೆ ಕೋರ್ಟ್ನ ರಿಲೀಫ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಸಿಟ್ ಜಾಸ್ತಿ ಲಾಯರ್ಗಳಿಗೆ. ಏನ್ ಮಾಡಿದಿರಿ ಹೇಳಿ. ಸರಿ, ಈಗ ಅಡ್ಮಿಷನ್ ಕೇಸ್ ಹೇಳಿ. ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾಯ್ತು, ಅಡ್ಮಿಷನ್ ರಿವಿಷನ್ ಜೂರಿಸ್ಟ್ರಿಕ್ಷನ್ ಅನ್ನು ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ there must be ರಿಬಟಲ್ ಎವಿಡೆನ್ಸ್. ನೋ ರಿಬಟಲ್ ಅಟ್ ಆಲ್. ರಿವಿಷನ್ ಸ್ಕೋಪ್ ಬರೋದು ಇಫ್ ಎನಿ ಪರ್ವರ್ಸಿಟಿ ಇದ್ದಾಗ ಮಾತ್ರ. ಅದರ್ವೈಸ್ ರಿವಿಷನ್ ಇಸ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್. ಇದೆಲ್ಲ ಮೊದಲೇ ಹೇಳ್ಬೇಕಿತ್ತು. ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಕೇಳಿ ಎಲ್ಲ ಹುಡುಕಾಡಿ ಎಲ್ಲ ಏನೇನಿದೆ ಅಂತ ನೋಡಿ ಆದ್ಮೇಲೆ ಈಗ ಸೆಟ್ಲ್ಮೆಂಟ್ ತಗೊಳ್ರಿ, ಆಮೇಲೆ ಮಾಡ್ಕೊಳ್ಳಿ ಸೆಟ್ಲ್ಮೆಂಟ್. ರಿವಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೂ ಮಾಡ್ಕೋಬಹುದು ಸೆಟ್ಲ್ಮೆಂಟ್. ಅಲ್ಲಿ ವಾರೆಂಟ್ ಬಂದ ತಕ್ಷಣ ಹೋಗಿ ದುಡ್ಡು ಕಟ್ಟಿ ಸೆಟ್ಲ್ ಮಾಡ್ಕೋಬಹುದು, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಕಾಂಪೌಂಡಿಂಗ್ ಆಫ್ I don't want to now, after hearing the arguments and expressing my opinion, I will not adjourn the matter. You would have mentioned it before that. I spent almost 20 minutes for you, both of you. Don't. Sorry, ನಾನು ಏನ್ ಮಾಡಕ್ಕಲ್ಲ. ಸಾರಿ ನಾನೇನ್ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ಲಿ? ಸಾರಿ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ಲಿ ರೀ? You have already, we have this court spent 20 minutes time regarding your defense also. I heard you enough. Don't. This petition is listed for admission today, and heard the petitioner counsel and also the counsel appearing for the respondent. The factual matters of the case of the respondent before the trial court that this petitioner has borrowed the loan of rupees 3 lakhs and issued the checks, and he did not repay the amount. And hence, when the checks were presented, check was presented and the same was returned with an endorsement, insufficient fund. And thereafter, legal notice was also issued and the same has been acknowledged. And when the demand is not complied, complaint was filed. The trial court took the cognizance, and thereafter, the complainant examined himself as PW1 and got marked document exhibit P126. On the other hand, the PW1 was cross-examined by the defense counsel and not get any defense evidence. The trial court, after considering material and record, convicted the petitioner for the offence section 138 of NA Act and directed to pay a fine of rupees 3,42,083, and also directed to undergo simple imprisonment for a period of 2 years. Being agreed by the judgment of conviction. Yen mistake? Amend agide. Amend ಆದ್ಮೇಲೆ 2 ವರ್ಷ ಅಂತ ಮಾಡಿದ್ದಾರೆ. What is mistake? ಎರಡು ನೀವು ಬರೀ ಚೆಕ್ ಬೌನ್ಸ್ ಮಾತ್ರ ಡಿಫಾಲ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಅಂತ ಏನಿಲ್ಲ, ಸಬ್ಸ್ಟ್ಯಾಂಟಿವ್ ಸೆಂಟೆನ್ಸ್ ಕೊಡ್ಬೋದು ಅಂತ ಇದೆ. ಏನ್ ಮಂಡೆ? ತೋಳಿ ಮೇಡಮ್ ಏನಾಯ್ತು? ಅಲ್ವಾ ಕೊಡಿ, ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ. ಸೊಸೈಟಿ ರೀ, ಅವ್ರು ಇನ್ನೇನ್ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಕ್ಕಲ್ಲ. ನೀವು ಚೆಕ್ ಅಮೌಂಟೇ ಕೊಡ್ಬೇಕು, ಫೈನ್ ಅಮೌಂಟ್ ಕೊಡ್ಬೇಕು. ಯಾವಾಗ ತಗೊಳ್ಳಿ ಹೇಳ್ರಿ. 31 ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಬಂದೇ ಇಲ್ಲ. 31 ಅಂತಾರೆ, ಆಗುತ್ತಾ? 31 ಗುರುವಾರ ರೀ, ಈ ಗುರುವಾರ. ಏನ್ ನಿಮಗೆ ಮಂಡೆಗೆ ಏನ್ ಎಷ್ಟು ಒಂದ್ 2-3 ದಿವಸ ಕೊಡೋದ್ರಲ್ಲಿ ಏನಿದೆ ರೀ ಮಂಡೆಗೆ? ಅದೇ ಫಸ್ಟ್ ವೀಕಿನ ಹೇಳ್ತಾರದು, 4th ರೀ. 6ರಿಂದ 8 ಅಲ್ಲ, 4ನೇ ತಾರೀಕು ನೆಕ್ಸ್ಟ್ ಮಂಡೆ. 12ಕ್ಕೆ. ನನಗೆ ಕೇಳಿದ್ ಮರ್ತೋಗ್ಬಿಡುತ್ತೆ ಮತ್ತೆ, ಅವ್ರ ಪೇಮೆಂಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ. ಈಗ ಆಲ್ರೆಡಿ 20 ನಿಮಿಷ ಕ್ಲಿಯರ್ ಮಾಡಿದೀನಲ್ಲ. ಮಂಡೆಗೆ ನಿಮ್ಗೆ ನೀವು 6ರಿಂದ ಇರಲ್ಲಲ್ವಾ? ಮಂಡೆಗೆ ಪೋಸ್ಟ್ ಮಾಡೋಣ. ತಗೊಳ್ಳಿ, ಏನಾಯ್ತು ಮೇಡಮ್? ಅದೆಲ್ಲ ಬಿಟ್ಬಿಡಿ, ಸುಮ್ಮನೆ ವೇಸ್ಟ್ ಆಫ್ ಟೈಮ್. ದಿ ಕೌನ್ಸಿಲ್, after hearing the arguments on merits regarding admission, submits that he is going to settle the matter and ಏನು ಚೆಕ್ ಕೊಡ್ತೀರಾ? ಏನ್ ಮಾಡ್ತೀರಿ? Going to make payment on Monday and hence list this matter on 4th of April. SP Ramesha Matthew. Password ಮಾಡಿ. Nataraj Ballal B Latif. ಹೇಳಿ. ಹೇಳಿ. ಹಿಂದಿನ ಡೇಟ್ ಆಫ್ ಏನಾಗಿದೆ ನೋಡಿ ಮೇಡಮ್. ಆಯ್ತು, ಏನಾಯ್ತು ಲಾಸ್ಟ್ ಟೈಮ್? Counsel for petitioner is learned counsel for the petitioner is absent. Office is directed to Wakalat is not filed. Since Wakalat is filed and the same is in order, is this matter on 28/3. ಆಯ್ತು, ಯಾವಾಗ ಸೆಟಲ್ ಮಾಡ್ತೀರಿ? Petitioner counsel seeks 10 days time to settle the matter and hence list this matter on 6th ಬೇಡ, 7th of 7th of April. Respondent counsel is also present in fact. Sudarshan L. TN
My lord,
Vishwanath.
I appear for petitioner, my lords.
Once
This is
again.
138 proceedings, my lords. The petitioner has been convicted under section 138 of NA Act. For 5,25,000 is the amount which has to be paid, my lords. And my lords, the lordship, I have deposited 50% of the amount. The only question, my lords, we are challenged is there's an alteration, material alteration on the check, my lords, because the signature, the contents also vary. That we have brought it on cross-examination, and also my lords, we have made a specific.
Have you disputed the signature?
Signature.
Or is it your contention that the signature is in one handwriting and the ratings are in different handwriting? That is the.
That is the only.
That's Supreme Court uttara kottibidare.
Correct.
Payer if it is given blank check, you are authorizing the payer to fill up all this.
Apart from that, my lords, so there is kindly see, my lords, that the capacity of the complainant to give the money, to lend the loan, my lords, kindly see, he relies on two documents, Exhibit P10 and P7. P10 and P8, ಅದು ಒಂದು ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಮಾಡಿದೆ ಅಂತಾರೆ. That is in the year 2010. However, my lords, the transaction has happened in the year 2015 and 16, my lords. 2017 ಅಲ್ಲಿ ಇದು ಮಾಡಿರೋದು. Apart from that, he also further realized that ನಾನು ಡ್ರಾ ಮಾಡಿದ್ದೆ ಅಮೌಂಟ್ ಫ್ರಮ್ ದ ಅಕೌಂಟ್ ಅಂತ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. But that shows only 1,30,000 which has been drawn. So now the claim is my lords filed. So that
ನಿಮ್ದಷ್ಟು transaction
ಇವ್ರು ಹೇಳೋದು 5 lakhs ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. 5 lakhs ಹೇಳ್ತಾರೆ. So 1 lakh. So that is going contradictions with the documents produced by the complainant, and also, my lords, that.
Then why you gave the check for rupees 5 lakhs?
My lords,
that is the case. Basavalingappa case hoytu. Source of
my lords,
income for having made the payment. Subsequent judgment of apex court.
This has been taken for the
Basavalingappa case only in respect of the source is concerned, whether he was having capacity to lend the money. In view of the subsequent judgments, that judgment also goes. Heli neevenu evidence madilla. You have to explain why you gave the check for rupees 5 lakhs.
That my lords, for the
what is your explanation? You have not made any defense evidence also.
Illa adralli defense evidence madilla, but when I have put a suggestion that this was there was a cheaty business, my lords, cheat business between
any admission regarding your cheat transaction is concerned.
No, my lords, he has denied that. However,
suggestions will not come to your rescue.
However, my lords, he says further, my lords, in the cross examination, my lords, I was able to bring that I have filled up the contents of the check in dispute as per the direction of the accused ಅಂತ ಹೇಳ್ತಾರೆ. Since she does not don't know to write in English, it may be true that accused has the knowledge of writing. It is false to say that I have misused the signed check of the accused that I have collected from her for security purpose in respect of.
I already made it clear that once you have admitted the signature, you have no defense at all unless you rebut it. You have not rebutted.
That is only contention, my lords.
Even for filling, allowing the petitioner, complainant to fill up the checks also is not a defense. Once the check is delivered. That's all?
That's all my submission.
Yes, madam. Trial court or appellate court? Trial court, yes. Paragraph. Where is the final finding? Paragraph number? Page. Except the bond defense of the accused that she had issued the checks in dispute, the complainant as a security for the financial assistance that she used to avail from the complainant in respect of her cheat business, there is no serious denial on her part regarding her alleged liability under the subject check in favor of the complainant. In such circumstances, a presumption drawn in favor of the complainant. No advanced sum of rupees so learned defense. In such circumstances, an examination of Hari Prasad by complainant cannot be considered to be an omission or lapse. Good. This matter is listed for admission and heard petitioner counsel and also the counsel appearing to the respondent. The factual matters of the case of the respondent before the trial court that the petitioner has approached this petitioner, respondent complainant, the second week of March 2015 and sought for financial help of rupees 5 lakhs for a period of 20 months. The petitioner also assured him that she would repay the said amount to him with interest at 1.5% per annum. Believing the words, amount of rupees 5 lakh was paid and accused as issued post-dated check as a security for the amount borrowed, but did not repay the amount with interest, and hence when the check was presented, the same was returned with an endorsement funds insufficient. Legal notice was issued and the same was served. Despite of the service of notice, neither replied nor complied with the demand. Hence complaint was filed. In the trial court took the cognizance and examined the complainant as PW1, got marked documents, Exhibit P128. The petitioner counsel has cross-examined the PW1 and not read any defense evidence. The trial court, after considering both oral and documentary evidence, convicted the petitioner for 138 and sentenced to pay a fine of rupees 5,25,000. In default of payment, shall undergo simple imprisonment for 1 year. Being agreed by the judgment of conviction, an appeal is filed in Criminal Appeal number 850 of 2019. And the appellate court, on reconsideration of both oral and documentary evidence, dismissed the appeal. Hence, the present revision petition is filed. The counsel appearing to the petitioner would vehemently contend that it is illustrated that the handwriting in the check and signature are in different handwriting. And apart from that, specific defense was taken before the trial court that the complainant was not having capacity to lend the money of rupees 5 lakhs. The counsel also submits that the transaction is, the check was issued in respect of the check transaction. And documents which has been relied upon by the complaint for having withdrawn the amount is only of rupees 1 lakh and odd, not to the tune of rupees 5 lakhs, which was allegedly lent in favor of the petitioner. And this aspect has not been considered by the trial court, and hence it requires interference of this court. And hence matter has to be admitted. For counter, the counsel appearing to the respondent complainant would submit that the signature on the check is not disputed. The only dispute before the trial court while cross-examining the PW1 that the check was given in connection with the check transaction. And in order to prove the said fact, not let any rebuttal evidence. The same has been considered by the trial court as well as the appellate court. The counsel brought to notice of this court the finding of the trial court in paragraph number 21 to 27. Therein also discussed with regard to the issuance of check as well as no defense evidence has been led. The counsel also brought to the notice of this court the reappreciation made by the appellate court with regard to the evidence available on record, particularly in paragraph number 4, considering the grounds urged in the appeal memo, and also reasoning given in paragraph number 9 to 16. And so also the paragraph number 18 with regard to the purport and object of NI Act, dismissed the appeal. And hence counsel would contend that there is no any merit to admit the revision petition. Having heard The petition of counsel and also the counsel appearing for the respondent and looking into the material available on record. The complainant, in order to substantiate the claim, examined the complainant as per the one, and also got marked document exhibit given to 8. Admittedly, legal notice was served on the petitioner in terms of exhibit C6 postal acknowledgement, and no reply was given. The defense which was taken before the trial court is with regard to check was issued in connection with cheat transaction. And in order to substantiate the same, in the cross-examination, nothing is illustrated that transaction of cheat transaction. And also the petitioner not led any rebuttal evidence before the trial court. Hence, it is clear that after that, a defense was taken even though no reply was given. Really, the check was given in connection with the check transaction. The petitioner would have given reply immediately after the service of notice. The same is not done. The other contention of the petitioner counsel that both check contains the signature handwritings are in different handwriting. And once the check is admitted and given an authority to the drawer of the in favor of authority in favor of the holder of the check to fill up the same. And the same cannot be a ground as held by the apex court. The other contention that he was not having capacity to lend the money, and counsel would vehemently contend that statement was produced and the same discloses only drawing up amount of ₹1 lakh and odd, and also relied upon the sale date for having paid the amount. ಅದು ಮೇಲ್ಗಡೆ ಹಾಕೋಬಿಡಿ ಮೇಡಮ್, ಬೀರ್ ಸಿಂಗ್ ಮೇಲ್ಗಡೆ ಹೇಳಿದ್ಮೇಲೆ ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ದಿ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಅಂದಲ್ಲ, ಅಲ್ಲಿ ಹಾಕೋಬಿಡಿ. ಹೆಡ್ ನೋಟ್ ಬಿ ನಲ್ಲಿ ಸಿಗುತ್ತೆ. Presumption that check duly signed and voluntarily made over to payee, was in dishonor of debt or liability, arises irrespective of whether check was post-dated or blank check for filling by payer or any other person, in absence of evidence of undue influence or coercion. And the same cannot be a ground. ಅಂತ ಹಾಕೋಣ ಅಷ್ಟೇ. ಆಯ್ತಾ? ನೆಕ್ಸ್ಟ್ ಲಾಸ್ಟ್ ಏನೋ ಸೆಂಟೆನ್ಸ್ ಅಂತ ಇದ್ಮೇಲೆ
other contention of the line of counsel that he was not having capacity to
lend the money, and only amount was gone to the tune of ₹1 lakh and that, and not the entire amount. And the same cannot be a ground. And the complainant had produced the document of sale deed of the year 28/1/2010 for having paid the amount, for having sold the property, and out of the sale consideration the loan amount was lent. When document exhibit P7 and 8, statement of account and certified copy of the sale deed is produced, the very contention cannot be accepted. Having perused the the finding of the trial court as well as the appellate court, and the appellate court, trial court also in number particularly 31 to 33 discussed with regard to the defense taken by the petitioner. And so also in paragraph number 35 with regard to the documents which have been relied upon by the complainant, and also drawn the presumption in favor of the complainant. The appellate court also on reappreciation of material available on record discussed in paragraph number 15-16 regarding trial court has relied upon the documents, particularly bank statement and also the sale deed. And apart from that, case was filed in the year 2017 itself, and no reply was given in spite of service of notice. And given the reasoning that trial court has applied its mind and relied upon both oral and documentary evidence, having considered the finding of trial court as well as the appellate court, and also taking into note of material available on record, it is not a fit case to admit the appeal and not find any error in appreciating both oral and documentary evidence. And in order to exercise the discretion while exercising the revisional jurisdiction, there must be a perversity in the finding, and such finding is not found, and hence no merit to admit the revision petition. In view of the discussions made up, I pass the following order. Revision petition is dismissed.
Please.
ನೀವು ತಗೋಬಹುದು ದುಡ್ಡು ಅಷ್ಟೇ. ಎಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿದಾರೆ ಇಲ್ಲೇ ಆಗಿದೆನಾ ಲೋಗ ಅರ್ಜಿ ಹಾಕೊಂಡು ತಗೊಳ್ಳಿ ಅಷ್ಟೇ. ಎಸ್ 42 ದಿಲೀಪ್ ಕುಮಾರ್. ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್. But 42 to 47 are arising out of common judgment. Right. ಇಲ್ಲಾವುದು ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇಲ್ವಲ್ಲ, ಇಲ್ಲಿ ಅಪೀಲ್ ಅಲ್ಲ, ಎಲ್ಲ ಇಂಡಿಪೆಂಡೆಂಟ್ ಬಿಟ್ವೀನ್ ಸೇಮ್ ಪಾರ್ಟೀಸ್, ಇಂಡಿಪೆಂಡೆಂಟ್. ಆಯ್ತು, ಇಂಡಿಪೆಂಡೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್. ಆಯ್ತು.
Now the commissioner was not there was arraigned as actually number 2. The court has convicted in all the cases. The facts of the case was now the idea is for the provisional sentence in all the cases. All 6 cases are in each case 2 lakhs check only.
2 lakhs.
2 lakhs check only. With regard to all these cases, 6 cases, the accused has made payment admittedly, as admitted with BW1, 9 lakhs. 9 lakhs.
9 lakhs is admitted.
Admitted.
Having repaid the amount.
Yes. Admitted with BW1. If 9 lakhs is the paid out of 5 lakhs, 6 cases, only will lose 3 lakhs. See, what did not take into consideration of the check amount? Wrongly convicted for the double check amount.
In all the cases, double the amount.
There is admission. That yes, with regard to these 6 cases.
Trial court judgment ಅಲ್ಲಿ ಏನಾದ್ರು admission ಬಗ್ಗೆ discussion ಆಗಿದೆಯಾ? ಏನಿದೆ ಅಂತ.
41.
First matter 1318. First matter 42. 41 ನಿಮ್ದಲ್ಲ 42. Increase 40. 39 40.
When the date of enacting the check amount, whether it's a or not, our forensic document evidence, these are paid to the see the effect of the advance money paid like complaint to purchase the apartment in the accused for the developer and promoter of residential apartment, but thereafter this agreement will be cancelled to do the purpose. Other thing, the accused has to return the entire amount of 30 lakh advance to the case of the complaint.
On the perusal of the material, the accused have paid only rupees 9 lakhs in these 6 cases, and remaining due is rupees 21 lakhs.
In these 6 cases, my lord, the check amount itself is 12 lakhs, not 21 lakhs.
ಅಂದ್ರೆ ನೀವು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಾಗ 30 ಲಕ್ಷ. The accused agreed to repay the entire amount of rupees 30 lakhs along with 3 lakhs as interest ಅಂತಿದೆ ನೋಡ್ರಿ.
That is the case of the prosecution.
ಆಯ್ತು.
That is the case of the prosecution. What is the case? In this case, out of 12 lakhs, the complaint has admitted that I have repaid 9 lakhs, but the remaining amount he has already given other cases still pending. That has been admitted by the even with the cross examination. If that is the case, if this check amount is more than the liability, these checks amount are more than the liability. The case itself is not material because the checks amount are more than the liability. So again, in para because in the para 15, with the close of transaction become the is not authorized and he has no knowledge of the transaction with the accused and complaint, but these are denied very good. In the course of transaction, there is no sanction about this transaction, but only purpose mentioned that there is no document for which to show the relax paid in the complaint which is admitted very critical one. Further mentioned that the complaint has not paid with 30 lakhs, but which is denied very critical one. The legal concept for the accused himself says that the accused have paid 2 lakhs to back on 29.16, what was and 29.15. This is admitted by PW1. If the complaint company did not pay advance amount of rupees 30 lakhs, why the accused has been funded 9 lakhs to the complaint? This is the assumption of the lower court. Assuming that he might have been paid 30 lakhs, that is why I am coming. And the court assume not presume and therefore complaint and pass a judgment. Therefore, it shows that the complaint will be 30 lakhs to the accused and then to decide the liability, the accused reported to 9 lakhs. Except if there is no mental relation and the accused will only come to the accused. Out of that, when the agreement was cancelled, the accused reported 9 lakhs. Out of each cases reported 4.
Out of the 30 lakhs, it was repaid 9 lakhs or
in these cases, especially the witness has admitted, the payment has been made to these cases. Pending before the court. For the 6 cases.
That is out of 30 lakhs you paid rupees. That is the finding. That who has to that I agree that why you have not let the evidence before the trial court if that is not
That with regard to these cases, these 6 cases I have made payment of 9 lakhs. Then cannot be regard to the other.
ಎಲ್ಲಾದ್ರೂ ಸೇಮ್ ಡಬಲ್ ದಿ ಅಮೌಂಟ್ ಆಗಿದೆಯಾ ನೋಡಿ ಮೇಡಮ್ ಸೇಮ್ 42 to 47 heard the petitioner counsel an IA 1/21 for all cases madam ella same IA 1 ene the counsel would submit that in the cross examination of PW1 it is admitted that an amount of rupees 9 lakh was paid and no document is placed before the court that the amount paid was rupees 30 lakhs. Out of that 30 lakhs an amount of rupees 9 lakh is paid and trial court has committed an error in directing the petitioner to pay the double the amount of the check and fails to take note of an amount of rupees 9 lakh was paid and while adjusting the said amount actually due was only rupees 3 lakhs according to 3 lakhs and not the 12 lakhs. Having heard the submission of the petitioner counsel and also the counsel grounds urged in the revision petition another ground.
There is a resolution. Resolution is being specifically given to record money in sitting length. To record the money in sitting length. The facts of the case is not for the money in sitting length. So that resolution itself was a defective. That is not being considered.
Then why you have collected this much of amount? You are a Samruddhi Realty Limited company. You have collected the amount to give site. Money lending or site?
Not site.
Agreement of purchase of property, plot number so and so. ಆಯ್ತು ಅದೆಲ್ಲ ನೋಡೋಣ ಆಮೇಲೆ ವಿಲ್ ಸಿ ಏನಾಯ್ತು ಮೇಡಮ್. And having considered the submission made by the petitioner counsel and also the grounds urged in the revision petition, matter requires to be considered. Since PW1 was cross-examined before the trial court, even though not led any rebuttal evidence. Hence, it is appropriate to suspend the sentence subject to the following conditions. ಯಾರು ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ಯಾರು ದುಡ್ಡಿದೆ ನಮ್ಮ ಹತ್ರ ಅಂತ ಹೇಳೋದಿಲ್ಲ. ಆಯ್ತು 50% within 4 weeks, not check amount, fine amount. Fine amount. ಏನಾಯ್ತು ಮೇಡಮ್? 50% of the fine amount unta. Sorry, check amount unta, not the fine amount. Aita check amount within 4 weeks. Aita next 4 weeks kottidini. 4 weeks kottidinri to deposit the amount. I have given 4 weeks. Aita execute a bond for rupees 1 lakh with 1 surety before the trial court. Issue notice against respondent, call for records. All but up to 47, 48 really.
48 was updated go. One petition was presented to that. And the petition was what child of
have you produced the order sheet? ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ? ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಆರ್ಡರ್ ಶೀಟ್? Produce order sheet, then I will consider. If no opportunity, I will set aside the order. If an opportunity, if you are not availed the opportunity, then you have no case. No, we'll see.
When the judgment was pronounced, on the same it was dismissed and the judgment was pronounced.
Judgment ಗೆ ಇದ್ದು ಹಾಕಿದಿರ ಅರ್ಜಿನ?
ಮತ್ತೆ 1 week message is claim.
ಆಯ್ತು, you produce order sheet, we'll see. You produce the order sheet. ಏನಾಗಿದೆ, ಅಡ್ವೊಕೇಟ್ಸ್ ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರ ಅದನ್ನ ಕೇಳ್ಕೊಂಡು ಆರ್ಡರ್ ಬರೆಯಂಗಿಲ್ಲ. ಬಿಕಾಸ್ ಐ ಆಮ್ ಆಲ್ಸೋ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ಡ್. ಅದಕ್ಕೋಸ್ಕರ ವೆನ್ ಐ ವಾಸ್ ಎ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್, ಎಕ್ಸಾಂಪಲ್ ಹೇಳ್ತೀನಿ ಹೆಂಗೆ ಅಂತ. ಯಾರ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬಂದ್ರು, ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು, ಇಲ್ಲ ಟ್ರಯಲ್ ಆಗಿಲ್ಲ, ಕಸ್ಟಡಿ ಇದಾನೆ 4 ವರ್ಷದಿಂದ ಅಂದ್ರು. ಆಕ್ಚುಲಿ ಚಾರ್ಜೇ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ ಅಂದ್ರು. ನಮ್ಮ ಹೈಕೋರ್ಟ್ ನವ್ರು ಏನ್ ಮಾಡ್ಬಿಟ್ರು, ಬೇಲ್ ಗ್ರಾಂಟೆಡ್. ಆ ಸಬ್ಮಿಷನ್ ಕೇಳ್ಕೊಂಡು ಬೇಲ್ ಗ್ರಾಂಟೆಡ್. The truth is not that. Charge was framed 3 years back, and when the matter was set on for trial, at the instance of the accused only, matter was urgent for 3 years on cost also. ನಾನಾಗಿದ್ರೆ ಈಗ ಹೇಳ್ತಾ ಇದ್ನಲ್ಲ, ನನಗೆ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇದೆ, ಅದಕ್ಕೆ ಕೇಳಿದೆ ಆರ್ಡರ್ ಶೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. ಆಮೇಲೆ ನಾನು ಅದಕ್ಕೆ ಬರ್ದೆ ಹೈಕೋರ್ಟಿಗೆ ರಿಪ್ಲೈ. ಏನಂತ ಬರ್ದೆ ಅಂದ್ರೆ, ಕೌನ್ಸಿಲ್ ಮೇಡ್ ಫಾಲ್ಸ್ ಸಬ್ಮಿಷನ್ ಅಂಡ್ ಒಬ್ಟೈನ್ಡ್ an order making false submission ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನನಗೆ ಕೇಳಿದ್ರು, ಎಷ್ಟು ವಿಟ್ನೆಸ್ ನಾವು ಕೆಲಸ ಮಾಡೋದು ನೋಡ್ತಾ ಇರ್ತೀರಿ ನೀವು, ಎಷ್ಟು ಬರ್ದಿದ್ದೇನಿಲ್ಲ ಹೈಕೋರ್ಟ್ನವರು, ತಿಂಗಳಿಗೆ ಎಷ್ಟು ಜನ ವಿಟ್ನೆಸ್ ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತಾರ ಜಡ್ಜು, ಅದ್ರ ನಾವೇನ ಕೆಲಸ ಮಾಡಲ್ಲ ನಂಗೆ ಊಹಿಸ್ಕೊಂಡು ಎಲ್ಲ ಕೇಳಿದ್ರು. ನಾನು ಎಲ್ಲ ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ಕಳ್ಸಿಕೊಟ್ಟೆ. ಎಷ್ಟು ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ವಿ, ಎಷ್ಟು ಡಿಸ್ಪೋಸಲ್ ಮಾಡಿದ್ವಿ, ಈ ಕೇಸಲ್ಲಿ ಏನಾಗಿದೆ, ಯಾರ್ ಇನ್ಸ್ಟೆನ್ಸ್ ಅಲ್ಲಿ ಅಡ್ಜರ್ನ್ ಆಗಿದೆ ಅಂತೆಲ್ಲ. ಗಟ್ಸಿದ್ದೀರ ಅವತ್ತೇ ರಿಕಾಲ್ ಮಾಡ್ಬೇಕಿತ್ತು ಆರ್ಡರ್ನ, ಬೇಲ್ ಆರ್ಡರ್ನ. ಮಾಡ್ಲಿಲ್ಲ. ರಿಪೋರ್ಟ್ ಕೇಳಿದ್ರು, ಇಂಥ ದಿವಸದೊಳಗೆ ಕೊಡ್ಬೇಕು ಅಂತ. ರಿಪೋರ್ಟ್ ಕೊಟ್ಟೆ, ಸರ್ಟಿಫೈಡ್ ಹಾಕಿ ಕಳ್ಸಿಕೊಟ್ಟಿದ್ದೆ. ನೋ ಸಚ್. ದಿಸ್ ಇಸ್ ಮೈ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್, ದಟ್ಸ್ ವೈ ಐ ಆಮ್ ಶೇರಿಂಗ್ ದಿಸ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್. ಈ ತರ ಆಗಬಾರ್ದು. ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸುಳ್ಳು ಹೇಳಿ ರಿಲೀಫ್ ತಗೋಬಾರ್ದು. ಕಾಸ್ಟ್ ಕೊಟ್ಟು ಎಲ್ಲ ಮಾಡಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡು ವಿಟ್ನೆಸ್ ನ ವಾಪಸ್ ಕಳ್ಸಿದ್ರು ಕೂಡ ಇಲ್ಲಿ ಬಂದು ಚಾರ್ಜೇ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ ಅಂತ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಮೇಡ್ ದಿ ಸಬ್ಮಿಷನ್ ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ blindly accepted by the court and granted bail in the court hall itself. ಅದೇ ಜಡ್ಜ್ ಗಡ್ಸಿದ್ರೆ ಆರ್ಡರ್ ತಗೊಂಡು ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ತಗೊಂಡು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ರಿಕಾಲ್ ಮಾಡ್ಬೇಕಿತ್ತು ಆರ್ಡರ್ನ, ಅಲ್ವಾ? ಮಿಸ್ರೆಪ್ರೆಸೆಂಟ್ ಫ್ರಾಡ್ ಆನ್ ದಿ ಕೋರ್ಟ್, ಮೇಕಿಂಗ್ ಫಾಲ್ಸ್ ಸಬ್ಮಿಷನ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. These are the things are going on. That's why I insist for order sheet. Order sheet ಅಲ್ಲಿ ಇಲ್ಲ, ನಿಮ್ಗೆ ಅವಕಾಶ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ I will definitely set aside the order and remand the matter. ಏನಾಯ್ತು? ಕೊಟ್ಬಿಡಿ, ಡೇಟ್ ಕೊಡಿ. 8th of April ಕೌನ್ಸಿಲ್ 2 ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ. ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ತರ್ಸ್ಕೊಂಡು ಹಾಕಿ ಕೊಟ್ಕೊಂಡು. Petitioner counsel is directed to produce the order sheet ಅಂತ ಹಾಕಿ 8th of April. ಎಸ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ ಕೌನ್ಸಿಲ್. Not considered. Merits only, without suspending the sentence. Yes. Now it is concurrent pending. What is your defense before the trial court? Have you disputed the check? Issued, sir, whether check contains your signature or not. What is the suggestion? That's why I'm asking you whether check is disputed, signature is disputed. Anta. Issuance of it is different from council. Issuance of check is different from the denial of signature. Have you denied the signature before the trial court? Idea not accused denied his signature in his cross examination, but in his examination in chief, he just denied handwriting but not the signature. This is the observation. Paragraph number 14 of the trial court order. Sahi? ಬರವಣಿಗೆ ಸಹಿ ನನ್ನದಲ್ಲ ಎರಡೂನು ಆಯ್ತು. ಚೆಕ್ ವಾಸ್ ಡಿಸಾನರ್ಡ್ ಆನ್ ದ ಗ್ರೌಂಡ್ ಆಫ್ ದಿ ಸಿಗ್ನೇಚರ್ ವೇರೀಸ್ ಅಂತನಾ ಅಥವಾ ಫಂಡ್ಸ್ ಇನ್ಸಫಿಷಿಯಂಟ್ ಅಂತ ಅಂದಾಗ when you denies your signature and you assert that signature not belongs to you, have you sent that document to the handwriting expert? Then what is the check amount?
And out of the check amount, the sales proceeds received, he has lent money. In the class examination, he says, out of the same proceeds, he has invested in purchasing some other property. That was some other property which he has purchased, she has not placed the document before the court. And she was dismissed from service. She was working in a private school. In the relevant period where the transaction. And she herself produces some documents.
What is your defense in the evidence? While cross-examining as well as the chief evidence. What is your defense?
Saying that I have not followed this act of the
Total denial. Sorry, madam. Heard the petitioner counsel on IA 1 of 22 for suspension of sentence. The counsel would submit that total denial of the transaction between the petitioner and the complainant. And the petitioner also led his defense evidence, examining himself as GW1. The counsel also would submit that when he has denied the signature on the check, the same is not sent for handwriting expert. When trial court committed an error in relying upon the check as well as exhibit P 10 and 11 regarding financial capacity, and the same is also disputed. Having heard the submission of the petitioner counsel and also the grounds urged in the petition, sentence is suspended subject to depositing of 50% of the amount within 4 weeks from today. And directed to execute a bond for rupees 2 lakh with 2 sureties before the trial court. Issue notice against respondent and call for records. 52 BS Nagaraj. Concurrent pending the what is your defense before the trial court? Security for what?
Not 3 lakhs. But I need my signature.
You need your signature. For what you have given security?
For debt collection, not for this transaction. For
Another transaction you are admitting with the complainant. What is that transaction? Business relationship ಏನ್ರಿ ಅದು? What is that? You have avoid the loan. ಅದನ್ನ ಹೇಳಿ, ಓಪನ್ ಆಗಿ ಹೇಳಿ. ಇನ್ನೊಂದು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ತಗೊಂಡಿದ್ದೆ, ಅವಾಗ ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೆ, ಮೊದಲಿನ ಲೋನ್ಗೆ ಕೊಟ್ಟಿದ್ದೆ ಚೆಕ್ ಅದು ವಾಪಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನಿಮ್ ಡಿಫೆನ್ಸ್. ಮತ್ತೆ ಆ ಚೆಕ್ ನ ಮಿಸ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ, ಅದೇನೆ ವಾಪಸ್ ಕೊಡದಲ್ಲೇ ಮಿಸ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ. Page number 50, defense of the accused. ಈಗ ನೋಡಿದ್ರೆ ಇಲ್ಲ ಅಂತೀರಿ. The accused admitted exhibit B. Rest of the averments denied by the accused and states that the accused has not borrowed any amount from the complainant. He has issued exhibit B1 check towards security of the debt. The accused has not signed the exhibit B1 check. He has not at all put the contents of the check. For the signature of the accused, ಆಯ್ತು ಚೆಕ್ ಫೋರ್ಜ್ ಆಯ್ತು ಅನ್ನೋ ಚೆಕ್ ಕಳಿಸಿದ್ರೆ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ ಗೆ, ಮತ್ತೆ ಫೋರ್ಜರಿ ಹೆಂಗ್ ಪ್ರೂವ್ ಮಾಡೋದು? You are sure that you have not signed the check. Why you have not sent the check for handwriting? Can you please say? ಏನಂತ ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ರು? You are not answering to my question. Check is not signed by you. Why you have not sent the check to the handwriting expert? You are alleging that there is a forgery. What is the mode for proving a forgery? Simply denying that ನನ್ನ signature ನಂದಲ್ಲ, handwriting ನಂದಲ್ಲ, that is enough. Say madam, the counsel appearing for the petitioner will submit the liability. The petitioner has disputed the very issuance of check and also delayed the signature, but not sent the same for handwriting expert in order to prove the forgery. A total denial of the transaction, but content that earlier there was a transaction and a check was given in connection with the earlier debt. The petitioner also examined before the trial court as PW1, but not produced any documents. Having heard the submission and also the grounds urged in the petition, matter requires consideration to exercise the revisional jurisdiction. And in view of the grounds also urged in the petition, sentence is suspended subject to the following conditions: 50% with one surety. Check amount estiide 3 lakh, 1 lakh with one surety before the trial court. 53 Prithviraj BN. Hmm. 50,000. When you defense, no? Check was last in the road. ಹೋಗ್ಲಿ ಕ್ರಾಸ್ ಮಾಡಿದಿರ ವಿಟ್ನೆಸ್ PW1 ನ? ಆಯ್ತು ಆಯ್ತು, ಬೇರೆ ಗಂಡಸರ ಜೊತೆ ಮಾಡ್ಲಿಲ್ಲ, ಈ ಗಂಡಸರ ಜೊತೆ ಮಾತ್ರ ಮಾಡಿದೆ ಅಂತ, ಹೌದಾ? ನಾನು ಆರೋಪಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ 5 ಬಾರಿ ನೋಡಿರ್ತೇನೆ. ಆಲ್ಸೋ ಅಡ್ಮಿಟ್ ದಟ್ ನಮ್ಮ ಮನೆ ಹಣಕಾಸು ವ್ಯವಹಾರ ನನ್ನ ಗಂಡ ಮಾಡುತ್ತಾರೆ, ಬೇರೆ ಬೇಕಾದ ಜೊತೆ ವ್ಯವಹಾರ ಮಾಡಬೇಕಾದ್ರೆ ಮನೆ ಗಂಡತಿ ಮಾಡುತ್ತಾರೆ ಅಂದರೆ ಸರಿ ಅಷ್ಟೇ. Same madam. What the petitioner counsel and counsel submission is that check was lost in the road. ಹೌದಾ? in the road, and the same has been misused by this petitioner, and there was no any transaction between the petitioner and the respondent. In view of the submission and also the grounds urged in the petition, suspended subject to deposit of 50%. One surety with 50,000 with one surety. 54 Srinivasayan. Ilva kodi file kodi ನೋಡೋಣ. Srinivas ಹೇಳ್ರಿ. Concurrent finding ಏನ್ ನಿಮ್ ಡಿಫೆನ್ಸ್ ಏನು? ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಏನು ಮಾಡೇ ಇಲ್ಲ? ಯಾವಾಗ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಟೇಕನ್ ಆಸ್ ನಿಲ್ ಅಂತ ಆಗಿರೋದು? ಯಾವ ಪೀರಿಯಡ್ ಅಲ್ಲಿ, ಯಾವ ಡೇಟ್ ಅಲ್ಲಿ? ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿದೀರಾ? ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿದೀರಾ? 29 ನೋಡ್ರಿ, ರಿವಿಷನ್ ಸ್ಕೋಪ್ ಬರೋದು ಯಾವಾಗ ಅಂದ್ರೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದ್ದು, ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಅಡ್ಯೂಸ್ ಮಾಡಿದ್ದು, ರಿಬಟಲ್ ಎವಿಡೆನ್ಸ್ ನ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮತ್ತೆ ಹೈಕೋರ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಮಾತ್ರ ಬರ್ತದೆ ರಿವಿಷನ್. ಯು ಆರ್ ಅವೇರ್ ಆಫ್ ದಿ ಸ್ಕೋಪ್ ಆಫ್ ರಿವಿಷನ್. ಲಿಗಾಲಿಟಿ ಇಟ್ಸ್ ಕರೆಕ್ಟ್ನೆಸ್ ಅಂಡ್ ಆಲ್ಸೋ ದಿ ಪ್ರೊಪ್ರೈಟಿ ಆಫ್ ದಿ ಆರ್ಡರ್. ಪ್ರೊಪ್ರೈಟಿ ಆಫ್ ದಿ ಆರ್ಡರ್ ಬಗ್ಗೆ ಇಲ್ಲ, ಲಿಗಾಲಿಟಿ ಅಂಡ್ ಕರೆಕ್ಟ್ನೆಸ್. ಚೆಕ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ದಾರೆ, there is a presumption and 118 and 139. ಕ್ವಶನ್ ಆಫ್ ಲಾನು ಹೋಯ್ತು ಲಿಗಾಲಿಟಿ ಮೇಲೆ. ಕರೆಕ್ಟ್ನೆಸ್ ಯಾವಾಗ ಬರುತ್ತೆ? ನೀವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದ್ದು ಮಾಡಿಲ್ಲ, ಮತ್ ನಾನು ಏನ್ ರಿವಿಷನ್ ಮಾಡಬೇಕು? 311 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ, ಯಾವಾಗ ಹಾಕಿದ್ರಿ? ಅದು ಯಾವಾಗ ರಿಜೆಕ್ಟ್ ಆಗಿದ್ದು ಯಾವಾಗ ಹೇಳಿ? ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು ಯಾವಾಗ? ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್? ಈಗ ನಿಮ್ ಗ್ರೌಂಡ್ ಅಲ್ಲ, ಗ್ರೌಂಡ್ ಬಿಟ್ಬಿಡಿ. ಫಸ್ಟ್ ಆರ್ಡರ್ ನಲ್ಲಿ ಏನಾದ್ರು ತಗೊಂಬರಿ. ಏನಾದ್ರು ಇದೆಯಾ? ಮಾಡೇ ಇಲ್ಲ, ಮತ್ತೇನ್ರಿ ಮಾಡ್ಬೇಕು? ಓಕೆ, ನೋಡಿ ಅಪರ್ಚುನಿಟಿ ನೀವು ಬಂದಾಗೆಲ್ಲ ಕೊಡಕ್ಕಲ್ಲ. ನೋಡಿ ಮೇಡಮ್, ಅದಕ್ಕೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ನೋಡೋಣ. ವಿಲ್ ಸಿ. ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿ ನೋಡೋಣ. ಗ್ರೌಂಡ್ ಇದ್ರೆ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್. Petitioner counsel is directed to produce the copy of the order sheet. This matter on 8th April. ಅಷ್ಟೊಳಗೆ ತರ್ಸ್ಕೊಳ್ಳಿ. 11th ಆಯ್ತು. 11th. ಸಿದ್ದರಾಮಯ್ಯ ಹೇಳ್ರಿ. ಕನ್ಕರೆಂಟ್ ಪೆಂಡಿಂಗ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರಿ? ನಿಮ್ ಡಿಫೆನ್ಸ್ ಏನು? You have not produced any evidence. You have led the evidence. But ಏನೋ ನಿಲ್ಲ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ನಿಮ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿದೆಯಾ? ಸಿ the accused examined himself as DW1 and no documents are marked. Now, what is your defense? What is your defense on that? ಬಾಕಿ ಇದ್ದಿದ್ದು 30,000 ಅಂತ. ನೋಡಿ ಮೇಡಮ್, third Anaya 2 of 22 for suspension of sentence and bail. The counsel would submit that there was a transaction between the son of the complainant and this petitioner to the tune of rupees 1 lakh. Out of that, an amount of rupees 70,000 was paid and remaining balance payable was rupees 30,000. There was no any transaction between the complainant and this petitioner, and the check which was given earlier in favor of the complainant son was misused. And in order to prove the said fact, also examined the witness, examined the accused as a DW1, and the same has not been considered by both the trial court as well as the appellate court. In view of the submission as well as the grounds urged in the petition, matter requires the consideration, and hence sentence is suspended subject to depositing 50% of the amount within 4 weeks. Excluding and deducting the amount which was deposited before the appellate court. Madella, 50%. Mad 50% mad. No. Idu concurrent finding revision jurisdiction. Revision normally 90% ಯಾವುದು ಅಲೋ ಆಗಲ್ಲ ಆಯ್ತಾ ಏನು 10% ಏನಾರು ಆದ್ರೆ ಅಲೋ ಆಗ್ತದೆ ಆಯ್ತು ನೋಡೋಣ ಕಂಟಿನ್ಯೂ ಎಲ್ಲದಕ್ಕೂ ಒಂದೇ ಯಾರ್ಡ್ ಸ್ಟಿಕ್ ಸಿದ್ದರಾಮಯ್ಯ ಬಂದ್ರು 50% ಯಾರು ಬಂದ್ರು 50% ನೋ ಯಾರ್ಡ್ ಸ್ಟಿಕ್ ಆಯ್ತು ಕೇಸ್ ನೋಡೇ ಮಾಡೋದು ನಾನು ನಿಮ್ಮನ್ನ ನೋಡಿ ಯಾವತ್ತೂ ಆರ್ಡರ್ ಬರೆಯೋದೇ ಇಲ್ಲ ಆಯ್ತು ಅಷ್ಟೇ 50% ಎಲ್ಲರಿಗೂ ಅಷ್ಟೇ ಬಾಂಡ್ ಅಮೌಂಟ್ ಎಷ್ಟಿದೆ ಬಾಂಡ್ ಅಲ್ಲ ಅಲ್ಲಿ ಅಮೌಂಟ್ ಅಲ್ಲಿ ನಿಮ್ ಚೆಕ್ ಅಮೌಂಟ್ ಫೈನ್ ಅಮೌಂಟ್ ಎಷ್ಟು ಆಯ್ತು 1 lakh ವಿತ್ ಕನ್ಸಿಡರೇಷನ್ MRC ಮನೋಹರ್ What is your defense before the trial court? ಏನಿದೆ ಮ್ಯಾಟರ್ 227 ಏನಾಗಿದೆ ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಚಾರ್ಜ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತಾ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು ವೇರ್ ಇಸ್ ದಿ ರೀಸನಿಂಗ್ ಏನದ ಅಲಿಗೇಷನ್ ಏನು ಅಫೆನ್ಸ್ ಏನು 376 ರೀಸನಿಂಗ್ ಹೋಗ್ರಿ ಫಸ್ಟ್ ಏನು ರೀಸನಿಂಗ್ ಆರ್ಡರ್ ನಲ್ಲಿ ರೀಸನಿಂಗ್ ಕೊಡ 41 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ 38 reasoning at 40-41. Prosecutors in her detailed complaint and strictly stated the main ingredients of the alleged offences. There cannot be any delay as stated in the application. The prosecution has produced important piece of documentary evidence by way of photographs with prosecutrix and the accused showing in the intimate position, and there are videos and other documentary materials etc. which are to be considered only during the course of trial. All these documents are prima facie sufficient to frame charge without giving an opportunity for the prosecutors to lead her evidence and reduce all documents and witnesses that cannot be discharged at this stage. But all accused is discharged by merely considering his grounds in the application, it amounts to great injustice and amounts to denial of opportunity for the prosecutors to prove the charges. Absolutely, there is no ground. Photos of the cannot delay it. But in the entire statute, whether the make up a case 450, 496. I'm relying upon two documents. But page 55 and 56, the email for the email is a whole story. Started into our complaint and other than that. It is mentioned about her love affair. Engaged and in fact that accused was married and having a daughter of 9 years, and she knew very well about the entire circumstances. So the complainant and statement are contradictory. In ground and discharge ge. In ground and discharge again. Basically, complaint is that the complaint very now with the accused. And afterwards they wanted to listen to the line. And then the engagement ceremony was held in the house of the couple. That photographs have been taken, etc.
distancing her. Then on suspicion, she said that why you are distancing me, you are okay to marry me and all. Afterwards, she disclosed that I have already married and I have an 8 years daughter. Then he started to, because my daughter is not agreeing, willing to marry you because she insisted to stay with my husband, etc. And then she said that we have not disclosed all those things. But the email discloses that already she has disclosed that I moved you to the family court for divorce. It is suspect. The email dated 26 October 2013. I have produced that page 55. That discloses that what happened to your matrimonial divorce case exercise. So this, your worship can leave the income that I have not received that. I have explained that what is my position. I already married and I have a daughter of 9 years, and my relationship with the husband is not cordial. That's why I wanted to marry you.
Whether I have disclosed that prior to that, that is it not a disputed fact?
No, that she herself has said in the email that he has said that matrimonial case levels worship 5 at least 55.
What it says?
Not very serious. Case
55.
Dated 25th October 2013. I'm not getting sick, still alive, I'm missing you very badly. Today you ask me, do you have any doubt about your divorce agreement? Right. But honestly, I do not have any. It means the project on 26/10/2013 itself, she knows that complaint is 2014, 13/1/2014. That apart, if you project turn to page 56, 57.
No, this document itself shows that there was a promise that the divorce petition was pending.
Then suppressing. I am not suppressing. She said that suppressing that I have already married. And having a daughter of 10 years, he fell in love with me and he promised to marry me.
That's what you said, that divorce petition is pending, that will be considered as a promise. That is the promise. All are disputed facts. It requires time only. And she categorically says in the complaint that you subjected her for sexual act, promising that you would marry her. Whether the court can discharge the accused.
Nowhere in the complaint, she has said the date, month, and year. Nothing is spoken before the complaint.
You see, even FIR, you see, FIR also specific. ನೋಡ್ರಿ, ಇಲ್ಲೇ ಇದೆ. ವಾಸ್ತವವಾಗಿದ್ದು 2012ರಿಂದ ಬೆಂಗಳೂರು ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಸಿಟಿಯಲ್ಲಿರುವ ಇನ್ಫೋಸಿಸ್ ನಲ್ಲಿ ಸಾಫ್ಟ್ವೇರ್ ಇಂಜಿನಿಯರ್ ಆಗಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದು. ಈ ಸಮಯದಲ್ಲಿ ಫಿರ್ಯಾದಿದಾರರು ದಿನಾಂಕ 2/6/2013 ಬೆಂಗಳೂರಿನ ಲಲಿತಾ ಅಶೋಕ್ ಹೋಟೆಲ್ ನಲ್ಲಿ ಬರ್ಡೇ ಪಾರ್ಟಿಯಲ್ಲಿ ಶಿವೇಂದ್ರ ಕುಮಾರ್ ಎಂಬುವರನ್ನು ಪರಿಚಯ ಮಾಡಿಕೊಂಡಿದ್ದು. ಸದರಿ ಶಿವೇಂದ್ರ ಕುಮಾರ್ ಅವರು ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಸಿಟಿಯ ವಿಪ್ರೋದಲ್ಲಿ ಸಾಫ್ಟ್ವೇರ್ ಇಂಜಿನಿಯರ್ ಆಗಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದು. ಸದರಿ ಇಬ್ಬರ ಸ್ನೇಹ ಪ್ರೀತಿಗೆ ತಿರುಗಿದ್ದು. ಇಬ್ಬರು ಪರಸ್ಪರ ಪ್ರೀತಿಸಿದ್ದು. ಹೀಗಿರುವಾಗ ಸದರಿ ಇಬ್ಬರ ಮನೆಯಲ್ಲಿ ಇವರ ಪ್ರೀತಿಗೆ ಒಪ್ಪಿ ಫಿರ್ಯಾದಿದಾರ ಹಿರಿಯರ ಸಮ್ಮುಖದಲ್ಲಿ ಒರಿಸ್ಸಾದ ಭುವನೇಶ್ವರ್ನಲ್ಲಿರುವ ಮೇರ್ ಹೋಟೆಲ್ ನಲ್ಲಿ ಎಂಗೇಜ್ಮೆಂಟ್ ಸಹ ಆಗಿದ್ದು. ಅನಂತರ ಫಿರ್ಯಾದಿದಾರರು ಬೆಂಗಳೂರಿನ HSR ಲೇಔಟ್ ನಲ್ಲಿರುವ ಶಿವೇಂದ್ರ ಕುಮಾರ್ ಅವರ ವಾಸಮನೆಗೆ ಬಂದು ಹೋಗುತ್ತಿದ್ದು. ಈ ಸಮಯದಲ್ಲಿ ಮಾರ್ಚ್ 2014ರಲ್ಲಿ ಫಿರ್ಯಾದಿದಾರರು ಗೋಪಿ ಮನೆಯಲ್ಲಿ ಗೋಪಿನ ಅದೇನೋ ಗೊತ್ತಿಲ್ಲ ಇರುವಾಗ ಯಾರು ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ ಆರೋಪಿಯ ಫಿರ್ಯಾದಿದಾರ ಇಷ್ಟಕ್ಕೆ ವಿರುದ್ಧವಾಗಿ ಆಕೆಯ ಮೇಲೆ ಹಠಾತ್ ಸಂಭೋಗ ಮಾಡಿದ್ದು. ಇದೇ ರೀತಿ ಹಲವಾರು ಬಾರಿ ಫಿರ್ಯಾದಿದಾರರು ಮದುವೆಯಾಗುವುದಾಗಿ ನಂಬಿಸಿ ಬೇರೆ ಬೇರೆ ತಿರುಗಳಲ್ಲಿ ಫಿರ್ಯಾದಿದಾರರ ಮೇಲೆ ಹಠಾತ್ ಮಾಡಿದ್ದು. ಅನಂತರ ಆರೋಪಿಯು ಫಿರ್ಯಾದಿದಾರರನ್ನು ಮದುವೆಯಾಗುವುದಿಲ್ಲವೆಂದು ನಿರಾಕರಿಸಿದ್ದು. ಅದರ ಸದರಿ ಶಿವೇಂದ್ರ ಕುಮಾರ್ ಈಗಲೂ ಸಂಧ್ಯಾರಾಣಿ ಎಂಬುದು ಮದುವೆಯಾಗಿದ್ದು. ಅಲ್ಲದೆ ಅವರಿಗೆ ಈಗಾಗಲೇ ವಿಚಾರ ಫಿರ್ಯಾದಿದಾರರಿಗೆ ತಿಳಿದು ಆರೋಪಿಯನ್ನು ಕೇಳಲು ಹೋದಾಗ ಆರೋಪಿಯ ಫಿರ್ಯಾದಿ ಜೊತೆ ತೆಗೆದುಕೊಂಡಿರುವ ಫೋಟೋಗಳನ್ನು ಇಂಟರ್ನೆಟ್ ನಲ್ಲಿ ಹಾಕುವುದಾಗಿ ಜೊತೆಗೆ ಬೆದರಿಕೆ ಹಾಕಿದ್ದು. ಆಕೆಯು ಸತ್ಯನಾರಾಯಣರವರಿಗೆ ಮಗನ ಮದುವೆಯ ವಿಚಾರವನ್ನು ಮರೆಮಾಚಿ ಫಿರ್ಯಾದಿದಾರರಿಗೆ ಮೋಸ ಮಾಡಿರುತ್ತದೆ ಎಂದು ದೂರು ಇತ್ಯಾದಿ. This is the sum and substance of the complaint allegation. Yes, counsel. Matter of trial. Matter of trial. Heinous offense of 376. Email all will only can confront at the time of cross examination. You can confront those documents at the time of trial. Right. Good. Yen madam, what do you say? Hmm. 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 It's a matter of trial anta. Hmm. Hmm. Yes. Hmm.
State.
Hmm.
2020, mere future promise does not amount to in the false promise then it amounts.
That is on merits. That is on merits on that.
Not after trial.
ಕೊಡಿ ಎಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಕೊಡಿ ನೋಡೋಣ ವಿಲ್ಸಿ ಯಾವ್ದು ಹೇಳಿ ನಾವೇ ತಗ್ಸ್ಕೊತೀವಿ ಹೇಳಿ ಏನ್ ನೋಡೋಣ ಡಿಸ್ಚಾರ್ಜ್ ಮೇಲೆ ಏನಾದ್ರು ಆರ್ಡರ್ ಮಾಡಿದಾರಾ ಅದೇ ಕೇಳಿದ್ದು ಅದನ್ನೇ ಕೇಳಿ ಅದು ಮೂರು ಕೊಡಿ ಮಧ್ಯಾಹ್ನ 2:30 ಹಿಯರ್ ಮಾಡಿದ್ದೀನಿ 20 ನಿಮಿಷ ನೋಟ್ ಡೋಂಟ್ ವೇಸ್ಟ್ ದಿ ಟೈಮ್. ನೀವು ಇಲ್ಲ ಅಂದ್ರೆ ನಾವೇ ತರ್ಸ್ಕೊತೀವಿ. ಕೊಡಿ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಯಾವ್ದು ಕೊಡಿ, ಆ ಸೈಟೇಷನ್ಸ್ ಕೊಡಿ, ನಾವೇ ತರ್ಸ್ಕೊತೀವಿ. ಹೇಳಿ ಕೊಡಿ ಅವ್ರಿಗೆ, ತರ್ಸ್ಕೊಳ್ಳಿ ಅವ್ರ ಕೇಳಿ ಕೊಡಿ ಮೇಡಮ್ ಕೇಳಿ. 2:30 ನೆಕ್ಸ್ಟ್ ರಾಜಶೇಖರ್. Amount is disputed or check is disputed? Amount is disputed. Filled by the complainant. That is not a ground. That is covered by judgment of the apex court. For what? Details need not send to the FSL. Handwriting expert need not send. Once you have given the blank check, that is an authorization to the complainant. That's what Supreme Court says in this case. Head. Next. Adu bit bere enaru idea? Evidence madidira? PW1 exhibit D1 bank passbook. ಏನದು ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್? ಆತರ ನೋಡಿ ಮೇಡಮ್. the petitioner counsel and also the petitioner counsel and IA ಏನಾರಿದೆಯಾ? IA 1/22 for suspension of sentence and bail. The counsel would submit that though admits the signature and amount mentioned in the check exhibit B1 is disputed, and also counsel would submit that the other checks pertaining to the petitioner was honored long back, and subject matter of the check which was presented subsequently, and to that effect exhibit D1 is also produced before the trial court and examined. The petitioner as DW1. The petitioner has led his rebuttal evidence, and the same has not been considered by the trial court as well as the appellate court. In view of the submission of the petitioner counsel and also the grounds urged in the petition, matter requires consideration, and hence sentence is suspended subject to executing a bond for subject to payment of 50% of the amount. Issue the check amount to 5 lakhs with surety, with 2 lakhs with 1 surety before the trial court. Next further hearing. CN Raju. ಏನ ಮೊನ್ನೆ ಇತ್ತಲ್ಲ ಅದೇನಾ ಬಸವರು? ಅದೇನಾ ಪ್ಯಾರಾಲಿಸಿಸ್ ಆ ಕೇಸ? ಪ್ಯಾರಾಲಿಸಿಸ್ ಕೇಸ ಇದು ಮತ್ತೆ 392 ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಯಾಕೆ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ? ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೋಡೋಣ ಬರ್ತಾರೆ. ಯಾವ್ದು ಮೇಡಮ್? ಸೀರಿಯಲ್ ನಂಬರ್ 59. ಅದು ಯಾರು ಇಲ್ವಾ ಪಾಸ್ ಓವರ್? S.G. Bhagwan and Balakrishnan.
My lord. Serial.
Yes, madam.
They have to argue, my lord.
They are ready to argue. Are you ready?
My lord, after hearing their arguments, I may be permitted to take notes and address arguments on the next date.
No partner business. Don't make this court as a trial court. Argue. Yes. Ready.
My lord, then a date short account.
Last time ಏನಾಗಿದೆ ನೋಡಿ ಮೇಡಮ್ ಆರ್ಡರ್ ಶೀಟ್ ತಗೊಳ್ಳಿ.
I was present, my lord.
You are present. ಅವ್ರು ನೀವೇ ಇರ್ಲಿಲ್ವಾ ಲಾಸ್ಟ್ ಟೈಮ್? ಆಯ್ತು. ಆಯ್ತು. And now whether revision is maintainable when divergent finding is there. According to you, in the trial court, the accused was acquitted. In the appellate court, it is reversed. That is secondary on merits. So whether revision is maintainable. Divergent finding. Divergent finding iddaga. Revision maintains or appeal maintains. Concurrent iddaga revision lies. Divergent finding iddaga. Adide nanda judgment ondide nodi August 2020 annadu. Any other side also seeking time. Kodi judgment kodi. I have referred division bench judgment and passed an order. Division not maintainable and appeal maintains anta madide. Yavaga petitioner counsel is directed to examine regarding maintainability of the revision petition. Respondent counsel also seeks time. This matter on 8th April. So cause notice served on petitioner S.A. Sachidara. Nagaraj Reddy idara. Other side are idara S.K. Acharya. Right. Counsel ad ಬರ್ಕೊಂಡ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ಜಾಗ ಬಿಟ್ಬಿಡಿ ಅಲ್ಲಿಂದ. By force. ಆಯ್ತು ಬಲವಂತ ಆದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರ? Brother and sister. Instead of giving property, you have given the amount. That's all. No, during the presence of the father only, you only offered money instead of property. What is your defense before the trial court? ನಾನು ನನ್ನ ತಂದೆಯ ಹಾಗೂ ಪಂಚಾಯತ್ ಸೇರಿ ಆರೋಪಿಯ ವಿರುದ್ಧ ಜಿದ್ದಿನಿಂದ ಬಲವಂತವಾಗಿ ಚೆಕ್ಕಿಗೆ ಸಹಾಯ ಪಡಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅದೆಲ್ಲ ಡಿಫೆನ್ಸ್. ಕೋರಿಕೊಳ್ಳಬೇಕೆಂದು ಸಿಪಿಐ ಪ್ರಹ್ಲಾದ್ ಮುಚ್ಚಡಿಕೆ ಬರೆದು ಹೇಳಿದ್ದಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. Then what is your defense? DW1 has gone to the extent of saying that he doesn't know the whereabouts of the parents. However, further in the cross examination, he has deposed that he has signed the exhibit P1 because they have asked him to sign. This evidence of DW1 disproves his contention that his signature on exhibit P is obtained forcibly. DW1 has admitted that there are no sufficient funds in the account while he has issued exhibit P1 check. DFW1 has got marked exhibit D1 notice issued by the complainant to her father dated so and so. Is the reply notice dated so and so. D3 is the further notice dated so and so. Exhibit D1 is the postal assignment and so and so petition extract. RTC extracts so and so are the records of bank transactions. Certificate copy of the order sheet so and so. OS award passed by the other lot so and so. Bank passed. D15 GPA is the important document. It reveals that on 23/2/7 the father of the complainant and accused has executed the GPA in favor of son. Exhibit P1 check was dated 3/2000 and as per the evidence of PW1, PW2 and PW4 check was issued on so and so. So it is specific the defense of the accused that exhibit D1 15 May has been cancelled and there are no evidence to show the same. Even DWW1 doesn't remember the date of cancellation of exhibit D15. It can be gathered that he had admitted his signature on exhibit P1, P9, and he has stated that on their saying he has issued exhibit P1. As admitted by him, he has not lodged any complaint before the police about forcible signature. In support of his contention, DWN has not examined any witness. Accused being a BA graduate cannot be forced to sign a blank check, and the accused has admitted his signature and also admitted signature on exhibit P9. P9 ಏನದು? ಮತ್ತೆ ಎಕ್ಸಿಬಿಟ್ P9 ಹಾಕಿದಾರಲ್ಲ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರಲ್ಲ.
Even if P9 plots, the thing is not honored.
Has paid rupees 3 lakh to his father and also the accused has not produced any document with regard to the partition entered into himself and his father. Therefore, from all this reasoning given by the trial court, how it is an erroneous order. That is also a liability. Maybe you are not karta. According to you, you only said that you have paid the amount to your father also, his share 3 lakhs. And there are no evidence to show that he has paid rupees 3 lakhs to his father. And also the accused has not produced any document with regard to the partition entered between himself and his father. This is the observation. ಆಮೇಲೆ ನಿಮ್ ಡಿಫೆನ್ಸ್ ರೀ, ನಿಮ್ಗೂ ನಿಮ್ಮ ಅಪ್ಪನಿಗೂ ಮಾಡ್ಕೊಂಡಿದ್ರಿ, ದುಡ್ಡು ಕೊಟ್ಟಿದೀವಿ 3 ಲಕ್ಷ ಅಂತ ನೀವೆಲ್ಲ ಹೇಳಿದಿರಿ. ಅದಕ್ಕೆ ನಾನು ದಾಖಲೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬರ್ದವ್ರು.
Legally enforceable debt, not liability. The question of legally enforceable debt doesn't arise. If D5 is the negation, it is 6.
Panchayat alli you have agreed to pay the amount of rupees 2,50,000 from the joint family property, and accused failed to pay the same. Hence, again one more panchayat must end, and accused has agreed to pay sum of rupees 2 lakhs and signed an agreement, and the same was kept with CPI Prahlad, and accused has issued a check so and so bearing number that the presentation of the said check for encashment funds insufficient. That is the only argument. Legally not dead. Yes, what do you say? Exhibit P9. ಮೊದ್ಲು 2.5 ಅಂದ್ರು ಆಮೇಲೆ 2 ಆಯ್ತು. ಎಕ್ಸಿಬಿಟ್ P9. ಮೋದಿ ಹೇಳಿಸಿ ಈ ಕೆಳಕಂಡ ಪಂಚಾಯತ್ ಸಮಕ್ಷ
ಅಪ್ಪನ ಆಸ್ತಿ ಹಕ್ಕು
ತೀರ್ಮಾನಿಸಿರುತ್ತೆ. ಆಯ್ತು ಆಯ್ತು. ಸರ್ ಅವನ್ ಎವಿಡೆನ್ಸ್ ಹಾಕಿದ್ಯಾ? ಅಕ್ಯೂಸ್ಡ್ ಎವಿಡೆನ್ಸ್ ಅವನ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಓದ್ತಾ ಇರೋದು. ಅಪ್ಪ ಮಗ ಇಬ್ರೇ ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡವ್ರೆ. ಅದು ರದ್ದುಗೊಂಡಿದೆ 2008 ರದ್ದುಗೊಂಡಿದೆ. ಕೊಡ್ತೀನಿ ಅಂತ ಅದೇ ದಾಖಲೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ, ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ. ಕೊಡಿ ಮೇಡಮ್, ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಇದೆಯಾ? 26/3/2022 ಯಾರೋ ವಕಾಲತ್ತಿದೆ. ಮೆಮೋ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್. ಇಲ್ವಲ್ರಿ ಆ ಥರದ್ದೇನು ಅಪ್ಲಿಕೇಶನ್? ಮೆಮೋ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್ ಮಾತ್ರ ಇದೆ. ಇಂಪಾರ್ಟೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ. ನೋಡ್ಸ್. Heard the petitioner counsel and also the counsel appearing for the respondent. The factual matters of the case of the respondent complainant before the trial court that the complainant is the sister of this petitioner. ಇಬ್ರು ಸೈನ್ ಮಾಡಿ ಏನೋ ಮಾಡಿದಾರಲ್ರಿ. ಇದ್ರ ಮೇಲೆ ಏನು ಆರ್ಡರ್ ಆಗ್ಲಿಲ್ವಾ? Petitioner herein is agreed to pay sum of rupees 2,50,000 as a full and final settlement on or before 9/4/2020. 9/4/20 ಅಂದ್ರೆ ಇದು 26/2 ಆಗಿರೋದು. ಆಮೇಲೆ ಕೊರೋನಾ ಬಂತು, ಮೋಸ್ಟ್ಲಿ ಏನಾಗಿಲ್ಲ. Agreed immediately after arranging the amount will be, give intimation to the respondent through his counsel. The date of registration of the release date on that day, both petitioner and the respondent without any fail appear before the complete registration formalities. Order agide madam. Both parties of a joint compromise application. Same is taken on record. They say for a short accommodation to report settlement in terms of the compromise. Adjournment agide. Okay. And the petitioner is the only son to their father, and they have all got married. It is contended that except the complainant, the remaining two daughters have given everything with respect to the joint family properties at the time of their marriage. And regarding her share is concerned, a panchayat was held. And this petitioner has agreed to pay a sum of rupees 2,50,000 from the joint family property to the complainant on 15/7/2007. But he failed to pay the same. Hence, once again, panchayat was held on 2/11/2007. And the petitioner has agreed to pay a sum of rupees 2 lakhs and signed an agreement. And he has issued a check dated 3/12/2007. On presentation, the check was returned with an endorsement funds insufficient, and hence legal notice was issued on 14/2/2008 and reply was given on 23/2/2008. Not complied the demand, hence complaint was filed and cognizance was taken, and this petitioner was secured. The complainant examined herself as given, and three witnesses and also witnesses were examined as 2 to 4 and relied upon document exhibit P9. P1 to 9. The petitioner also examined himself as DW1 and got marked 21 documents exhibit D1 to 21. The trial court, after considering both oral and documentary evidence, convicted the petitioner herein for the offence pursuant to 138 of NI Act and ordered to pay an amount of rupees 2,50,000. The petitioner herein agreed by the said judgment of conviction and sentence filed an appeal to criminal appeal number 103 of 2010. And the appellate court also on reappreciation of both oral and documentary evidence confirmed the judgment of the trial court and dismissed the appeal. Hence, the revision petition is filed. The counsel who is appointed as amicus curiae, since the petitioner counsel did not assist the court, it submits that the check is not issued for any debt or liability, and the same is also forcibly taken in the panchayat. And hence, invoking of section 138 of NI Act doesn't arise. Though check was issued, that is not towards enforceable debt and liability. And trial court as well as appellate court ought not to have convicted and sentenced the petitioner. And this aspect has been completely ignored by both the courts. The trial court has given much importance that once mandatory requirements are followed, sufficient for entertaining the complaint and passing an order. And the very reasoning is against the law. And presumption invoked against the petitioner is also not permissible. For contra, the counsel appearing to the respondent complainant would submit that issuance of check is not disputed. And the fact that earlier he had agreed to pay rupees 2,50,000 is not in dispute. When he did not pay the amount, once again Panchayat was held. Document Exhibit T9 came into existence. And accordingly, he made the payment of rupees 2 lakhs by way of check, and the said check was presented and dishonored. And hence the very contention that the check is not in respect of debt or liability cannot be accepted. The counsel also would submit that an application is filed before this court under 147 of NI Act, seeking permission to this court to compound the offence, and he agreed to pay the amount in the month of April 2020, but not complied it. And the said application is also on record before the court. Now he cannot contend that he is not liable to pay any amount and check is not towards any debt or liability. Having heard the petitioner counsel and also the counsel appearing for the respondent complainant, and also on perusal of material available on record, the point that would arise the consideration of this court are whether the subject of the check issued in favor of is towards debt or liability. Whether the check issued not towards the debt or liability as contended by the petitioner counsel. Whether both the courts have committed an error in convicting and confirming the judgment of the trial court and it requires revisional jurisdiction. Having heard the respective counsel, it is not in dispute that the complainant as well as the petitioner hearing are brother and sister. It is the case of the complainant that the petitioner hearing in the Panchayat, he had agreed to pay an amount of 2,50,000 towards her share in the joint family property. It is also the case of the complainant that the amount was not paid, and hence once again Panchayat was held. And in terms of the said Panchayat, a document came into existence in terms of Exhibit T9. T9 ಮದ್ದಿಂದ ಅವಾಗ 2.5 ಲಕ್ಷದ ಆಯ್ತು ಏನಾಯ್ತು T9 agreeing to rupees 2,50,000 and the said amount was not paid, and subsequently one more Panchayat was held, and in spite of the same the amount was not paid. No doubt the accused also met his evidence. Accused oblique petitioner also met his evidence as DW1, and he got marked document Exhibit D1 to D21. Having considered the material and record, it is not in dispute that the family was having into undivided family property. The counsel would submit that when the father was alive, the complainant is not entitled for any share. But the fact is that a Panchayat was held is not in dispute. But only contention of the petitioner that the said check was obtained by force. It is emerged in the evidence that he has not given any complaint that check was obtained by force, and he has not disputed the issuance of the check. It is also important to note that in this case, court also an application is filed as 147 of the Act seeking permission to compound the offence. And this Petitioner also has signed the said document, but sought time to keep the parties and settle the issues involved between the parties. And subsequently, due to COVID-19, no order has been passed in respect of the said application. The trial court, while considering the material on record in paragraph number 21, 22, 23, after discussing the evidence of PW1 and PW1, taken note of admitting the signature available in Exhibit P1 and also the issuance of the said check and entering into the agreement in terms of Exhibit P9. Also taken note of no complaint was given, though it is contended that check was obtained by force. The panchayat held between the complainant and accused also not in dispute, and no contra evidence against the evidence of complainant, except examining the petitioner himself as DW1 and marking of document. When such check is given towards the share of her property and towards her share in the property of the joint family, and also an admitted fact that there was a partition between the father and son, and not given any share in favor of the complainant, and not disputed the agreement as well as earlier agreement as well as issuance of check, only contend that the same is not towards any debt or liability. No doubt it is not a debt. It is only a liability to pay the amount towards her share in the family property. When specifying the factual aspects, the contention of the petitioner counsel that it is not towards any debt or liability cannot be accepted. I have already pointed out that the trial court also considered all these aspects, particularly in paragraph number 21, 22, 23, and 24, and in keeping the principles laid on the judgments referred in paragraph number 26, 24, 25, 26, and also 27, comes to the conclusion that check was issued towards legally enforceable debt. The appellate court also, on reappreciation of petitions available on record in paragraph number 12 to 18, discuss the evidence available on record, particularly the evidence of PW1 to 4 as well as the accused evidence, and also taken note of the evidence of petitioner in paragraph number 22. And in paragraph number 23, given the reasoning that the check was given towards his liability. And PW1 to 4 have also deposed before the court that there was an agreement between the parties with regard to the joint family property. And petitioner agreed to rupees 2,50,000 and also later he agreed to pay 2 lakh. And hence check was given. And this matter is also considered the material available on record in detailed discussion in paragraph number 23. It appreciated both oral and document evidence. The very contention of the petitioner counsel that the subject matter of the check is not towards debt or liability, and its contention cannot be accepted, and both the courts have given finding that the subject matter of check was given towards liability to pay the amount in lieu of share of the complainant, and the fact that complainant is the sister of the petitioner is not in dispute. It is also not in dispute that family was having the joint family property. And when witnesses have examined and proved with regard to the execution of document Exhibit P9, and check was also given in favor of petitioner towards consideration of her share in the property. Now counsel cannot contend that sale is not towards debt or liability, and the same is not enforceable. The very submission cannot be accepted. Hence, I do not find any reasons to. Comes to the other conclusion, exercising the revisional jurisdiction. The revisional jurisdiction can be exercised only if finding is apparent on record, not consider the material available on record, and judgment is passed without looking into the present evidence available before the court, and if perverse finding is given, then court can exercise the revisional jurisdiction. The same is not found in the matter on hand, and hence no merit to exercise the revisional jurisdiction. In view of the discussion made above, I pass the following order. Revision petition is dismissed. The registrar is directed to pay an amount of ₹5,000 as amicus curiae charges in favor of the amicus curiae. 63, Shankar and Associates. Next, 64, N. Suresha, SPP. ಪಾಸ್ ಓವರ್ ಯಾರಿಲ್ವಾ? ಲಾಸ್ಟ್ ಟೈಮ್ ಆಬ್ಸೆಂಟಾ? ಮತ್ತೇನೆಲ್ಲ ನೋಡೋಣ, ಮತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಲಕ್ಷ್ಮೀನಾರಾಯಣ 65, ವಿಜಯ
for the respondent.
ಹಾ, ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಇದಾರ ನೋಡಿ ಮೇಡಮ್.
Many times it has come, my lord. They are not appearing.
138
130 short matter around 70,000 and involved ಅಷ್ಟೇ.
ಆಯ್ತು, ಇನ್ನು 10 ವರ್ಷ ಸಾಕಾಗಿಲ್ಲ ಅವ್ರಿಗೆ. 2012 NI ಆಕ್ಟ್. ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ. ಮಧ್ಯಾಹ್ನ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಐ ವಿಲ್ ಕನ್ಸಿಡರ್ ಆನ್ ಮೆರಿಟ್ಸ್. ನಾಗೇಂದ್ರ ನಾಯ್ಕ್ ಪಾಸ್ ಓವರ್. 67, HV ಮಂಜುನಾಥ್ ಇದಾರ? ಯಾರು ಇಲ್ಲ, ಪಾಸ್ ಓವರ್. ಪದ್ಮಾವತಮ್ಮ, RB ದೇಶಪಾಂಡೆ. ಹಾ, ಕೊಡಿ ಬನ್ನಿ. ಹ್ಮ್ 279, 304, 337 ಇದೆಯಾ? ಹಾ, ಏನ್ ಗ್ರೌಂಡ್ ಏನ್ ನಿಮ್ದು ರಿವಿಷನ್ ಅಲ್ಲಿ? ಹಾ, PW3. ಮೋಟರ್ ಸೈಕಲ್ ನಿಮ್ಮ ವೆಹಿಕಲ್ ಏನು? ನಿಮ್ಮ ವೆಹಿಕಲ್ ಏನ್ರಿ? ಅಪೆಂಡಿಂಗ್ ವೆಹಿಕಲ್ ಏನು? ನಿಮ್ದೇ ಬೈಕಾ? ಹಾ, ಅಪೆಂಡಿಂಗ್. ನಿಮ್ದೇನ್ ಮಿನಿ ಲಾರಿನ, ಟಿಪ್ಪರ್ ಲಾರಿನ, ದೊಡ್ಡ ಲಾರಿನ? ಟಿಪ್ಪರ್ ಲಾರಿನೇ. ಹಾ, ಮಿನಿ ಲಾರಿ, ಟಿಪ್ಪರ್ ಲಾರಿ ಅದೇನು ದೊಡ್ಡ? ಇಟ್ ವಿಲ್ ನಾಟ್ ಮೇಕ್ ಎನಿ ಡಿಫರೆನ್ಸ್. ಹಾ, PW1. ಓ, ನಾನು ನಿಲ್ಲಿಸ್ತಿಲ್ವಾ ಅಲ್ಲಿ? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಸೆಂಟೆನ್ಸ್? 6 months. Only question now ಏನಿದ್ರು whether PW1 and PW3 evidence can be accepted or not. 279 I will set aside the order. ಕೊಡಿ evidence ಕೊಡಿ ಮೇಡಮ್, PW1 and 3. If you discredited the evidence of PW1 and 3, then PW ಒಬ್ಬನೇ ಇದ್ನ ಮೋಟರ್ ಸೈಕಲ್ ಅಲ್ಲಿ? ಮೋಟರ್ ಸೈಕಲ್ ಅಲ್ಲಿ ಅವ್ನು ಒಬ್ಬನೇ ಇದ್ನ ಅಂದೆ. 300 ಸತ್ತ ಹೋದ್ನಾ ಅವನೇ? Around 9:55 AM, myself and deceased also going by motorcycle to Kengeri main road in front of Ganesh temple. We were going towards Mysore road. At that time, going towards Mysore road, a lorry which came from rear side dashed against my bike from the left side of the same Same. Thereby fell down on the right side pillion rider, fell down on the left side. The lorry ran over the head of the pillion rider, causing severe injuries. He sustained so. Shifted Rajarajeshwari Hospital by ambulance, but the rider declared as dead. They had taken treatment at hospital. The offending lorry so had lodged complaint before the police. Sale is marked as exhibit P1. Mazar. He also sustained injuries, sir. The spot of accident is a busy road in the morning hours. My bike was going at a distance of 5 to 10 feet from the left footpath. The said road has got 40 feet width. Same is a two-way traffic road. It is not true. I was riding my high speed. Not true. Other vehicles were also going by beside my vehicle. It is not true. I have not seen the vehicle which hit my bike. The lorry driver, after the accident, slowed down the lorry and saw us and went away from the spot. Before the police, it is not true. I have not stated the portion of lorry which hit my bike. It is not true. Not true to lorry drove my bike. They never caused accident. It is false to suggest that I am not so. I am aware of the spot accident written in the matter. It is not true. I have not signed at police station. So here elicit ಮಾಡಿಸಿದ್ರಿ ಕ್ರಾಸ್ ಅನ್ನು to disbelieve the accident. ಮತ್ತೆ ಅಲ್ಲ ಅದನ್ನೇ ಹೇಳಿದ್ದು. ಎಲ್ಲಿದೆ ಹೋಗ್ಲಿ ನಿಮ್ಮ ಆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಯಾರು ಎಲ್ಲಿದೆ? CW2 age 25 injuries found mentioned in certificates and in nature. Portion anta ad nimse class alli it is not true adri ade suggestion ashte hit to my bike anta Among them are the driver sustained injury and other injuries. The pillion rider suffered head injury. The injured was accepted by ambulance to hospital. The accident was due to negligence of the driver of the lorry. I have not observed the driver of the lorry. During enquiries by police, I have stated that I had observed the driver of the lorry. Now I cannot identify the driver. That's better identification. ಆಯ್ತು ನೀವು PW1 ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಇವನಲ್ಲ ಇವನು ಇಲ್ಲೇ ಇಲ್ಲ ಅಂತ ಆ ಸಜೆಷನ್ ಅಷ್ಟೇ ರೀ ಸಜೆಷನ್ ಬೇಡ ವಾಹನ ಸಹಿತ ಬಲಭಾಗಕ್ಕೆ ಹಿಂದೆ ಕುಳಿತಿದ್ದ ಏರು ಭಾಗದಲ್ಲಿ ಬಿದ್ದಾಗ ಲಾರಿಯ ಚಕ್ರ ತಲೆಯ ಮೇಲೆ ಹರಿದು ಹೋಗಿದ್ದು ನಾನು ಎದ್ದು ನೋಡಲಾಗಿ ವಾಹನ ನಿಲ್ಲಿಸಿದ ಹೊರಟು ಹೋದರು ನನ್ನ ಹಿಂಬದಿ ಸವಾರನ ತಲೆಯಿಂದ is it your case that you are not riding the vehicle on the date of date ಎಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಇದೆ ಅದು ನೀವು ಮಾಡಿದೀರಾ ಅಯ್ಯೋ ಅಂತ ಅಯ್ಯೋ ಏನ್ ಹೇಳ್ತಾನೆ ಆಯ್ತ್ರಿ ಬರೀ ಡಿನೇ ಸಜೆಷನ್ಸ್ ಮಾಡಿ ಉಪಯೋಗ ಇಲ್ಲ ದಟ್ ಇಸ್ ನಾಟ್ ಅನ್ ಆರ್ಟ್ ಆಫ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಯು ಹ್ಯಾವ್ ಟು ಎಲಿಸಿಟ್ ದಿ ಆನ್ಸರ್ಸ್ ಫ್ರಮ್ ದ ಮೌತ್ ಆಫ್ ವಿಟ್ನೆಸಸ್ ಇವನೇ ಕಂಪ್ಲೇನೆಂಟ್ ಅವನೇ ಕಂಪ್ಲೇನೆಂಟ್ ಹೇಳಿ ಲಾರಿ ಚಾಲಕರು ನೋಡಿರುತ್ತೇನೆ ಮತ್ತು ನೋಡಿದರೆ ಗುರುತಿಸುತ್ತೇನೆ ಸ್ಲೋ ಡೌನ್ ಮಾಡ್ದ ಅಂತ ಹೌದು ಸ್ಲೋ ಡೌನ್ ಮಾಡಿದಾಗ ಹಿಂದೆಯಿಂದ ಬಂದು ನಾವ್ ಎಡಗಡೆ ಭಾಗದಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ವಿ ಅವಾಗ ಡಿಕ್ಕಿ ಹೊಡೆದ ಅಂತ ಅಷ್ಟೇ ನಾನು ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ರಿಪೋರ್ಟ್ IME ರಿಪೋರ್ಟ್ ಎಲ್ಲ ಹೇಳಿದ್ರಿ ಏನದು Exhibit B mark ಆದಂಗಿಲ್ಲ 9 damages found. ನರಕು ಸಾಗರಿಕೆ ವಾಹನ. ಸೈಡ್ ಅಲ್ಲೇ ಡಿಕ್ಕಿ ಹೊಡೆದ್ರೆ ಏನಾಗುತ್ತೆ ಒಂಚೂರು ಟಚ್ ಆದ್ರೆ ಸಾಕು, ಏನ್ ಡ್ಯಾಮೇಜ್? ಹೆವಿ ವೆಹಿಕಲ್ ಡ್ಯಾಮೇಜ್. Sketch exhibit P. Exhibit P12. Oh, both are proceeding in the same direction. That's all. ಮಧ್ಯಾಹ್ನ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀನಿ. PW5 vehicle owner, lorry owner. You accused as the driver on the date of the accident. ಬಾಂಡ್ ಎಲ್ಲ ಮಾಡಿ ಎಲ್ಲ ವಿಸಿಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ರಿಲೀಸ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ. But as whether he says that as on the date of the accident the vehicle was driven by this petitioner ilva ಏನು ಹೇಳ್ತಾನೆ? ಕೊಡಿ ಮೇಡಮ್. The document shown to me where my signature same is marked also shown. Shivraj Kumar mentioned in exhibit P8 is accused before the court. Exhibit P8 ಏನು? ರಿಪ್ಲೈ ನೋಟಿಸ್ ಗೆ ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದಾನಲ್ಲದ? Exhibit P8. Shivraj Kumar is the driver ಅಂತ ಹೇಳ್ತಾರೆ. ಆಯ್ತು 2:30 dictate the orders. Court seat and ಜಾಸ್ತಿ ಹೇಳಿ 69. ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ನಿಮ್ದಾನೆ. ನಾಡಿದಕ್ಕಿಲ್ಲ ಇಲ್ಲ ಈಗಲೇ ಹೇಳಿ ಗೊತ್ತಾರೆ ಕೇಳ್ತೀನಿ. ನಿಮ್ಗೆ ಮಧ್ಯಾಹ್ನ ಇನ್ಕನ್ವೀನಿಯಂಟ್ ಅಂದ್ರೆ ಈಗ ನಾವು ರೈಟ್ ನಾವು ಇಲ್ಲಿ ಹಿಯರ್ ಅನದರ್ 15 minutes. ಹೇಳಿ. ಯಾವ ಇಯರ್ 2013, ಆಲ್ಮೋಸ್ಟ್ 1 decade. ನಾಡಿದ್ದ ನಮ್ಗೆ ಇರ್ಬೇಕಲ್ಲ ಡೇಟ್. ನಾವು ಆಲ್ರೆಡಿ 15 ದಿವಸಕ್ಕೆ ಡೇಟ್ ಕೊಡ್ತಾ ಇದೀವಿ. ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್ ಇವತ್ತೇನೆ, ಅದಕ್ಕೆ ಇವತ್ತು ಡೇಟ್ ಕೊಟ್ರು. ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ? ಅದು ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ಅಂದ್ರೆ ಕನ್ವೀನಿಯಂಟ್ ಟು ಕೋರ್ಟ್. ಅಂದ್ರೆ ಈಗ ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ತೊಂದ್ರೆ ನಿಮ್ಗೆ ಈಗ ಹೇಳಿ ಮಾಡ್ಬೋದಲ್ಲ. ಈಗಲೂ ತೊಂದ್ರೆ ಇದೆಯಾ? ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಏನ್ ರಿಕ್ವೆಸ್ಟ್ ಕರೆಕ್ಟ್ ಮಾಡಿದ್ರೆ 10 ನಿಮಿಷ ಓದಿದ್ರೆ ಮಾತಾಡ್ಬೇಕಲ್ಲ, ಅವಾಗ ಕಷ್ಟ.
Can I make a mention, my lord?
Yes, counsel.
Serial number 81, my lord. The previous counsel on record for APMC was passed away. So court had issued court notice to the APMC. ಶನಿವಾರ ನನಗೆ ರೆಕಾರ್ಡ್ಸ್ ಕೊಟ್ಟು ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವತ್ತು ಬೆಳಗ್ಗೆ ನಾನು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
ಹಾಕಿದ್ದೀರಾ?
ಇವತ್ತು ಬೆಳಗ್ಗೆ ಹಾಕಿದ್ದೀನಿ. Time we granted, my lord. I'll go through it and
name counsel Swarup.
Please, Swarup. Please, my lord.
Serial number 81. Counsel Swarup submits that he has filed wakalat today in the office on behalf of petitioner or respondent?
Appellant, my lord.
Petitioner. And hence office is directed to put up the wakalat and show the name of counsel T. Swarup. on behalf of the petitioner. List this matter on 8th April.
Much obliged.
Other side are state or respondent idara?
Respondent idare.
Idara ಅವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದಿರಾ?
ನಂಬರ್ ಏನು ಗೊತ್ತಿಲ್ಲ.
81 ಅಲ್ಲಿ ಯಾರೋ ಕೌನ್ಸಿಲ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ವಲ್ಲ, ಅದಕ್ಕೆ ಅಡ್ವೊಕೇಟ್ ಬಂದಿದ್ದಾರೆ. ನೀವೇನಾ ಲೋಕೇಶ್ ಕುಮಾರ್? ಲಿಸ್ಟೆಡ್ ಆನ್ 8th April. 6th ಬೇಕಾ? ಆಯ್ತು, 6th of April, not 8th.
ಪ್ಲೀಸ್ ಮನಿ.
ಹೇಳಿ.
ಮಚ್ obliged.
ಯಾವುದು? 66 ಈಗಿದೆಯಲ್ಲ, ಅದೇ ತಾನೇ ಇದ್ದಿದ್ದು. ಪಾಸ್ ಓವರ್ ಮಾಡಿದೀವಿ. ಮುಗಿಸ್ಕೊ ಬನ್ನಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಏನು? ಆಯ್ತು, ನಾಳೆ ಟೈಮ್ ಇರಲ್ರಿ ನಮ್ಗೆ. ಹೋದ್ರೆ ಮತ್ತೆ 14 ದಿವಸ ಹೋಗುತ್ತೆ ಡೇಟ್. ನಾಳೆಗೆ ಅಂದ್ರೆ ನಾವು ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀವಿ, ಇಂಥ ದಿವಸಕ್ಕೆ ಇಷ್ಟು ಅಂತ ಹಾಕೊಂಡಿರ್ತೀವಿ. ಅಷ್ಟು ಕೊಟ್ಟನೆ ದಿನ 100 ಪಿಟಿಷನ್ಸ್ ಕೊಡ್ತಾ ಇದೆ, ನೋಡಿದಿರಲ್ಲ. ರೆಡಿ ಇದ್ರೆ ಮತ್ ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ. ನಿಮ್ದು ಈಗ ಪಾಸ್ ಓವರ್ ಮಾಡಿದೀನಿ ಅಲ್ರಿ, ಅಲ್ಲಿ 3 ಗಂಟೆಗೆ ಇಲ್ಲಿ ಬನ್ನಿ, 2:15 ಏನು? ಆಯ್ತು ತಗೊಳ್ಳಿ. ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ 6 times list this matter on 8th April. ಎಷ್ಟು? ಏಕೆ ಏನ್ರಿ ಬರೀ ಟೈಮ್ ಕೇಳ್ಬಿಟ್ರಿ, ಏನಿಲ್ಲ. ಆಯ್ತು, 8th April list this matter. ಆಯ್ತಾ ಮೇಡಮ್? ಆಯ್ತು. 71 ಏನ್ರಿ? ಏನು VS ಪ್ರಸಾದ್ 71 ಏನು? ಸ್ಟೇಟ್ ನೀವೇ ಮಾಡಿ, ನಿಮ್ ಸೀನಿಯರ್ ಹಾಕ್ಬೇಕು. ಸೀನಿಯರ್ ಬಂದ್ರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಏನ್ ಚೇಂಜ್ ಆಗಲ್ಲ. ಐ ವಿಲ್ ಲುಕ್ ಇನ್ ಟು ದಿ ಎವಿಡೆನ್ಸ್ ಅಂಡ್ ಯು ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್, ದಟ್ಸ್ ಆಲ್. ಯಾರು ಬಂದ್ರು ಅಷ್ಟೇ, ಸೀನಿಯರ್ ಬಂದ್ರು ಅಷ್ಟೇ, ಜೂನಿಯರ್ ಬಂದ್ರು ಅಷ್ಟೇ. ವಿತೌಟ್ ಲುಕಿಂಗ್ ಇನ್ ಟು ದಿ ರೆಕಾರ್ಡ್ಸ್ ಐ ವಿಲ್ ನಾಟ್ ಪಾಸ್ ಎನಿ ಆರ್ಡರ್ಸ್. ಸೀನಿಯರ್ ಬಂದ್ರು ಒಂದೇ, ಜೂನಿಯರ್ ಬಂದ್ರು ಒಂದೇ, ಯಾರು ಬಂದ್ರು ಒಂದೇ. ಯು ಅಸಿಸ್ಟ್ ಕೋರ್ಟ್ ಅಷ್ಟೇ. ಇಫ್ ಎನಿ ಡಿಫಿಕಲ್ಟಿ, ಕೋರ್ಟ್ ವಿಲ್ ಅಸಿಸ್ಟ್ ಯು. ನೋಟ್ ಇಟ್. ಆಯ್ತು. ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ 6 times list this matter on 8th April. ಅಷ್ಟೇನಾ?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮಧ್ಯಾಹ್ನ ಬಂದಿದ ತಕ್ಷಣ ಪಾಸ್ ಓವರ್ ತಗೋತಾರ? ಪಾಸ್ ಓವರ್ ತುಂಬಾ ಇದೆಯಮ್ಮ ಮೇಡಮ್?
Think of it.
ಬಂದೆ ಸರ್.
ಸರಿ, ನನ್ನ ಹೆಸರು ಬರೆಯುತ್ತೀರಿ. ನನ್ನ ಹೆಸರು ಬರ್ತಾ ಇಲ್ಲ. ಸರ್, ಲಾಸ್ಟ್ ಟೈಮ್ ಹೆಸರು ಬರ್ಲಾರಕ್ಕೆ ಡೇಟ್ ಆಗಿದೆ. ಒಂದ್ ನಿಮಿಷ. ಹಲೋ, ಮಾಡೋದು ಒಂದ್ ಮಾಡುದು, ಒಂದ್ ಹೊಡೋದು, ಎರಡು ಹೆಸರು ಹೊಡೆದು ಚಲೋ. ಸರ್ ಬರ್ತೀನಿ.
ಸರ್ ಹೇಳಿ ಸರ್. ಗುಲ್ಬರ್ಗ
ಸೀರಿಯಲ್ ನಂಬರ್
HGP-ನಾ?
ಗುರುರಾಜ್ ವಿ SGP ಮೇಡಮ್.
ಓಕೆ.
ನಾವು ಕೈಲಾಸ್ CH-18 ಅಂತ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಪೆಟಿಷನರ್ಸ್. ಆಯ್ತು. ಅಷ್ಟೇನ್ ಬೇಕಾಗಿಲ್ಲ.
ಏನ್ ಹೇಳ್ತಾನ ಬಂದರೆ ಅದೇ Lord, I have filed a charge sheet copy. Charge sheet copy and
Yes, counsel.
there is no any whisper made by the respondent police regarding the marriage of the petitioner with the complainant with the petitioner. Already the marriage has been taken place. The accused is in judicial custody since from 19/11/21, my lord. And the petitioner was arrested and produced from. He is in JC, my lord.
Madam, earlier order is allowed. Here is the earlier order.
Earlier order, my lord.
Ilva. Why you are not taking earlier order?
Produced, my lord. Earlier order produced. Bail petition ಜೊತೆಗೆ ಹಾಕಿನ್, my lord.
ಎಲ್ಲಿದೆ ಹೇಳಿ, ಯಾವ್ದು ಪೇಜ್ ನಂಬರ್?
ಇದು ಪೇಜ್ ನಂಬರ್ 1 ಇದು ಇದರಲ್ಲಿ ಇದೆ ನೋಡಿ ಬನ್ನಿ. ಬೇಲ್ ಪಿಟಿಷನ್ ಜೊತೆಗೆ ಪೇಜ್ ನಂಬರ್
page number 27.
27.
What was the reason given earlier?
In period of weeks when the father was in the hospital, the members of the having considered the gravity of the offense, complaint is specific that he had sexual intercourse with her against her will, and the case is still under investigation. When such heinous offense is alleged by the complainant is alleged committed by this petitioner, he is not a fit case to exercise discretion under section 438. Now the charge sheet has been filed and the accused is in judicial custody, my lord. Therefore, keeping and the accused has got married with the complainant, my lord. Therefore, keeping him in judicial custody will not serve any purpose. Therefore, I am ready to abide by the conditions imposed by the Honorable Court and also abide by the
Yes, counsel. State.
Yes, date of marriage is registered and petitioner and complainant 2/7/2021. It is earliest. That's the
27?
last year. 2/7/2021. Registered marriage was. And
now both are married.
2021 is married, but from 2 years back, he was forcibly sexual intercourse and so many times to the complaint minor.
That is before the marriage.
Yes, ma'am. And also after the my lord, after the marriage, he is lodged a complaint against this petitioner under section 498A, my lord. Even also after the registration of this case, She was filed a complaint against petitioner on 27/7/2021. Offense punishment is 490 days, 323, 324. Petitioner along with parents of the petitioner.
After the marriage.
After the marriage, my lord, and she has not whispered a single word stating that she has filed this complaint again earlier to the 498, my lord. Therefore,
one more case is also registered against this petitioner prior to registering this case.
no, my lord. After registering this case, one more case has been registered.
For the offense punishment on section 498A.
498, my lord.
Sorry, madam. And the petitioner counsel and also the counsel appearing to the state. This is a successive bail petition filed by the petitioner seeking bail in respect of the offences punishment of section 376(2) within bracket N 323, 504 and 506, 34 of IPC. This court earlier rejected bail petition of this petitioner, considering the material on record that this petition, the allegation against this petitioner is that he subjected her for sexual act on 8/6/2019. He continuously subjected her for 2 weeks when her father was in the hospital. It is also an allegation that he had continued the sexual act with her, and also he has promised that he would marry her. And when quarrel was taken place between the complainant and family members of the petitioner, he turned hostile to his promise. This court, while considering the material on record, comes to the conclusion that considering the gravity of the offense, and complaint is specific that he had sexual intercourse with her against her will, and the case is still under investigation, and hence not a case for exercising the discretion. Now, after filing the charge sheet, has come up with this bail petition contending that both of them married after the alleged sexual act. That is on 15/6/2021 at Lakshmi Narayana Temple near Naganahalli Cross. In the presence of all the family members of complainant and petitioner. And the marriage was also got registered on 2/7/21. The complainant intended to dominate the petitioner and his family members and willfully lodged the complaint on 28/6/21, alleging the act was taken place in 2021 or 2019, and when the investigation is already been completed and delay also not properly explained in lodging the complaint, no need of custodial trial. For account of the counsel appearing to the state, it submits that according to the petitioner, marriage was taken place on 15/6/2021. And though marriage was registered on 2/7/2021 as per the petitioner, but complaint is given on 28/6/2021. But according to the petitioner, marriage was solemnized. Marriage was registered on 2/7/2021. And having considered the said factor, aspect into consideration, and also the allegation in the complaint, wherein it is stated that he was subjected to sexual act for a period of 2 years or 2 months, 2 weeks, and also the allegation that when the father was in the hospital, took the advantage of this situation and subjected her for sexual act. Having considered the incident was taking place in 2019, that is on 8/6/2019, as well as subsequent to the said incident, the complaint is lodged almost after 2 years, and also the counsel appearing for the state would submit that other case is also registered under section 498A, 323, 324. And when such submission is made, it is clear that an offense of cruelty is also invoked against the petitioner in other crime. And taking into all this aspect into consideration, and also after filing of charge sheet, the present petition is filed. The allegation of subjecting her for sexual act in the year 2019, and also the contention that subsequently both of them married, and also the case invoking section 498A of IPC. I am of the opinion it is a fit case to exercise the discretion in favor of the petitioner, and no need of custodial trial, and hence the petitioner may be enlarged and bail with certain conditions. Sanjay A. Patil.
Minutes, I appear for petitioners.
Yes.
Minutes, this is a successive petition. Earlier, lordships had dealt with the matter at ink page 27 of the paper book, wherein the FSL report was not before your lordships, and hence your lordships had given liberty to move after the receipt of FSL. Now that the FSL is received and they have placed before your lordships, and also a copy is given to me. The recovery insofar as this petitioner is concerned, who is accused number 2, Jettappa, your lordship would see at ink page 21 of the charge sheet that those are item number 17 and 18.
Charge sheet page number
21 minutes. The relevant recovery materials are 21. That is column number 11 ಅಲ್ಲಿ.
11 ಅಲ್ಲಿ ಒಂದೊಂದೇನು ಕೇಳೋದಿಲ್ಲ ಅದೇ
ಮಿಲಾಡ್ಸ್
ನಿಮ್ಮ ವಾಯ್ಸ್ ಕ್ಲಿಯರ್ ಬರ್ತಿತ್ತಾ?
ಅಲ್ಲೇ
ಮಿಲಾಡ್ಸ್
ಗುರುರಾಜ್ ಮಾಸಿಲ್ಕರ್ ಮ್ಯೂಟ್ ಮಾಡಿದಾರಲ್ವಾ? Government advocate. Yes, continue, counsel. Some disturbance from.
Yes, madam. There is some. Not serial numbers, item number 17 and 18, which is against the present petitioner who is not wearing Kesari Bannada full.
Charge sheet commences at page number 20.
At page number 20 and 21 is the column number 11 recovery. That is serial number 17 and 18.
ಸಿದ್ಧಾರೂಢ ಈತನ ಶವದ ಮೈ ಮೇಲೆ ಇದ್ದ ಬಿಳಿ ಬಣ್ಣದ ಹಾಫ್ ಬನಿಯನ್ ಒಂದು.
Malad sir, 17 ಮತ್ತೆ 18 is relevant to the accused number Jettappa. That is the
Jettappa ಈತನ ಕೇಸರಿ ಬಣ್ಣದ ಫುಲ್ ತೋಳಿನ ಶರ್ಟ್ ಒಂದು ಹಳೆಯದು.
ತೋಳಿನ ಒಂದು ಶರ್ಟ್, ನೀಲಿ ಬಣ್ಣದ ನೈಟ್ ಪ್ಯಾಂಟ್
ಇತ್ತು. ನೀಲಿ ಬಣ್ಣ ನೈಟ್ ಪ್ಯಾಂಟ್.
ಹೌದು ಸರ್. 17 ಮತ್ತು 18 ಈತನ ಮೇಲೆ ರಿಕವರಿ ತೋರಿಸ್ತಾರೆ.
ಆಯ್ತು. ಸೀಸರ್ what is the report?
The report FSL report is placed before lordship. In all 19 items were appear to be sent to the FSL. I will come to the FSL later on. At ink page 22 of the charge sheet itself, In all 1 to 18 items were sent as per the report of the IO. ಈ FSL ಅಲ್ಲಿ ಮಾತ್ರ 16 ಐಟಮ್ ಕಾಣುತ್ತೆ ಸ್ವಾಮಿ. ಅರೌಂಡ್ 16 ಐಟಮ್ಸ್ ಅಂತ ತೋರಿಸ್ತಾರೆ.
Where is that FSL report?
ನನಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್, ಒಂದು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೋರ್ಟ್ಗೆ ಹಾಕಿದಾರಾ?
ಸರ್ ಅವರು
17th March I will file my
ಇದೆ next
memo.
The 16 items were sent, and out of which now
that is serial number 15 and 16.
How sir? Serial number 15 and 16, sir. Sir, if your lordship sees, serial number 15 was stained very few 0.1-1 centimeter. ಆಮೇಲೆ 16 ಅದೇ sir, very few 0.1 so and so. Why I say this is, moderately stained items are found at serial number 3 to 5, and another moderate item was seen at serial number 9. 0.1-1 centimeter is so negligible that here and there ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಹತ್ತಿದೆ ಅನ್ನೋದೊಂದು ಮಾತು it is been reflected. And now the items which were stained at serial number 4, what they say is it is a B group of blood.
No. O group of blood. Serial number.
I stand corrected.
Opinion. Serial number 4. O group, not B group.
No, it's O group.
O group belongs to the deceased only.
And O group belongs to the deceased. Another sir. Post-mortem allu illa, neither in the charge sheet, not in the post-mortem, whether the group of the deceased at ink page 35 post-mortem report hakidin sir. ಅಲ್ಲಿ ಎಲ್ಲೂ
ಡಿಸೀಸ್ ಗೆ ಸಂಬಂಧಪಟ್ಟಂತ ಕ್ಲಾತ್ ಸೀಸ್ ಆಗಿಲ್ವಾ? ಇಲ್ಲ ಇದೆ ನೋಡಿ, ಮಡ್ಡು, ಸ್ಯಾಂಪಲ್ ಮಡ್ಡು, one ಕವಾಡಿ ಪೀಸಸ್, one blanket. This is pertaining to the deceased only. These are also contains the O group blood. Matches with the deceased blood found in the stains available in the cloth of the petitioner.
And recovered from the
FSL report helps you.
FSL report, I will make an attempt, because
attempt ಮಾಡಿ.
Why I say this is, if your lordship sees the size and approximity of the blood found on
approximate ಅದೆಲ್ಲ ಈಗೆಲ್ಲ ಬರೋದಿಲ್ಲ ಅದೆಲ್ಲ. Next, only to connect the accused whether material is there or not. ಏನ್ರಿ ಗುರುರಾಜ್ ಹಸಿಲ್ಕರ್,
page number 26 of which was filed by the petitioner, my lord, as per number 17, my lord.
26.
ಇವನು ಅಲ್ಲಿ ಹಾಸಿಗೆ ಮೇಲಿದ್ದ ದೋಷಾರೋಪಣೆ 11ರಲ್ಲಿ ಜಪ್ತಾದ ಬ್ಲಾಂಕೆಟ್ ಇಂದ, ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್ ಪೆಟಿಷನರ್ ಮೈ ಲಾರ್ಡ್, ಜಟ್ಟಪ್ಪ ನಾಟಿಕರ್, ಇವನು ಅಲ್ಲಿ ಹಾಸಿಗೆ ಮೇಲಿದ್ದ ದೋಷಾರೋಪಣೆ ಕಾಲಂ ನಂಬರ್ 11ರಲ್ಲಿ ಜಪ್ತಾದ ಬ್ಲಾಂಕೆಟ್ ದಿಂದ ಅವನ ಕುತ್ತಿಗೆಗೆ
ಬಿಗಿದು ಉಸಿರು ಕಟ್ಟಿಸಿ ಕೊಲೆ ಮಾಡಿದ.
It's also as per FSL report, it was also blood-stained blankets was reported, my lord.
Earlier lordships had discussed on merit, so I did not go take your lordships to that portion.
Yes. Only regarding FSL, whether FSL will help you or not.
Yes, that was the liberty given, so I pointed out only that.
Or the petitioner counsel and also the counsel appearing for the state. This is a successive bail petition filed by the petitioner before this court. This court earlier in criminal petition number 201255 of 2021, considering the matter on merits, dismissed the bail petition and given an opportunity to the petitioner to approach this court after the receipt of FSL report. Now the petitioner has filed the petition before the court, contending that FSL report is received. The counsel appearing for the petitioner would contend that the blood stains which were found in the cloth of this petitioner, only very few, and size in also only 0.1 centimeters in both the articles. and very quantum of blood found in the item number 15 and 16, that is shirt and night pant of the petitioner, very less, and hence the petitioner is entitled for bail. For counter, the counsel appearing for the state to contend that the FSL report goes against the petitioner, and with regard to item number 15 and 16 belongs to this petitioner. Report is clear that a stained with O group of blood, and the blood group of the deceased is also O group of blood, and hence the blood stains found in the cloth of the petitioner is also corroborates with material on record. Having heard the respective counsel and also on perusal of material, and this court already in the earlier petition considered the matter on merits, and only liberty is given to the petitioner to approach this court after the receipt of FSL report. And perusal of the FSL report, I have already pointed out that the item number 15 and 16 belongs to this petitioner, was stained with blood, and the same is also the O group of blood, and the same prima facie matches with the blood group of the victim when assessing the factual aspects, and also in item number 15 and 16 when blood stains are also found and positive report is given, I am of the opinion it is not a fit case to exercise the discretion in favor of the petitioner in the successive bail petition. There is no any change circumstances to enlarge the petitioner on bail, and only in successive bail petition the court can exercise the discretion if any change circumstances, and the same is not found, and FSL also goes against the petitioner, and hence it is not a fit case to exercise the discretion under section 439 of CRPC.
Trial may be expedited 1 year, I sir. 1st of April 21 in the there.
Offense alla ಮಾಡ್ರಿ 1 ವರ್ಷ ಆದ್ರೆ ಏನ್ ಮಾಡೋದು ಹೇಳಿ, ಲೈಫ್ ಸೆಂಟೆನ್ಸ್. ಅಲ್ಲಿ ಎಷ್ಟು ಕೇಸ್ ಇರ್ತದೋ ನಮ್ಗೇನು ಗೊತ್ತಾಗ್ತದೆ ಹೇಳಿ.
Please.
Bail petition is rejected.
My lord, 439 petition. Petitioner is accused number 1. Earlier, my lord, petitioner filed anticipated bail before this honorable court. And under apprehension of arrest. My lord, the case was registered under section 279 304A. My lord, the contents of the complaint itself clearly disclose the fact that my lord, the deceased was having is a alcoholic, used to consume alcohol heavily. And my lord, when driving his motorcycle, he fell down and sustained injury, died on the spot. As per the complaint, government discloses the fact narrated in the complaint, my lord. Later, my lord, on suspicious, my lord, petitioner and rest of the accused, in all 4 accused have been arrested only on the strength of confession. Now already, my lord, 2 to 4 accused have been released on bail by the session court. Except confession, my lord, absolutely there is no material to invoke section 302. My lord, considering the fact that my lord, rest of the accused have been released on bail. Apart from that, my lord,
released on bail on regular bail or in
regular bail, my lord. I have submit. I have in the same order itself, my lord, accused number 4 has released on bail. In the rest of the in one more petition, my lord, I have submitted along with memo last week itself. Whether it is in the file or not, whether it is reached or not, I don't know, my lord.
It is reached. It has reached.
My lord, in all accused number 2 to 4 have been released on bail, except confession, absolutely no material, my lord.
This petitioner is accused number
1, my lord.
A1.
A1.
He is the masterminded.
He is according to he is the brother of the deceased, my lord. Because of that reason, my lord, they have arrested and only on the strength of confession, my lord. Except confession, absolutely no material. My lord,
let him go and surrender. Then let the district court consider his bail petition also under section 439.
Since from 13/1/2022, he is in custody, my lord.
13/1 already arrest agidena?
Arrest regular bail, my lord. Earlier anticipated.
Now regular bail.
Now regular bail. They have been released on, rest of the accused have been released on regular bail.
What is the allegation against this petitioner?
My lord, according to the there was a
earlier it was pretended as an accident.
How's a complaint adjournments itself, the complainant himself categorically stated in his complaint that he fell down and sustained injury, died on the spot. So crime was registered under 279 and 304A. Only on the fact that, my lord, he being the brother, my lord, only on suspicious, my lord, and confession.
Not suspicious. Postmortem report discloses that death was due to hemorrhage and shock, secondary to blunt injury to vital organs, that is brain and lungs. That is the PM report. That's why it was converted as 302 instead of 279 304A.
Lord, already co-accused have been laid on bail since from 13-1 except confession and my lord, absolutely no material at all. Under this circumstance, I pray this honorable court, my lord. ಜೋರಾಗಿ ಹೋಗುವಾಗ ಜೋಲಿ ಹೋಗಿ ರಸ್ತೆ ಪಕ್ಕದ ಗೇಟ್ ಅಲ್ಲಿ ಹಾಯಿಸಿ ರಸ್ತೆ ಎಡಗಡೆ ಇವರ ಹೊಲದ ಕಡೆ ಬಿದ್ದು ಮರಣ ಹೊಂದದಂತೆ.
Where is the charge sheet?
Still it is not been filed. Still it is not yet been filed.
Charge sheet file ಆಗಿಲ್ಲ ಇನ್ನು.
ಇಲ್ಲ ಸರ್.
ಬಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗದಲ್ಲೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನವರು ಬೇಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು, ಉಳ್ಕಾದ ಆರೋಪಿಗಳು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್ 2 to 4.
ಎಲ್ಲಿದೆ ರೀಸನಿಂಗ್ ನೋಡೋಣ. ವಿಲ್ ಸಿ.
My lord, separate memo I have submitted, my lord, in criminal miscellaneous number 94 of 2022. So far as 2 and 3 is concerned. So far as the 4 is concerned, my lord, along with the present petitioner rejected copy, partly allowed. Come to conclusion that, my lord, the complaint is to be looked into. It became clear that deceased died due to rash and negligent driving by himself. Considering that fact, only, my lord, the trial court granted bail to the rest of the accused. In page number 6, my lord, after 4 lines, my lord, the complaint is to be looked into. It becomes clear that deceased died due to rash and negligent driving by himself.
Whether earlier bail petitions of these petitioners were rejected by the High Court?
Illa, sir.
Yeah, criminal petition, special petition 71.
About anticipated bail along with the petitioner was filed before this honorable court earlier. Same was rejected.
So what about now the bail granted in favor of other accused number 2 and 3?
Please.
Whether earlier it was rejected by the High Court or not?
Illa. Our bandila, they have not approached the High Court.
Only directly they went to the trial court.
Trial court and filed. So far as the present petitioner and accused number 4 is concerned, the petition was partly allowed.
Is there any discussion in the trial court by considering the postmortem report in the orders?
Allowed.
No such discussion is found. To convert the petition with regard to the 302. Anticipatory bail was granted. Wherein offense under section 279 304A.
Initially, my lord,
201. Where is the discussion with regard to the nature of injuries as per the PM report?
So far as 2 and 3 is concerned, my lord.
And only comes to the conclusion that they have assisted the shifting of the dead body.
They have assisted the accused number 1.
Accused number 1.
1.
But allegation against accused number 1, what is the allegation?
My lord, when the quarrel was taken place with regard to sharing of water, my lord, at that moment he assaulted with the pipe which was laying on the road, laying on the ground, my lord.
Specific allegation against this petitioner.
How
it will be a parity to grant the bail in favor of this petitioner when other accused persons only assisted in shifting the body?
Very session court itself consider the fact that the complaint government itself speaks.
That is with regard to the shifting of body, allegation is made against those petitioners. But specific allegation against this petitioner is that he inflicted injury with the pipe.
Pipe.
That too on head. As a result, brain and.
Only
that is the allegation.
Confession.
how this petitioner is entitled for bail on the ground of parity?
Well, I am not saying in the same that line, my
Now
lord.
only you made the submission that other accused persons are enlarged than bail. Is it not your duty to make mention before the court that the allegation against them?
Allegations
What is
are
the allegation and what is the allegation against this petitioner? Is it not misleading the court?
ಇಲ್ಲ ಸ್ವಲ್ಪ ಹಂಗೇನಿಲ್ಲ.
ಹಂಗೇನಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಮ attitude ತೋರಿಸ್ತದೆ ಏನು ಅಂತ. The allegation in what is the allegation?
Allegation is quite different. After assault, my lord, they shifted the
Now after court looked into the material only, now you are telling that the allegation against those petitioners are different.
ಇಲ್ಲ ಉದ್ದೇಶ ಹಂಗಿಲ್ಲ ಸ್ವಾಮಿ, ಹಂಗೇನಿಲ್ಲ.
Don't go to the misleading of the court.
ಇಲ್ಲ ಸಾರಿ ಹಂಗಿಲ್ಲ.
ಸಿಗೋ ರಿಲೀಫ್ ಸಿಗೋದಿಲ್ಲ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಿಸ್ಲೀಡ್ ಮಾಡಿದ್ರೆ ಕೋರ್ಟ್ಗೆ.
ಸಾರಿ ಮೈ ಲಾರ್ಡ್, ಆಯ್ತು
ಅಲ್ವಾ?
ಇಲ್ಲ ಸರಿ ಇದೆ ಸ್ವಾಮಿ.
Heard the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution. This is the successive bail petition filed by the petitioner. And earlier bail was filed under 438 of CRPC in criminal petition number 201424 of 2021. And this court having considered the material on record, though case was registered at the earliest point of trial for an offence resolution 279 and 304A of IPC. During the course of investigation, the postmortem report discloses that the death was due to hemorrhage and shock, secondary to blunt injury to vital organs, that is brains and lungs. Hence, this court comes to the conclusion that the matter requires to be interrogated, whether these petitioners are involved in the said case or not, and hence rejected earlier bail petition. Now the petitioner is in custody and he has been arrested, and after his arrest has approached this court by filing petitioners 439 of CRPC. The counsel appearing for the petitioner would mainly contend that this petitioner was arrested on 13/1/2022 and then he is in custody. The counsel also would submit that only based on the co-accused confessional statement, this petitioner is arraigned as accused number 1. And also counsel would submit that other accused number 2, 3 and 4 have already enlarged on bail. And hence this petitioner also entitled for bail. And no need of custodial further investigation in the matter. Yes. Counsel Andre Gurraj Hasilkar.
My lord, in this case, initially case was registered against the district 279-304A, my lord. As per the counsel for the petitioner submitted only on the sharing of the water, this there is a quarrel between this petitioner. Between the motive of this incident is that for the sharing of amount of rupees 58 lakhs fees, which was released by government, state government to release the award, which was land was acquired for. Even after that intention, both are the quarrel between the deceased and petitioner man. This is also one of the reasons for the committing the murder of the deceased man. This is the main old act against this petitioner is main rule of the in this incident, my lord. Only priority of releasing of accused number 2 and 3 is not a ground, my lord. They are only assist, only they have transferred the dead body, my lord. They have shifted the dead body only. Only the only allegation of the other. There is a big allegation against this petitioner is there, my lord. Even as per the postmortem report, it is a support to the prosecution, my lord. The blunt object was asserted to the deceased, my lord.
That's all.
Already at the time of investigation, the object was recovered from the blood stain cross, and object was recovered from this accused, my lord. Of course, investigation is going on, my lord.
So, the counsel appearing to the state would submit that not only dispute between the deceased and this petitioner regarding sharing of water, and it is sharing of the amount of rupees 58 lakhs in respect of property was acquired by the government. and hence committed the murder and pretended that same was an accident. The counsel would submit that the allegation against other accused persons that they shifted and they assisted this petitioner in shifting the body. And the allegation against them is different from this accused, and specific allegation against this petitioner is that he inflicted injury to pipe on the vital part, it is on head. Bottom report also supports the case prosecution. The matter doesn't arise in favor of this petitioner, and this petitioner is the main architect of murder. Having heard the petitioner counsel and also the counsel appearing for the state, and also looking into the factual aspects, I have already pointed out that earlier case was registered on 279 and 304 AFIPC. During the course of investigation, the post-mortem report was received, wherein it discloses that death was due to hemorrhage and shock secondary to blunt injury to vital organs, that is brain and lungs. Hence, 302 of IPC is invoked. The allegation against this petitioner is that he inflicted the injury with the deadly weapon on the vital part, which has resulted the hemorrhage and shock secondary to blunt injury to vital organs, that is brain and lungs. When such allegations are made, the question of parity doesn't arise in favor of this petitioner, and the allegation against them is that only they have assisted this petitioner in shifting of the body, but allegation against this petitioner that he had committed the murder. And when such allegations are made, and also when the allegation of pretending the incident as an accident is done by this petitioner, and the matter is under investigation until not yet filed the charge suit, and hence it is not a fit case to exercise the discretion in favor of the petitioner. In view of the discussion, the petition is rejected.
Yes. Lord, liberty after filing charge sheet.
Liberty ನೀವೇ ಬರ್ಬೋದು, ನಾನೇನು ಕೊಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ you can come and seek bail.
Sorry, my lord, intention was not like that. Sorry.
Intention ಪ್ರಶ್ನೆ ಅಲ್ರಿ.
So benjaiti ಒಳಗ
believe ಕೊಡ್ತೀವೋ ಬಿಡ್ತೀವೋ ಅದು secondary. But you should bring it to the court notice all facts ಅಲ್ವಾ? ಅವ್ರಿಗೆ ಬೇಲ್ ಕೊಟ್ಟವ್ರ ಇವ್ರಿಗೆ ಕೊಡಿ ಅಂತಂದ್ರೆ ಹೆಂಗೆ?
ಔಟ್ ಆಫ್ benjaiti ಒಳಗ
allegation against them ಅನ್ನೋದು ನೋಡ್ಬೇಕು ಅಲ್ವಾ?
Sorry, my extremely.
Be fair before the court and that get an order merits. Dictation ಈಗ ಪಾಸ್ ಓವರ್ ಇದೆಯಾ? ಡಿಕ್ಟೇಷನ್ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಡೋಣ, ಆಮೇಲೆ ಪಾಸ್ ಓವರ್ ಬರೋಣ. ಕೊಡಿ. Serial number 68. Heard the petition of counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution before the trial court is that on 31/7/2010 around 9:55 AM, this petitioner, being the driver of the tipper lorry number K416217, drove the vehicle in a rash and negligent manner Kengeri Upanagara Ring Road in front of Ganesha temple and dashed against the motorcycle. As a result, the pillion rider of the motorcycle had sustained injuries and succumbed to the injuries, and the rider of the motorcycle also sustained simple injuries. Based on the complaint, police have registered the case for the offence measure 279, 337, 304 A of IPC and section 134 A and B read with section 187 of IMA Act, and also 146 read with 196 of IMA Act. The prosecution, in order to prove the case, examined witnesses PW 128 and also got marked document exhibit P1 to 13. The petitioner has not laid any defense evidence. The trial court, after considering both oral and documentary evidence, convicted the petitioner for all the offences invoked against the petitioner. And substantive sentence awarded 6 months for an offence punishment section 304A of IPC, and also impose sentence as well as fine in respect of other offences. Being agreed by the judgment of conviction and sentence, an appeal is filed before the appellate court. In criminal appeal number 733 of 2011, and the appellate court also on reappreciation of both oral and documentary evidence confirmed the judgment of conviction and sentence. Being agreed by the judgment of conviction and sentence present, judgment of conviction and sentence and confirmation, the present revision petition is filed. The main contention of the petitioner counsel before this court is that though the PW3 claims that he is an eyewitness to the accident, and he categorically admitted in the cross examination that he could not identify the petitioner, and only evidence remains before the court is PW1. The counsel would submit that PW1 also in the cross examination and in his evidence not specifically deposed with regard to the identification of this petitioner. The counsel brought to notice of this court that in the cross examination, he admitted that spot of accident is a busy road in the morning hours, and said road has got 40 feet width. The same is also a two-way traffic road. It is illustrated that except that, and also counsel brought to notice of this court that the suggestions are made to that this petitioner is not involved in any accident, and the same was denied. Ashton, I mean, main ground of PW1 or PW3? PW5 the counsel also submit that PW5 also not spoken anything about involvement of this petitioner, except stating that Shivraj Kumar mentioned in exhibit P8 is accused before the court. The counsel also would submit that vehicle number mentioned in the complaint is different from the charge sheet. And these are the contradictions are not considered by both the trial court as well as the appellate court, and hence the judgment of conviction and sentence may be set aside. For counter, the counsel appearing for the state would submit that the lorry owner who has been examined before the court as PW5 categorically stated that in exhibit P5 the name of this petitioner is mentioned. P8, his name is specifically mentioned, and his signature is also marked, wherein he categorically deposes that Shivraj Kumar name is mentioned in exhibit P8 is accused before the court, and hence the very contention of the petitioner counsel that witnesses have not identified this petitioner cannot be accepted, and the very owner given reply in terms of exhibit P8 admitting that this petitioner was the driver of the vehicle which was involved in the accident. The counsel also submits that PW1 in his evidence categorically deposed before the court that the lorry came from rear side and dashed against his bike from the left side of the same, and thereby both of them fell down, and the pillion rider fell down on the left side, and at that time lorry ran over the head of the pillion rider. It is also his evidence that accident was occurred due to negligence on the part of this petitioner. The council also would submit that, except mentioning that the road is busy road, and also road has got 40 feet width. Nothing is elicited in the cross examination of PW1 to discredit the evidence of PW1. The council also would submit that PW3 also categorically deposed before the court that there was an accident at Ring Road near to Ganesha Temple. There was a bike going towards Mysore Road, and lorry bearing number so and so came behind the said motorcycle. The lorry dashed against the motorcycle from the rear side, and thereby rider and pillion rider fell down on the road. This evidence is also clear that lorry driver drove the vehicle in a rash and negligent manner. Regarding identification is concerned, he was treated as hostile and cross-examined by the APP. The suggestion was made that he had seen the driver of the tipper, and the said suggestion was denied. But in the cross-examination of defense counsel, it is illustrated that he was at a distance of 20 feet from the accident. Immediately after hearing the sound, he saw the accident and went to the spot. But he denied the suggestion that lorry not caused the accident, but deceased was not known to him. It is suggested that he never witnessed the accident, but he witnessed it and he denied the suggestion. Then these are the materials are available before the court and trial court, taking into note of particularly the document exhibit P1 and also the sketch and IMA report, rightly comes to the conclusion that an accident was on account of negligence on the part of this petitioner, and hence it doesn't require any interference. Having heard the respective counsel and also on perusal of material, that is oral evidence and documentary evidence available on record, the point that would arise for the consideration of this court are whether the trial court has committed an error in accepting the evidence of PW1 and also the evidence of PW3 and other documentary evidence, and committed an error in convicting the petitioner for the offences. Whether the applicant has committed an error in not properly reappreciating the evidence available on record, and committed an error in confirming the order of conviction and sentence. Whether this court can exercise the powers under 397 Red Writs of 401, exercising the revisional jurisdiction. Point number 1 to 3. Having heard the respective counsel and also the material on record, it is the case of the prosecution that this petitioner drove the vehicle in a rash and negligent manner and dashed against the motorcycle which was proceeding on the left side of the road. As a result, the PW1, who is the rider of the motorcycle, has sustained injuries, and the pillion rider succumbed to the injuries. No dispute with regard to the accident is concerned, and no dispute with regard to the death of the pillion rider is concerned. The only dispute by this petitioner is that this petitioner was not driving the vehicle, and also he did not cause any accident as deposed by the prosecution witnesses. The prosecution mainly relies upon the evidence of PW1. The PW1 is the complainant, and also he was an injured witness. In order to prove the fact that he was sustained injury in the accident, prosecution mainly relies upon the document of exhibit P5. And hence it is clear that he had sustained the injury in the accident. And whether the evidence of PW1 inspires the confidence of the court, it comes to a conclusion that this petitioner had caused the accident, this court has to look into the material. Perusal of the evidence of PW1. Dashed against the cycle which is proceeding on the left side of the road. In fact, both of them have fell down and sustained injuries. I have already pointed out that no dispute with regard to this. Petitioner, that is the complainant who has been examined as PW1 categorically deposed the manner in which an accident was taken place. It is also important to note that in Exhibit P8, the owner of the vehicle has given reply in terms of Exhibit P8, wherein he has specifically mentioned in his reply that when the accident was taken, the petitioner was the driver of the said vehicle. The same has been questioned while when he was examined as PW5. The PW5 also before the court categorically deposed that document shown to him bearing his signature, that is Exhibit P7 and 8. P7 is the letter given to him and Exhibit P8 is the reply given by him. He also categorically admits that in Exhibit P8, Suraj Kumar name is mentioned in Exhibit P8, who is the accused before the court. The owner of the vehicle identifies that he gave the details in terms of Exhibit P8, and in terms of Exhibit P8, this petitioner was the driver at the time of the accident. No doubt in the evidence of PW3 though speaks with regard to the accident is concerned and how an accident was taken place, but not identified the petitioner. And hence cross-examination was made by the prosecution. But in the cross-examination, he categorically says that he was at a distance of 20 feet from the accident spot. He went and saw the accident, and suggestion was made that the lorry has not caused the accident, and the same was denied. And also he denied the suggestion that he did not witness the accident. Hence it is clear that he witnessed the accident but not specifically mentioned the name of this petitioner. The PW1 also in this evidence categorically deposes that the lorry driver drove the vehicle in a rash and negligent manner, and he was proceeding on the left side of the road at a distance of 4 feet from the edge of the road. And the same is also illustrated from the mouth of the PW1 in the cross-examination. And when such evidence is available before the court, and the evidence of PW1, 3, and 5 corroborates each other with regard to the accident is concerned. The sketch Exhibit P12 also discloses that both the vehicles are moving in the same direction. And lorry came from behind and dashed against the motorcycle which was on the left side of the road. When such material available before the court and the same is appreciated by both the trial court and also the appellate court, the question of invoking divisional jurisdiction doesn't arise. The trial court also, while appreciating the material and record, taken note of the evidence of particularly the PW1, PW3, PW5, and observed in paragraph number 15 that though PW3 turned hostile in respect to the identification of the accused as driver, and taken note of the evidence of PW1 and PW3 with regard to the accident is concerned. And also in paragraph number 16, also taken note of the combined reading of the evidence of PW1, PW5, PW3 and 8, and also taken note of the IME report as well as sketch, and in detail discussed from paragraph number 14 to 18, 14 to 12, 14 to 17 in coming to the conclusion. The appellate court also, in the judgment on reassessing both oral and documentary evidence, taken note of the exhibit P7 copy of notice and also the reply given by the owner of the vehicle, and the same is discussed in exhibit P16 regarding identity of the petitioner is concerned, and also taken note of the evidence of other witnesses, particularly relied upon the evidence of the PW1, PW3 and PW5, and considered exhibit P13 major regarding place of accident is concerned, and having considered the exhibit P7, P8 and also exhibit P13 documentary evidence discussed the same in paragraph number 17. And also with regard to the discrepancy in the vehicle is concerned, also discussed that neither the accused nor the PW5 have taken any legal recourse either against the complainant or against the police with regard to the mentioning of the vehicle in the complaint, as well as arraying the accused in the case, and also mentioning of the vehicle number which was involved in the accident, and the discrepancy with regard to the mentioning of vehicle is also discussed by the appellate court. Having considered the trial court order as well as the appellate court order, and mainly relies upon the evidence of PW1, who is an injured witness who had sustained injuries in the accident, and also in order to prove the fact that he had sustained the injuries, wound certificate is also marked, and apart from that, sketch exhibit P12 also taken note of regarding the vehicles are moving in the same direction, and it is the evidence of PW1 also that when he was proceeding along with the deceased pillion rider on the left side of the road, the lorry dashed against his vehicle, and due to the impact, both of them have fell down, and the pillion rider succumbed to the injury since lorry ran over on his head. When such material available before the court, and also the same is accepted by the trial court and appellate court also on reappreciation in criminal appeal in paragraph number 21 discussed in detail the evidence of PW1, and also taken note of, he categorically deposed that at a distance of 5 feet from the left side edge of the road, he was driving the motorcycle, and also taken note of exhibit P2 as well as exhibit P12 sketch. And in paragraph number 22 also on reappreciation of the evidence comes to the conclusion that on account of negligence on the part of the petitioner only, an accident was occurred. When such definite finding is given by the trial court as well as the appellate court on reappreciation, I do not find any error committed by the both the courts in appreciation of evidence, and hence it is not a fit case to exercise the discretion. Invoking the provisions under section 397, read section 401 of CRPC to interfere with the findings of both the courts. This court only exercise interference with regard to the finding is concerned if the material is not considered by both the courts, and when there is a perverse order and not looked into the cogent evidence available on record, under the circumstances court can invoke revisional jurisdiction, and the same is not warranted in the present case on hand. And hence I answered all the point 1 to 3 as negative. Now coming to the aspect of the offences which have been invoked against the petitioner, including section 279, and trial court ought not to have invoked section 279 when the ingredients of the offence under section 279 are merges with the serious offence of 304A. And hence it requires interference of this court and to set aside the order passed by the trial court for the offence pursuant to 279 of IPC, and the appellate court also not considered this fact. Now coming to the sentence is concerned with regard to section 304A of really IPC is concerned. ಏನ್ ಮಾಡದ್ರಿ ಫೈನ್ ಮಾಡಂಗಿಲ್ಲ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವ್ರು ಬರ್ದ್ಬಿಟ್ಟಾರ. ಡಿಪೆಂಡ್ಸ್ ಅಂದ್ರೆ ಹಂಗೆ ಬರ್ದ್ಬಿಟ್ಟಾರ. ಹೆಂಗ್ ಬರ್ದವ್ರ ಅಂದ್ರೆ ಓದಿದ್ರೆ ಓದ್ತೀನಿ ಕೊಡಿ ಮೇಡಮ್ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ಯಾರಾ 14 ನಾವೆಲ್ಲ ಮಾಡ್ತಾ ಇದ್ವಿ ಮೊದ್ಲು. ಇಟ್ ಈಸ್ ಅನ್ ಆಕ್ಸಿಡೆಂಟ್, ನೋ ಪರ್ಪಸ್ ವಿಲ್ ಬಿ ಸರ್ವ್ಡ್ ಇನ್ ಸೆಂಡಿಂಗ್ ಹಿಮ್ ಟು ಜೈಲ್ ಆಫ್ಟರ್ ಲಾಂಗ್ ಇಯರ್ಸ್ ಅಂತ ನಾನೇ ಸುಮಾರು ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ದಿದ್ದೀನಿ. ಬಟ್ ಏನ್ ಮಾಡೋದು, ಈ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವ್ರು ಹೇಳ್ತಾರೆ ಹಂಗ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ. ಇಟ್ ಶಾಕ್ಸ್ ದಿ ಕನ್ಸೈನ್ಸ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ ಅಂತ ಬರ್ದವ್ರು. State of Punjab, para number 24. Needless to say, principle of sentencing recognizes the corrective measures, but there are occasions when the deterrence is an imperative necessity depending upon the facts of the case. In our opinion, it is a quick case where we are constrained to say that High Court has been swayed away by the passion of mercy in applying the principle that payment of compensation is a factor for reduction of sentence to 24 days. ಅದರ ಆ ಕೇಸಲ್ಲಿ 24 ದಿವಸಕ್ಕೆ ಮಾಡಿಬಿಟ್ಟು ಮಾಫಿ ಮಾಡಿದ್ರು, ಅದಕ್ಕೆ ಬೈತಾ ಇದಾರೆ ನೋಡಿ. ಫ್ಯಾಕ್ಟ್ಸ್ ಆಫ್ ದಿ ಕೇಸ್ ಎಲ್ಲ ಒಂದ. ಇಟ್ ಈಸ್ ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ಇನ್ ದಿ ರಿಯಲ್ಮ್ ಆಫ್ ಮಿಸ್ಪ್ಲೇಸ್ಡ್ ಸಿಂಪತಿ. It is in a way mockery of justice, because justice is the crowning glory, the sovereign mistress and queen of virtue. As Cicero had said, such a crime blights not only the lives of the victims, but of many others around them. It ultimately shatters the faith of the public in judicial system. In our view, the sentence of 1 year is 1 year as imposed by the trial court magistrate, which has been affirmed by the appellate court, should be reduced to 6 months ಅಂತ ಮಾಡೋರು. 1 ವರ್ಷ ಇದ್ದಿದ್ದು 6 ತಿಂಗಳು ಮಾಡಿದ್ದಾರೆ. ಇಂದ್ರಲ್ಲೂ ಇರೋದೇ 6 ತಿಂಗಳು. ಅಲ್ಲೂ ನಾನೇನು ಡಿಸ್ಕ್ರಿಷನ್ ತೋರ್ಸಕ್ ಏನಿಲ್ಲ, ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ, ಮಾಡಕ್ ಬರಲ್ಲ ಅಂದೆ, ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ಮೊನ್ನೆ CH ಹನುಮಂತರಾಯ ಅದ್ರ ಮೇಲೆ ಒಂದು 3-4 ಆರ್ಗ್ಯುಮೆಂಟ್ ಸಿಟೇಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಲೈಫ್ ಆಫ್ ಎ ಪರ್ಸನ್ ಅಲ್ವಾ. ಮತ್ತೆ ಯಾವಾಗ ಬರ್ತದೆ ಪ್ರೊಬೇಷನ್ ಆಫ್ ಅಫೆಂಡರ್ಸ್ ಆಕ್ಟ್. ಏಜ್ ಎಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತಲೇ ಬರ್ದವ್ರು. ಆಯ್ತು, ನೀವ್ ಹೇಳಿ ನಾನು ಬರಿತೀನಿ. ಆಯ್ತು. The counsel regarding sentence is concerned, the petitioner counsel asserts that the petitioner was aged about 23 years at the time of the accident, and now almost 12 years is elapsed. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಯಾವ್ದು ಇಲ್ಲ, ನಾವು ನೋಡಿದ್ದೀನಿ, ನಾನೇ ಮಾಡ್ತಾ ಇದ್ದೆ, ಸುಮಾರು ಮಾಡಿದ್ದೀನಿ ನಾನು. ಅಲ್ಲಿ ಮೋಸ್ಟ್ಲಿ ಧಾರವಾಡ ಬೆಂಚು ಮತ್ತೆ ಇವನ್ ಮನೆಯಲ್ಲೂ ನಾನು ಇದ್ರ ಬೆಂಚ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ. ಎಲ್ಲಿ ದಿಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ವಾಸ್ ನಾಟ್ ಬ್ರಾಟ್ ಟು ನೋಟಿಸ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್. 2015 ಆದ್ಮೇಲೆ ಯಾರು ಕೊಟ್ಟಿಲ್ಲ, ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಇಲ್ಲ. ಆ ರೀತಿ ಇದೆ. ಫೈನ್ ಮರ್ಸಿ ತೋರ್ಸ್ಬಿಟ್ಟು ಮರ್ಸಿ ಮಾಡ್ತಾ ಇದೀರಿ ಅಂತ ಕೋರ್ಟ್ನವ್ರು ಹೈಕೋರ್ಟ್ನವ್ರಿಗೆ ಬೈದವ್ರು. 4 ಆಯ್ತ್ರಿ, ಅವೆಲ್ಲ ಇದೆ. 4 ಅಲ್ಲ, ನಾನೇ 2020 ಮಾಡಿದ್ದೀನಿ. ನಾನು ಎಲ್ಲ 1 ಲಕ್ಷ 2 ಲಕ್ಷ ಕಾಂಪನ್ಸೇಷನ್ ವಿಕ್ಟಿಮ್ ಫ್ಯಾಮಿಲಿಗೆ ನೋ ಪರ್ಪಸ್ ವುಡ್ ಬಿ ಸರ್ವ್ಡ್ ಆಫ್ಟರ್ ಲಾಂಗ್ ಆಫ್ 1.5 ಡಿಕೇಡ್ಸ್ ಅಂತೆಲ್ಲ ಸುಮಾರು ಮಾಡಿದ್ದೀನಿ. ಬಟ್ ನಾವು ವೆನ್ ಇಟ್ ಕಮ್ಸ್ ಟು ದ ನಾಲೆಡ್ಜ್ ಆಫ್ ಮೈ ಕೋರ್ಟ್, other day the public prosecutor has relied upon this judgment. When the judgment is brought to this court notice, I should not do that. It is against the propriety. ಇಲ್ರಿ, ನಾನು ಹೇಳಿದ್ನಲ್ಲ, ಇದ್ರೆ ನಾನೇ ಮಾಡ್ತಾ ಇದ್ದೆ. ಇಲ್ಲ, ಯಾವ್ದು ಇಲ್ಲ, ಎಲ್ಲ ಇಲ್ಲ. ಅದನ್ನ ನೋಡಾಗಿದೆ, ನಾನು ನೋಡ, ಯಾವ್ದು ಇಲ್ಲ. ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ಯಾವ್ದು ಬಂದಿಲ್ಲ. ಅದಕ್ಕೆ ಅವ್ರು ನೋಡಿ, ಆ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 24 ಬರ್ದಿರೋದು ನೋಡಿದ್ರೆ ಯಾರು ಬರೆಯಲ್ಲ. ಅದಕ್ಕೆ ಆಗಿತ್ತು, ನಾನೇ ಸುಮಾರು ರಿಲೈ ಮಾಡಿ ಬರ್ದಿದ್ದೀನಿ. ಅರ್ಲಿಯರ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಜಸ್ಟಿಸ್ ಜಗನ್ನಾಥನ್ ಸಾಹೇಬ್ರು ಮಾಡಿದ್ದೀನಿ, ಉಲ್ವಾಡಿ ರಮೇಶ್ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ, ಮತ್ತೆ ಸುಮಾರು ಮಾಡಿದ್ದಾರೆ. ನಾನೇ ಒಂದು ಆಲ್ಮೋಸ್ಟ್ 15-20 ಧಾರವಾಡದಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ, ಗುಲ್ಬರ್ಗಾದಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ. ಬಟ್ ನಾವು ಈ ಸೆಂಟೆನ್ಸ್ ಪಾರ್ಟಿ ಏನ್ ಮಾಡೋದು, ಬರ್ದಿರ್ತೀನಿ, ಏನು ತಗೊಬನ್ನಿ, ಆಮೇಲೆ ನೋಡಿ ಏನಿದ್ರು ಕರೆಕ್ಷನ್ ಮಾಡಿ. ಏನಾಯ್ತು ಮೇಡಮ್? No, and already 12 years has been elapsed, and it is an accident, and no purpose would be served in sending him to jail, and hence monetary compensation can be given to the family of the victim. The said submission cannot be accepted in view of the judgment of the apex court reported in 2015 within bracket 5 Supreme Court cases 182, wherein in paragraph number 24 the apex court held that it is nothing but a way of mockery of justice, and a fine cannot be a punishment. And the apex court also in detail discussing the same, reduce the sentence from 1 year to 6 months. In the case on hand, the very punishment given by the trial court is 6 months for an offence pursuant to 304A IPC. And when such being the facts, it is not a fit case to even further reduce the sentence, and the sentence of 6 months is a minimum sentence for the offence pursuant to 304A IPC. And hence the contention of the petitioner counsel cannot be accepted. In the next para, in respect of other offences is concerned, fine ಏನಾದ್ರು ಕಟ್ಟಿದ್ದೀರಾ ಅದರಲ್ಲಿ 279 ಅಲ್ಲಿ ಡೆಡಸೈಡ್ ಆಯ್ತು ತಗೊಂಡು meaning of the petition discussion made up by pass the following order. Revision petition is allowed in part. The judgment of conviction and sentence for the offence pursuant to 279 is hereby set aside. If any fine amount is deposited before the trial court for the said offence is concerned, it is ordered to refund the same on proper identification. Next, regarding sentence and fine for the other offences is concerned, the same is unaltered. Kodi haki being spoken word, then word. Nanageniಲ್ಲ. I also am very with regard to the accident is concerned. It is an accident, not intentional act. ಯಾರು ಏನು ಆಕ್ಸಿಡೆಂಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಮಾಡೋದಿಲ್ಲ, ಏನೋ ಆಗಿರ್ತದೆ. ಬಟ್ ಇಫ್ ಮಾನಿಟರಿ ಕೊಡ್ಬೋದು, ನಾನೇ ಕೊಟ್ಟಿದ್ದೀನಿ ಹೇಳಿದ್ನಲ್ಲ, ಒಂದು 10-15 ಕೇಸಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ, ಮೋಸ್ಟ್ಲಿ ಜಾಸ್ತಿನೇ ಕೊಟ್ಟಿದ್ದೀನಿ. But having the knowledge of this judgment, but I should not pass such an order. It amounts to a propriety of the order. Passed over third. Three ಏನಕ್ಕೆ ಮೇಡಮ್? SPP ಏನ್ ಮೇಡಮ್ ಇದು? ಏನಾಯ್ತು ಮೇಡಮ್? ಎರಡು ಅಕ್ವಿಟಲ್ ಆದಾಗ ನಾನು ಕೇಳ್ತಾರೆ, ಎರಡು ಅಕ್ವಿಟಲ್ ಆದಾಗ ಅಪೀಲೇ ಬರುತ್ತೆ ನೋಡಿ ಮೇಡಮ್. ಕಾಮನ್ ಇದನ್ನು ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದ್ದಾಗ ಅಪೀಲೇ ಬರುತ್ತೆ ಅಂತ. ಅಪೀಲ್ ಅಗೇನೆಸ್ಟ್ ಅಕ್ವಿಟಲ್ ಅಲ್ವಾ, ಅದರಿಂದ ಮೋಸ್ಟ್ಲಿ ನಾಟ್ RP ಅಪೀಲ್. ನೋಡಿ ಹೇಳಿ ಯಾವಾಗ HCGP seeks time to make submission regarding maintainability of the petition. Now list this matter on. ಎಷ್ಟು ದಿವಸ ಬೇಕು ಮೇಡಮ್? ಎಷ್ಟು ದಿವಸ ಬೇಕು ವೆರಿಫೈ ಮಾಡಿ ಹೇಳಕ್ಕೆ? 1st of April ಆಯ್ತು. ಏನದು? ಮೆಮೋ ಫಾರ್ ಕನ್ವರ್ಷನ್. ಏನ್ ಕನ್ವರ್ಷನ್ ಕೇಳಿದಾರೆ? ಏನ್ ಮಾಡ್ಬೇಕಂತ ನೋಡಿ. ಕಾಸ್ಟ್ ಹಾಕಿಲ್ವಾ? 7ನೇ ಸರಿ ಲಿಸ್ಟ್ ಆಗಿರೋದು ಇಲ್ಲಿ ಯಾರು ಹಾಕಿ ಅಲ್ವಾ? ಅದ್ ಬಿಟ್ಬಿಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ. ಇಲ್ಲೇನು ಮೆಮೋ ಕೇಳಿದಾರ ಏನದು? ಅಲ್ಲ ಏನ್ ಕೇಳಿದಾರೆ ಮೇಡಮ್? ಮೆಮೋ ಹಾಕಿದಾರ ಅವರು? ಮೆಮೋ ಹಾಕಿದೇನಿದು? ಇದೇ ಮೆಮೋನಲ್ಲ ಮೇಡಮ್, ಇದು ಗ್ರೌಂಡ್ಸ್ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಪೀಲ್ ಗ್ರೌಂಡ್ಸ್. ಇದು ಇಲ್ಲಿ ಮೆಮೋ ಇದೆ ನೋಡಿ, ಇಲ್ಲಿ ಮೆಮೋ ಇದೆ, ಇದು ಮೆಮೋ. So petitioner counsel has filed memo seeking permission to permit the appellant herein to convert criminal revision petition into criminal appeal to avoid technicalities. In view of the memo filed by the petitioner counsel permitted to convert the same as appeal. For the statistical purpose, criminal RP is disposed of. 24. ಲಕ್ಷ್ಮೀಕಾಂತ್ ಏನ್ರಿ ಇದು? ಅಕ್ಯೂಸ್ ಈಸ್ ಇನ್ JC. ಅಫೆನ್ಸ್ ಏನು? 138. ಹೇಳಿ. ಆರ್ಡರ್ ಯಾವಾಗ ಆಗಿರೋದು ಇದು ಆರ್ಡರ್? 19 ಜನವರಿಯಲ್ಲಿ. ಜನವರಿ 19. ಹಾ ಹೇಳಿ. ಹಾ ಯಾರು ಅಪಲೆಂಟ್? ಹಾ ಕೋವಿಡ್ 1 ವರ್ಷದ 2 ತಿಂಗಳ ಮೇಲೆ ಹೌದಾ? ಹಾ ಇನ್ ಬಿಟ್ವೀನ್ ದಿ ಟೈಮ್ ಏನಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆಯಾ? ಇಟ್ ವಾಸ್ ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ಗುಡ್ ಹೆಲ್ತ್ ಅಂತ ಈಗೇನ ಹೇಳಿದ್ರಲ್ಲ, ಅದನ್ನ ಸಪೋರ್ಟಿಂಗ್. ಜನವರಿ 2020 ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿದ್ದ ಅವಾಗ 19 ಇಂದ 21 ಮಾರ್ಚ್ ವರೆಗೂ ಏನಾದ್ರು ದಾಖಲೆ ಇದೆಯಾ? ಈಗ ಜೈಲಿಗೆ ಹೋದ ಅಂತ ಕೋರ್ಟಿಗೆ ಬಂದವನ ಅಷ್ಟೇ, ಹೌದಾ? ಹೇಳಿ. ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಆಗಿದ್ ಗೊತ್ತಿದ್ದು ಏನ್ ಗೊತ್ತಿಲ್ಲ ಹೇಳಿದಿರಾ? ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಅಪೀಲ್ ಡಿಸ್ಪೋಸ್ ಆಗಿದ್ದ ಹೇಳಿಲ್ಲ ಅಂತ ಏನಾರು ಹೇಳಿದಿರಾ ನೀವು? ಎಲ್ಲಿದೆ ಹೇಳಿ, ಯಾರ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡಿದಿರಿ? ಲಾಯರ್ ಮೇಲ? ಏನಂತ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ ಅಂತ. Is it a ground? What is his duty? Is it not his duty to go and inquire with the advocate when he was convicted and sentenced before the trial court to verify and 1056 days delay ಇದೆ. ಹೇಳಿ, ನೋ ಗ್ರೌಂಡ್ಸ್. ಒಂದು 200-300 ದಿವಸ ಆದ್ರೆ ಕೊಡ್ಬೋದು, ಇಲ್ಲ ಕಂಡೋನ್ ಮಾಡ್ಬೋದಿತ್ತು. ಮೆರಿಟ್ ಎಲ್ಲ ರಿವಿಷನ್ ಆಮೇಲೆ ನೋಡೋಣ. ಫಸ್ಟ್ ಯು ಮೇಕ್ ಔಟ್ ಎ ಕೇಸ್ ಫಾರ್ ಇಶ್ಯೂಯನ್ಸ್ ಆಫ್ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ನೌ ಹಿ ಇಸ್ ಇನ್ ಕಸ್ಟಡಿ, ದಟ್ಸ್ ವೈ ಯು ಓನ್ಲಿ ಅಪ್ರೋಚ್ ದಿ ಕೋರ್ಟ್. ರಿಸೀವ್ ದಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಫ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಸೋ ಅಂಡ್ ಸೋ ಆನ್ 10/3 ರಿಪೋರ್ಟ್ ದಿಸ್. ನೋಡಿ 2019 ರಿಂದ 22 ವರೆಗೂ ಹೋಗಿ ನೋಡ್ಲೇ ಇಲ್ಲ ಲಾಯರ್ನ. ಮತ್ತೆ ಕೋವಿಡ್ ಕಥೆ ಹೇಳ್ತೀರಿ ನೀವು. ನೋಡಿ ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಹೋಗಿ, ಪ್ರತಾಪ್ ಕುಮಾರ್ MS, ನೀವು ಅಡ್ವೊಕೇಟ್ ಹೇಳಿರೋದ? ನಿಮ್ದೇನ ಇದು? ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ಸ್. ನಿಮ್ಗೇನ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಟ್ಟು? Apart from that, during the year 2019, the petitioner has suffered many ailments ಅಂತ ಹೇಳಿದಿರಿ. ಅದಕ್ಕೆ ಸಪೋರ್ಟಿಂಗ್ ಏನಿದೆ ಕೊಟ್ಬಿಡಿ. ಕೊಟ್ರೆ ಈಗಲೇ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿ ಕೊಡ್ತೀರಾ? ದಾಖಲೆ ಏನಾರು ಹಾಕಿದೀರಾ? ಲಾಯರ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ನೀವ್ ಎಲ್ಲಿ ಹೇಳಿದಿರಿ? ಏನಂತ? ಎಲ್ಲಿದೆ? ಆ ತರ ಇಲ್ವಲ್ಲ, ಎಲ್ಲಿದೆ ನೋಡಿ. ನಾಟ್ ಇಂಟಿಮೇಟೆಡ್ ರಿಗಾರ್ಡಿಂಗ್ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್. ಯು ಆರ್ ಮೇಕಿಂಗ್ ಎನ್ ಅಲಿಗೇಷನ್ ಅಗೇನ್ಸ್ಟ್ ಯುವರ್ ಓನ್ ಕೊಲೀಗ್. ಆಯ್ತ್ರಿ, ಅವ್ನ್ ಸ್ವಿಚ್ ಆಫ್ ಆಯ್ತು. ಇವನೇನ್ ಮಾಡ್ದ? ಇವ್ನ್ ಹೋಗಿ ವಿಚಾರಿಸ್ಬಿಡಲ್ವಾ ಲಾಯರ್ನ ಹತ್ರ? 4 ವರ್ಷ ಸುಮ್ಮನೆ ಕೂತ್ಕೊಂಡ್ರೆ? ಲಾಯರ್ ಫೋನ್ ಸ್ವಿಚ್ ಆಫ್ ಆಗಿದೆ ಅಂತ ಅಷ್ಟೇ. ಅದೆಲ್ಲ ಬೇಡ, ಲಾಯರ್ ಬಿಟ್ಬಿಡೋಣ. ಈಗ ಏನಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆಯಾ 2019 ಜನವರಿಯಿಂದ? he was not keeping good health ಅನ್ನೋದಕ್ಕೆ ಏನಾರು ಅಡ್ಮಿಷನ್, ಏನಾರು ಅಡ್ಮಿಟ್ ಆಗಿದ್ದ ಆಸ್ಪತ್ರೆಗೆ ಏನಾರು ಇದೆಯಾ? ಔಟ್ ಪೇಷಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅವ್ನು ಡಾಕ್ಟರ್ ತಗೊಂಡೋಗಿ ಬಿಸಾಕಿರು ಮಾಡ್ಕೊಡ್ತಾನ ಅವ್ನು. ಅವಲ್ಲ ಏನಾರು ಇದೆಯಾ? ಡಾಕ್ಟರ್ಗಳು ಆ ಲೆವೆಲ್ಗೆ ಇಳ್ಬಿಟ್ಟವ್ರಿಗೆ ಏನ್ ಮಾಡೋದು? ಕೊಡಿ, ಏನಾರು ಇದ್ರೆ ಕೊಡಿ, ಇನ್ನೂ ಟೈಮ್ ಕೊಡ್ತೀನಿ. ಅಡ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ಸ್ ಇದ್ರೆ ಕೊಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸಲ್ ರೈಟ್ ನೌ. ತಗೊಳ್ಳಿ. Heard the petitioner counsel on IA 1/22 for condonation of delay of 1056 days in filing this criminal revision petition. The petitioner, in support of the application, filed a memo of facts of the counsel stating that the petitioner is in judicial custody and the order of dismissal of the appeal was not brought to the notice of the petitioner. And also it is stated that petitioner has suffered many ailments, but adu yavadu anta helodilla, male ailments, and he has taken the treatment in the hospital as an outpatient. It is also contended that due to COVID-19, there was a national lockdown, and Supreme Court also in SLP number 1/21 condoned the delay for filing the fresh suits within the set periods, and hence delay may be condoned. having heard the petitioner counsel and also on perusal of material on record, the judgment was passed on 1st day of January 2019 and appeal was dismissed. From January 2019 to even commencement of COVID-19, for a period of 13 months, no document is placed before the court, though it is stated that he was suffering from many ailments, and the same is not supported by any documents. And only counsel says that he was an outpatient, and hence the contention that he was an outpatient cannot be accepted, and no document is placed before the court that he was having many ailments during the said period, and no document of he was admitted in hospital is produced. Only it is the statement that he has taken treatment as outpatient, and when such thing, the facts of the case, no proper explanation is given for the period from 2019 January to March 2020 till the commencement of COVID-19. It is also important to note that the COVID-19 2019 has affected throughout the country as well as the world, and only lockdown was made for a shorter period, and thereafter with stringent conditions, courts are also functioned, and no doubt Supreme Court also extended the period of limitation. But in the case on hand, it has to be noted that this petitioner was convicted for the offence punishment of section 138 of Negotiable Instruments Act, and thereafter he has filed an appeal, and this petitioner was not diligent in verifying the status of the appeal, but now makes the blame through the counsel on record against the other colleague of advocate, and such allegation also not in the right perspective, and hence the very reasoning given by the petitioner also cannot be accepted. It is also important to note that when the petitioner kept quiet for a longer period of 4 years, when he was arrested on ಯಾವಾಗಲೇ arrested, ಯಾವಾಗ ಅರೆಸ್ಟ್ ಆಗಿದ್ದವನು? Arrested and produced before the court. Now he is undergoing the sentence. The present revision petition is filed after that, and hence it is not a fit case to condone the delay of 1056 days in filing this revision petition, and also not make out any ground to issue the notice against the respondent. In view of the discussion, and hence IA number 1 of 22 is dismissed. Consequently, the revision petition also dismissed. Court ಹೊರಗೆ ಬರಕ್ಕೆ ಹೇಳಿ ಅಷ್ಟೇ. Shashivardhan CZ ಬರ್ಲಿಲ್ಲ. This matter is called twice, no representation, and hence list this matter on 8th April. Earlier ಕೂಡ ಬಂದಿಲ್ವಾ? ಹಿಂಗೆ ಬರ್ಕೊಡಿ. In the previous occasion, submission was made that they are going to file joint memo, but no representation today. However, in the ends of justice, one more opportunity is given. List this matter on 8th of April. 39. SP Ramesha Matthew. Good. Last time ಏನಾಗಿದೆ ನೋಡಿ ಮೇಡಮ್. ಆಯ್ತು, ಇವತ್ತೇನು ಇಂಟಿಮೇಟ್ ಮಾಡಿದಿರಾ? ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿದಿರಾ? ಏನಾಯ್ತು? ಆಯ್ತು, ಯಾವತ್ ಬೇಕು ಹೇಳಿ. 4 weeks ಎಲ್ಲ ಕೊಡಕ್ಕಲ್ಲ. ಅದೆಲ್ಲ ಹೆಂಗೆ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ 4 weeks ಅಲ್ಲಿ ಟ್ರಯಲ್ ಇದು ಬರ್ತದೆ, ಕೋರ್ಟ್ ಕಮೆಂಟ್ಸ್ ಆಗ್ತದೆ. ಈ ತರದ್ದೆಲ್ಲ ಸಬ್ಮಿಷನ್ ಬಿಟ್ಕೊಡ್ಬೇಕು ಕೌನ್ಸಿಲ್. ಹೇಳಿ ಮತ್ತೆ ಈ ಅತಿ ಬುದ್ಧಿವಂತಿಕೆ ಬೇಡ. ಹೇಳಿ 2 ವಾರ ಬೇಕಾ ಕೊಡ್ತೀನಿ, ಬಟ್ ನಾಟ್ ಆಗಲ್ಲ ಅಂದ್ರೆ ಬೇಡ. ಈಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಹಿಯರ್ ಮಾಡೋಣ, ಆಯ್ತಾ? ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟ್ರ್ ಹೇಳಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿ ನೋಡೋಣ ಏನಿದೆ ನೋಡೋಣ. ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದೀರಾ? ಮತ್ತೆ ಕ್ರಾಸ್ ಮಾಡಿದೀರಾ? ಹೋಗ್ಲಿ ಮಾಡಿದೀರಾ? ಏನ್ ನಿಮ್ ಡಿಫೆನ್ಸ್ ಏನು? $5,50,000. 5,50,000. ಮತ್ತೆ ನೋ ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್. ಆಗುತ್ತೆ ಮಾಡ್ಬೇಕು ನೀವು. ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಆಗ್ಲೇ ಇದು 2013 ಕೇಸ್. ಈಗ ಇನ್ ಬಂದ್ 4 ತಿಂಗಳು ಕೊಡಿ, 4 ವಾರ ಕೊಡಿ ಅಂದ್ರೆ ಮತ್ತೆ 2013 CC ಇದು. ಒಂದು ಡಿಕೇಡ್ ಆಗಿದೆ ಆಗ್ಲೇ. ಒಂದು ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸಿಗೆ ಒಬ್ಬ ಕ್ಲೈಂಟ್ ಬರ್ತಾನೆ ಕೋರ್ಟ್ಗೆ. 10 ವರ್ಷ ನೀವು ಇಟ್ಕೊಂಡು ಕುತ್ಕೊಳ್ಳಿ ಫೈಲ್. ಇಲ್ಲಿ ಬಂದ್ ಮತ್ 4 ವಾರ ಕೇಳಿ. ನೀವೇ ಕ್ಲೈಂಟ್ ಆದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಿ? ನೀವು ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸ್ ಹೋದ್ರೆ ಒಂದು ಕೋರ್ಟಿಗೆ 10 ವರ್ಷ ಆದ್ರೆ ನಿಮ್ಗೆ ಏನ್ ಬರುತ್ತೆ ಕೋರ್ಟ್ ಬಗ್ಗೆ ಇಂಪ್ರೆಷನ್? ಏನ್ ಬರ್ತ್ರಿ? ಮತ್ತೆ ಸಜೆಸ್ಟ್ ಮಾಡೋದು ಯಾವಾಗ? 10 ವರ್ಷದ ಮೇಲೆ. You stand in the place of a client who seeks justice before the court. What would be the impression about the court? ಕೋರ್ಟ್ ನ ದಾಳ ಮಾಡ್ಕೊಂಡು ಹೆರಾಸ್ಮೆಂಟ್ ಮಾಡೋದು ಇಲ್ಲಿವರೆಗೆ ಅಷ್ಟೇನೆ. ದಟ್ಸ್ ಆಲ್. ಈಗ ನಾವು ಯು ಆರ್ ಸೀಕಿಂಗ್ ಫಾರ್ 4 weeks. ಆಮೇಲೆ 4 weeks ಆಟೋಮೆಟಿಕ್ ಆಗಿ ವೆಕೇಶನ್ ಬರ್ತದೆ. This type of conduct should not be encouraged. ಅಲ್ವಾ? ಮತ್ತೆ ಏನ್ರಿ ನೀವು? Petitioner counsel again seeks time on the ground that he is going to settle the matter and report the settlement, and hence 2 weeks time granted. List this matter on ಯಾವಾಗ ಮೇಡಮ್? 2 weeks ಅಂದ್ರೆ ಆಯ್ತು 11/4. 58 CN ರಾಜು ಬಂದ್ರೇನ್ರಿ ರಾಜು? ಏನಾಯ್ತು ಆಂಟಿಸಿಡೆಂಟ್ಸ್? ಏನ್ ಅಫೆನ್ಸ್ ಏನು? 392 ನಾ? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 6 months ಕೊಟ್ಟಿದ್ದಾರೆ. 65 days ಆಲ್ರೆಡಿ. ಮತ್ತೆ ಇದ್ರಲ್ಲಿ ಇನ್ನೇನ್ ಮತ್ತೆ ಕೊಟ್ರದೇ 6 ತಿಂಗಳಲ್ವಾ? 20 years ಆದ್ರೆ ಏನ್ ಮಾಡೋದು? 20 yearsಗೆ ಶುರು ಮಾಡೋಣಲ್ಲ. ಏನ್ರಿ? ಏನಾಯ್ತು ಮೇಡಮ್? ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್? ನೋ ಅದರ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ನೋಡಿ ಕೊಟ್ರದೇ 6 ತಿಂಗಳು, ಅದರಲ್ಲೂ ಮತ್ತೆ ಚೌಕಾಸಿ. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution before the trial court that on 19/6/2009 at about 9:15 PM, when the PW1 ಏನು ಅಡಿಕೆ ಚೀಟಿಗಳು ಅಂದ್ರೇನು? DCM ಟೌನ್ಶಿಪ್ ನಲ್ಲಿರುವ ಪ್ರಾಸ 1 ಕಿರಾಣಿ ಅಂಗಡಿಗೆ ಅಡಿಕೆ ಚೀಟಿಗಳನ್ನು ಕೊಂಡು ಅಡಿಕೆ ಚೀಟಿ ಸುಪಾರಿನ ಪಾನ್ ಕೇಳಕ್ ಬಂದ ಅಂತ. ಅದೇ ಸುಪಾರಿ ಏನು ಪಾನ್ ಮೇಡಮ್? ಅದ ಅಡಿಕೆ ಚೀಟಿ ಅಂದ್ರ ಏನಾಯ್ತು ಮೇಡಮ್? 9:15 PM, this petitioner came and purchased pan and also asked water. And even accused number 1 and accused number 1 asked water, and accordingly PW1 gave water. And at that time the PW1 has to return the 3 rupees change and went and put her hand on the cash counter. This petitioner snatched the gold chain worth of rupees 40,000, weighing 30 grams. And hence case has been registered for the offence punishment section 392 of CRPC. The police have registered. Police after the registration of the case investigated the matter and filed the charge sheet. The petitioner was secured. Petitioner and other accused ibruna other accused were secured, and prosecution and both of them have denied the charges leveled against them, and the prosecution examined PW 1 to 10 and also got marked document exhibit P1 to P7 and also marked MO1 gold chain, which was the subject matter of the robbery. The petitioner not led any defense evidence. The trial court, after considering both oral and documentary evidence, convicted the petitioner for the offense 392 of the IPC and sentenced him to undergo 6 months and also to pay a fine of rupees 1,000. In default of payment of fine, another 10 days as simple imprisonment. Being agreed by the judgment of conviction and sentence, an appeal is filed by both of them in criminal appeal number 161 of 2011 and 163 of 2011. The appellate court, on reappreciation of both oral and documentary evidence, dismissed the appeal. Being agreed by the judgment of conviction and confirmation, the present revision petition is filed. The counsel appearing for the petitioner would submit that there is no corroborative evidence to convict the petitioner, and recovery of the ornaments was also not proved by the respondent police. Exhibit P3 is the recovery measure, and PW 4 and 5 are the punch witnesses to the recovery measure, and both of them have turned hostile. In spite of the same, both the courts have committed an error in convicting the petitioner, and there was no any test identification period. And when the petitioner was, when the witness PW1 not having the acquaintance with the petitioner, ought to have conducted the test identification period, and the same is not conducted, and hence it requires interference of this court. Per contra, the counsel appearing for the state submits that the PW1 is the victim who lost the gold chain at the instance of this petitioner and other accused person. And counsel also would submit that specific allegation against this petitioner that he only snatched the Mangalia chain from the neck of the PW1. A2. Adane. Even A1 A2 na. A2 na. Even you. Adare A1 in recovery agide, but you ne snatch madiddu. You mere specific charge. He only snatched the Mangalia chain anta. Aita enaytu madam. Snatch the gold chain belongs to the PW1. There are support madidare madam evidence. PW 1 to 3, 8 to 11. PW1 speaks regarding registration of the FIR when there is an incriminating and acceptable evidence come out from the mouth of PW1, 8 and 11 against both the accused for having committed the offense of robbery. Conduct of PW4 to turning hostile to the case of the prosecution does not in any way sound suspicious. The counsel also submits that the accused number, witness number PW8 and 11 spoken with regard to the recovery of the MO1. And both of them committed an offense of robbery, and MO1 also recovered. And hence the trial court as well as the appellate court considered the evidence available on record. Having the counsel also submits that there are no any criminal antecedents against the petitioner herein. PW9. Kind book. phone booth. Right. The council also submits that PW9 identified the petitioners that they used to come and use the coin booth. On coin booth ನಡೆಸ್ತಾ ಇದ್ನ ಅದೇನ್ ಹೇಳಿದ್ದು regarding presence of accused near the shop. And he has given evidence regarding both of the accused near the shop of the complainant prior to the alleged incident. And he had seen both of them. And the same is also considered by the trial court. And hence it doesn't require any interference. Having heard the petitioner, counsel, and also the counsel appearing for the respondent, and also considering the material available on record, the point that would arise for the consideration of this court are whether the trial court as well as the appellate court committed an error in convicting and confirming the petitioner for the offense mentioned in 392 of CRPC, and whether it requires interference of this court by exercising the revisional jurisdiction. Having heard the respective counsel and also on perusal of material, the prosecution mainly relied upon the evidence of PW1 to 7. Out of PW1 to 7, PW1 is the victim. And no doubt PW4 to 6 have turned hostile. But PW9, in her evidence, has stated that before the incident, she had seen these petitioners near the shop of PW1. The PW1 also reiterated in her evidence in consonance with the contents of Exhibit P1 complaint that both of them came near the shop and asked for the pawn sheet, and while giving change, when the PW1 came near the cash box, the present petitioner snatched the gold chain from her neck. And also the recovery is made at the instance of accused number 1. ಅದು ಯಾರ ಕಡೆಯಿಂದ ಮೇಡಮ್ ಏನು ಸೇಲ್ ಆಗಿತ್ತಾ ಏನಾಗಿತ್ತಾ? ಅದೇ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಮಾರಾಟ ಮಾಡಿದ್ನಾ ಅಥವಾ ಎಲ್ಲಿತ್ತದು? ಅವನ ಮನೆ ಇಲ್ಲ. The same was recovered from the house of the accused number 1. And PW1 also identified the present petitioner. When such being the case, the very contention of the petitioner counsel that no test identification period is conducted, and the same is required when the witnesses are not properly identified the accused persons, and also when they are not having any prior acquaintance with the accused persons. Admittedly, the alleged incident occurred at about 9:15 p.m. in the night hours. And court also cannot expect the other witnesses, and PW19 categorically deposed before the court that she had seen both the petitioners near the shop of the PW1 before committing the offense of robbery. And PW11, then circle inspector, he also deposed before the court that the PW8 produced these accused persons. ಅದೇ ಫೋನ್ ಬಂದಿದ್ರು ಅಂತ, ಫೋನ್ ಮಾಡಕ್ ಕಾಯಿನ್ ಬಾತ್ ಹತ್ರ ಬಂದಿದ್ರು ಅಂತ ಅವಾಗ ನೋಡಿದ್ದೆ ಅಂತ. ಅದೇ ಪ್ರಯರ್ ಟು ದಿ ಇನ್ಸಿಡೆಂಟ್ ಅಂತ. ಏನಾಯ್ತು ಮೇಡಮ್? And PW8 and 11 also the witnesses for recovery. And though PW4 to 6 have turned hostile, the official evidence cannot be discarded only on the ground that they are the police officials, and there must be some answers elicited from the mouth of those witnesses to disbelieve the evidence of the official witnesses, and the same is not found. And hence I do not find any error committed by the trial court as well as the appellate court in appreciation of evidence. and only this court can interfere with the findings of the trial court if perverse findings are given and evidence placed before the trial court is not sufficient to comes to the conclusion that the same is not inspires the confidence of the court, and such circumstances is not warranted in the case on hand. The counsel appearing for the petitioner would submit that he was aged about 24 years at the time. Our history 20 years, sir. 20 years at the time of incident, and is not having any criminal antecedents, and having taken note of the said fact also into consideration, it is an offense of robbery. Snatching the gold chain belongs to the PW1, and also having taken note of the sentence imposed by the trial court, it is only for a period of 6 months. And the same is not harsh as contended by the petitioner counsel, and question of reducing the sentence again doesn't arise. In keeping the gravity of the offense, and it is an offense against the society at large, as well as in order to make the wrongful gain, and hence not a case for even reduce the sentence. In view of the discussions made up, I pass the following. View act. An offense in idರಲ್ಲಿ 397. View act invoke ಮಾಡಿದಾರಾ? ಇವನಿಗೆ ಸಣ್ಣ ಮಕ್ಕಳಿದಾರ, ಇವನಿಗೇನು 20 ವರ್ಷ ಅಂತಿರಲ್ಲ ನಿಮ್ ಪ್ರಕಾರ ಏಜ್? ಏನಿರಲ್ಲ, ಎಷ್ಟು ದಿವಸ ಇದ್ದ ಒಳಗೆ? 65 days. ಫೈನಾ ಎಷ್ಟು ಕೊಡ್ತೀರಿ? ಏನ್ ಪ್ರಿನ್ಸಿಪಲ್ ಇದಾರೆ ಇದರಲ್ಲಿ? ಏನಕ್ಕೋಸ್ಕರ ಇನ್ವೋಕ್ ಮಾಡಿದ್ದಾರೆ? 7 and 8. On record report made by the probation officer division, it is detailed report. It was shows that appellant was below 20 years of age on the date of commission of offense. He was educated up to 8th standard. At the relevant time, he was employed as a carpenter in ECC also. The man comes from a lower middle class but respectable family. His father is a retired school teacher. There are different circumstances. Fell into the undesirable company and turn under the sponsors also. Report sets up the background of the family. Remember further. Yena papa appa school teacher anta ena madavru. Father and brothers are well settled. Parents are keen to improve the appellant and are ready to supervise and exercise control over him. ಏನಾಗಿದೆ ಈಗ? ಮದುವೆ ಮಾಡ್ಕೊಂಡವನ? ಡ್ರೈವರ್ ಕೆಲಸ, ಮದುವೆ ಆಗಿ ಮಕ್ಳಿದಾರ? ಎಷ್ಟು ಮಕ್ಳಿಗೆ ಏಜ್? ಈಗ ಆಲ್ರೆಡಿ 65 ದಿವಸ ಹೋಗಿ ಬಂದ, ಇನ್ನೊಂದು 4 ತಿಂಗಳು ಇರ್ತಾನೆ ಬಿಡಿ, ಏನಾಗಲ್ಲ. The council also relied upon the order passed by the apex court reported in the AR 1983 SC 654, wherein the apex court taken note of the age of the petitioner, who is below the age of 20 at the time of the commission of offense, and his father is a school teacher, retired school teacher, and brothers and sisters have well settled, and parents are keen to improve the appellant and are ready to supervise and exercise control over him, and hence he may be enlarged on invoking section 4 of PO of Act. ಇದು 1983 ಇದ್ರಿ ಇದು. Madam, having considered the principles laid down in the judgment, no doubt the apex court invoked the PO Act while releasing the appellant, and wherein reasons are given that he was below the age of 20 years at the time of the commission of offense, and no doubt in the case on hand also at the time of committing an offense. He was aged about 21 years. Santosh, no, 20 years. 20 years. And the other reason given by the appellate court is that the father of the petitioner is a retired school teacher, and other family members have, including brothers and sisters, have well settled. And the said fact. Idralli appa amma enri idralli ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಲ್ಲ ಮತ್ತೆ ಇನ್ಕಂಪ್ಲೀಟ್ ನೀವು ನೋಡ್ಬೇಕು. ಪ್ಯಾರಾ 8 ಓದಿದ್ಮೇಲೆ ಅದನ್ನೇನಾರು ಹೇಳ್ಬೇಕಲ್ವಾ? ಅಪ್ಪ ಏನ್ರಿ ಅದೆಲ್ಲ ಬರೋದಿಲ್ಲ ಈಗ. ಹೇಳಿ. And here is a case, no such information is available before the court, and already this petitioner undergone he was in custody na, he was in custody ಅಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕನ್ವಿಕ್ಷನ್ ಆದಾಗ ಹೊರಗಡೆ ಇದ್ನಾ? ಮತ್ತೆ he was in custody during the trial stage. He was in custody for a period of 65 days during the trial stage, and remaining sentence only for a period of 4 months, and having taken note of the said fact and no other material is found to exercise the discretion to invoke section PO Act, and hence I do not find any force in the contention of the petition of counsel. We have the discussion made up. I pass the column order. Revision petition is dismissed. ಏನ್ರಿ ಚೈನ್ ಕತ್ಕೊಂಡು ಹೋಗೋಣ, ಅವನಿಗೇನ್ ಫೈನ್ ಹಾಕ್ಬಿಡೋದು? ಆಯ್ತು, ಬೇರೆ ಏನಾಗ್ಲಿ ಬಿಡಿ. ಆಯ್ತು, ನೋ ಫೈನ್. 56 ಏನ್ ಕರೆದಿಲ್ವಾ? MRC ಮನೋಹರ್ ಏನೋ ಇದ್ರಲ್ಲ ಬೆಳಗ್ಗೆ ಏನೋ ಕೇಳಿದ್ವಲ್ಲ ಇವ್ರದೇನು ಏನೋ ಜಜ್ಮೆಂಟ್ಸ್ ಕೊಡ್ತೀವಿ ಅಂದ್ರೆ. ಏನೋ ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲ. ಉದಯ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕನ ಇದು ಆನ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೌದಾ? ಅದೇ ಅದು ಇದ್ರದ್ದು. ನೆಕ್ಸ್ಟ್, consent with respect to 375 involves active understanding of circumstances. Pramod, ಅದ್ರಲ್ಲಿ ಏನು what is the principle in discharge? Quashing ಇದೆ, quashing. Consent 612.
On 19/2016, the appellant engaged in the proceeding to the complaint against the bill. Subsequently, the complaint applies the fact that the appellant was engaged in another matter. The appellant from the complaint that the individual was engaged in demanding to break up the engagement. On the appellant, he promised to vary the complaint and arranged for her to and he had engaged the complaint that the appellant was no longer in the relationship with the complaint. The novel of the apparent Now, the prosecutor can return to next page, analysis. Section 482 law section which the inherent powers before. Advance case decision 482 the inherent the powers of the court here. You wrote kindly. 616. 90. Consent not to be given under fear or misconception. The consent is not a consent intended to by any
section of this code.
If the consent benefit is given to a person under fear or injury or under misconception of fact, or if a person doing the act knows or has reason to believe that the consent was given in consequence of such a misconception. Then next page, para 14. Para 14. In the present case, the misconception of fact, that is very component, is the apparent promise to marry, specifically in the context of a promise to marry. This court has otherwise observed that there is a distinction between a false promise given on the understanding with the maker that it will be broken and the breach of promise which is made in good faith but subsequently not fulfilled. This saga is not to be applicable in the case of the inception he had no intention to keep the house. Inception he promised that he will marry, not getting divorced with his suspect. And later stage, because of his daughter and the suspect, there was some, the daughter was questioning not to divorce his mother, etc. etc. On account of that, he could not fulfill the promise.
Then
you also look at para 16.
16.
Where the promise to marry is false and the intention of the maker at the time of making the promise itself was not to abide by it, but to deceive the woman, to convince her to engage in sexual relationship. There is a misconception of fact that initiates the woman's consent. On the other hand, a breach of promise cannot be said to be a false promise. A breach of promise cannot be said to be a false promise. To establish a false promise, the maker of the promise have had no intention of upholding his word at the time of giving it. He consented to a woman under section 375 is initiated on the ground of misconception of fact. There such misconception was the basis for her to engage in this act. In case of Deepak Gulati, state,
yes.
There is a distinction.
Next judgment ಏನಂದ?
There is a distinction between the mere breach of promise and not fulfilling a false promise. Thus, the court must examine whether there was made at any there was made at every stage a false promise of marriage by the accused, and whether the consent involved was given after only understanding the matter and consequence of sexual indulgence. There may be a case where a prosecutor is agrees to have account of a love and passion for the accused, and not solely on account of misrepresentation made by the accused, or where an accused on account of circumstances which we could not have foreseen or which were beyond his control, was unable to marry her, despite having every intention to do so. Such cases must be treated differently. So in the case of hand, are very applicable to the present And next page. Hence, it is evident that there must be adequate evidence to show that at the relevant time, that the initial stage itself, the accused has no intention whatsoever of keeping his promise to marry the victim. There may be, of course, these circumstances in the person having the best of intention to unable to marry the victim, owing to various unavoidable circumstances. The failure, unavoidable circumstances, the failure to keep up the promise made with respect to the future circumstances, various unavoidable circumstances, the failure to keep the promise made with respect to a future uncertain date due to the reasons that you are not able to clear from the evidence available does not always go to misconception of fact. In order to come within the meaning of the term misconception of fact, the fact must have an immediate relevancy. Such a lengthy case cannot be called into, and in such situation, to alter the act of a girl, such a lengthy case cannot be called into in such a situation to alter the act of a girl is entirely and pass to criminal liability on the others, unless the court assured of the fact that the very beginning, the accused had never really injured the man. Para 17, they also extracted this case.
That is ratio is now clear. Right, clear. Next we go to the another judgment here. 2019 ಯಾವ್ದೋ ಒಂದು ರಿಲೇ ಮಾಡ್ತಾ ಇದ್ರಿ mostly with regard to inner enforcement. Rape and consensual sex, promise to marry. There is distinction between mere breach of promise and not fulfilling the false promise. That is your argument. Yes, madam. Regarding citation is concerned, you make your submission. The sum and substance of the aforesaid decision would be that. Right. They prove only after the trial anta argument. Not at the time of discharge anta. Howda? Ashana? Sure. What the petitioner counsel and also the counsel appearing for the state. The present petition is filed before this court, praying this court to set aside the order passed by the trial court in rejecting the application filed on section 227 of CRPC to discharge the accused for the offences punishable on section 376, 406, 420, 417, 506 of IPC. The factual matters of the case of the prosecution before the police that complainant is that the second respondent, who is the complainant, made an allegation. Second respondent are illuelo. Second respondent madala only idun madidralva. The complainant adu. The complainant made an allegation. She met the petitioner in the month of June 2013 in a social engagement, and frequently they were meeting. After that, contracted through over phone and developed friendship, and friendship turned to love affairs. And thereafter, marriage was also engagement was also performed. At Orissa, right, on 2/6/2013, Huda, 2/3/2014, 14. It is an allegation that in the month of March 2014, when she was in the house of one Gopi, this petitioner came and suddenly committed sexual act against her will, against her wish, and thereafter, with a promise to marry her, continued this sexual act, and thereafter petitioner refused to marry her, and hence complaint was given. Case has been registered for the above offences. The petitioner files an application before the trial court seeking an order of discharge for the charges leveled against him on the ground that there is no material to show the engagement ceremony was performed at Bhubaneswar and ring was exchanged, and not specifically stated in the complaint when the first and last date and how many days the accused had physical contact with the complainant. It is contended that in the email dated 13/7/2014, by the informant, comma, it is mentioned about her love affair, comma, engagement, and having the knowledge of the fact that accused was married and having a daughter of 9 years. And she knew very well about the entire family background of the accused. The statement made under 164 of CRPC are contradictory, and the complaint averments. Then sought for discharge. The said application is registered by the prosecution, contending that offences invoked against the petitioner is heinous in nature, and he is facing the charge of committing sexual act against her wish and committed rape against her consent, and there are sufficient materials and it requires the trial. The trial court, after having heard the respective petitioner as well as the state, comes to the conclusion that there are serious allegations against the petitioner, and the same cannot be looked into at this stage and only during the trial as a defense. The petitioner can put forth all these defenses, and unless trial is commenced, unless trial is conducted, the court also cannot give any finding with regard to the allegations made in the charge sheet. And if the accused is discharged by merely considering the grounds search in the application, it amounts to great injustice and amounts to denial of opportunity for the prosecutrix to prove her charge, and hence rejected the application. Hence, the present petition is filed before the court. The counsel appearing for the petitioner would mainly contend that the very order passed by the trial court is not considering the material on record and fails to take note of the fact that the petitioner is a married person and having 10 years daughter. And also mainly counsel contend that email dated 26/10/2013, which was sent much before the alleged engagement ceremony, clearly discloses that the complainant was fell in love affair with the petitioner. And material collected by the prosecution also, particularly the CW 4, 5, and 6, are the hearsay witnesses. And they are the residents of Orissa. And other official witnesses and their evidence is only formal in nature. And these are the aspects has not been considered by the trial court. The counsel also, in support of this argument, relied upon the judgment of the apex court reported in 2003 within bracket 4 Supreme Court cases 46 Udaya versus State of Karnataka, wherein the apex court discussed with regard to the misconception of fact and consent under misconception of fact. Twin conditions for the applicability of section 90, a false promise, held is not a fact within the meaning of the penal code. The counsel also brought to notice of this court the judgment of the apex court reported in 2019 within bracket 9 Supreme Court cases 608. Pramod Suryaban Pawar versus State of Maharashtra and another, wherein also the apex court discussed with regard to section 90 of IPC, which doesn't define term consent, and also discussed with regard to the misconception of fact, amounts to absence of consent under section 375. The counsel brought to notice of paragraph number 14, 16, 17, wherein detailed discussion was made and exercised the powers of 482 of CRPC. The counsel also relied upon the judgment reported in AIR Online 2019 SC 68, wherein also the apex court discussed with regard to the rape and consensual sex promise to marry. There is distinction between mere breach of promise and not fulfilling a false promise. Having referred this judgment, the counsel would vehemently contend that in the case on hand, it is specific allegation that with a promise to marry her, sexual act was done. And when such being the allegation in the complaint, And charge sheet allegation is also that he did not keep up his promise, and with that promise only he had sexual act. And these judgments comes to the aid of the petitioner. Per contra, the counsel appearing for the state would submit that the very judgment relied upon by the petitioner counsel reported in 2019 in Pramod Suryaban Pawar case, referring paragraph 18, the apex court extracting the paragraph number 13 in the judgment noted in Dhruvaram Murlidhar Sonar versus State of Maharashtra, held that quashing the proceedings, meticulous analysis of then madam 14 alla ನೀವು paragraph number 14, relying upon a judgment on change ಮಾಡಿ in Anurag Soni versus State of Chhattisgarh, discussed with regard to the sum and substance of the aforesaid decisions would be that if it is established and proved that from the inception the accused who gave the promise to the prosecutrix to marry, did not have any intention to marry, and the prosecutrix gave the consent for sexual intercourse and such an assurance by the accused that he would marry her, such a consent can be said to be a consent obtained on a misconception of fact as per section 90 of this IPC. And hence, in the case on hand, the factual aspect is different, and the same doesn't amount to a misconception of fact. And hence, the judgments are not applicable to the fact of the case on hand. Having heard the petitioner counsel and also the counsel appearing for the state, this court has to look into the factual aspects of the case and then decide whether trial court has committed an error in dismissing the application under section 227 of CRPC in discharging the petitioner. Having considered these respective submissions and also on material available on record, particularly in the complaint, a specific allegation is made against the petitioner that both of them fell in love, and earlier they were friends, and both the family members accepting their love affair, an engagement ceremony was held at Orissa, Bhubaneswar in a hotel. It is an allegation that in the month of March 2014, when the petitioner was residing in the house, in the house of in the month of March 2014, when the complainant was in the house of this petitioner, and this petitioner, taking the advantage of no other persons in the house, committed sexual act against her wish, and thereafter promising her that he would marry her, continued the sexual act. Having taken note of this averment found in the complaint, it is specific that taking the advantage of loneliness of the complainant, he committed sexual act against her wish in his own house. And the allegation is that thereafter he continued sexual act with a promise to marry her. Hence, this court has to take note of the allegation made in the complaint. And specific allegation is that in the month of March, taking the advantage of loneliness of the complainant, he committed sexual act against her wish, and thereafter he continued the sexual act with a promise. Hence, the very judgments relied upon by the petitioner counsel that consent is obtained on misconception of fact on the basis of promise to marry cannot be accepted in the case on hand. Specific allegation is that he committed sexual act against her wish, and thereafter he continued the sexual act with a promise to marry her. And when such being the facts and when specific allegations are made that this petitioner subjected her for sexual act against her wish, and the same has to be proved in a trial as held by the trial court. It is an offense of serious offense of 376. invoked against the petitioner, and apart from that, other offences are also invoked under section 406, 420, and 504. When such being the material, and also when the prosecutrix makes an allegation specifically that he committed sexual act against her wish, and the same has to be whether it is with the consent or with misconception of fact as contended by the petitioner, unless the trial is conducted, the very contention of the petitioner counsel cannot be accepted. No doubt, in the judgment of the apex court in Uday versus State of Karnataka, the apex court comes to such a conclusion after considering the material available on records after the trial. And no doubt, full stop. No doubt the trial apex court in the judgment of Pramod Suryaban Pawar case discussed with regard to the misconception of fact. And in the case on hand, question of misconception of fact doesn't arise, and I have already pointed out that it is not a misconception of fact. It is only it is a specific allegation that he committed sexual act without against her wish, and thereafter he continued the sexual act on the guise of promise to marry her. And when such being the factual aspects, it is not a fit case to set aside the order passed by the trial court and the application filed, and consequently application filed by the petitioner under section 227 of CRPC rejected by the trial court is confirmed, and it is a matter of trial, and trial has to be conducted with regard to the serious offense of 376 and other offences. In view of the discussions made up order, petition is dismissed. It doesn't require any interference. ಆಯ್ತು ರೀ, ಕಾಸ್ಟ್ ಹಾಕಿದಿರ್ಲಿ ಬಿಡಿ, ಏನಾಗೋದಿಲ್ಲ. 376 ಇದ್ದಾಗ let him pay the cost on. ಕೊಡಿ. The counsel appearing for the petitioner would submit that the very same application is dismissed with cost of 10,000, and it requires to be interfered with. And while imposing the cost, one second. While imposing the cost, the trial court has given the reasoning that already 5 years time is elapsed after filing of the charge sheet. The accused unnecessarily dragged on the matter all these years and made the victim to wait for all these years to begin the trial, which greatly affected the case of the prosecution due to inordinate delay in securing the witnesses and other prosecution witnesses. And hence comes to the conclusion that accused is responsible for all such delays and liable to be imposed heavy fine of 10,000. Having perused the contention raised by the petitioner counsel and also the reasoning given by the trial court, it is the matter of the year 2016, and this application was rejected in 2021, almost after 5 years. And the same is also taken note of by the trial court that almost 5 years has been elapsed, and unnecessarily the petitioner is dragging the matter and not assisting the court in commencement of the trial. And when such reasoning is given, and it is the matter of the year 2016, and the application was filed in the year ಯಾವ ಫೈಲ್ ಮಾಡಿದಿರಿ? ಇಲ್ಲ ಇದೆಯಲ್ಲ. In the year 2021, almost after lapse of 5 years, an application is filed for discharge, and hence I do not find any reasons to set aside the order of imposing cost also, and well reasons are given imposing cost, and hence it doesn't require any interference of this court even for interfering with the imposing of cost. In view of the discussions made up, I pass the current order. Reporting settlement. ಏನಾಯ್ತು ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್. SV Prakash.
My lord, I am for the appellant, my lord. Settlement failed, my lord.
Settlement failed. ಹೇಳಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳಿ. ಅದರ ಸೈಡ್ ಇದರ ತರನಾಥ್ ಪೂಜಾರಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಯಾರು ನೋಡಿ ಟೈಮ್ ತಗೊಂಡಿದ್ರು ಇವ್ರೇನಾ ಅವರು ಇದ್ರ ಇಬ್ರು ಇರ್ಲಿಲ್ವಾ? ಮತ್ತೆ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಹೆಂಗ್ ಬಂತು?
ಅದು ಪ್ರೀವಿಯಸ್ ಸ್ಟೇಜ್
ಪ್ರೀವಿಯಸ್ ಇರ್ಬೇಕು ನೋಡ್ರಿ.
ಪ್ರೀವಿಯಸ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಇತ್ತು.
Settlement ಅಂತ ಹೇಳಿದ್ರು ನೋಡಿ. ಯಾರ ಪ್ರೆಸೆಂಟ್, ಇವ್ರು ಯಾರು ಆಬ್ಸೆಂಟ್, ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ತಗೊಳ್ಳಿ. The petitioner counsel earlier made submission that there is likelihood of settlement, and in the previous occasion, both the counsels are absent. However, this court has given an opportunity. Now petitioner counsel submits that there is no settlement talks are failed. The respondent counsel is absent. This is the matter of the year 2011, and hence this matter on 8th April. If the respondent counsel doesn't appear on the next date of hearing, matter will be considered in his absence. 63. Venkrappa. ಏನ್ರಿ ಆಲ್ರೆಡಿ 4:45 ಒಂದು ಮೀಟಿಂಗ್ ಇದೆ 5 o'clock. ಎಲ್ಲ ಡೇಟ್ಸ್ ಮೇಡಮ್ ಡ್ಯೂ ಟು ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್ ಅರ್ಜೆಂಟ್. ಎಲ್ಲಾರು ಯಾರ್ದಾರು ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಇದ್ರೆ ಟೈಮ್ ಇದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಿ. ಯಾವ್ದಾರು ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಬೇಕು ನಂಗಿದ್ರೆ ಯಾರು ಮೆನ್ಷನ್ ಮಾಡ್ಬೋದು. 91 ಹೇಳಿ ಏನಾಗ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕಷ್ಟ ರೀ, ಬಾಳ ಇದೆ ನೋಡಿ. ಹೆಂಗಾಗುತ್ತೆ ದಿನಕ್ಕೆ 100 ಹಾಕೊಂಡ್ರೆ ನಾವ್ ಎಷ್ಟೊಂದು ಮಾಡೋದು ನೀವೇ ನೋಡ್ತಾ ಇದ್ರಿ. ನೆಕ್ಸ್ಟ್ ಇಲ್ಲ 8th of April ಆಗ್ಬೋದಾ? ಆಗ್ಬೋದು. 7th ಆಯ್ತು. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಕೃಷ್ಣಮೂರ್ತಿ ಪಿ ಇದಾರಾ? ಆಯ್ತು. ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಆಬ್ಸೆಂಟ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಯಾವಾಗ? 7th ಅಲ್ಲ? 7th April. ಯಾರೋ ಇನ್ನೇನೋ ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಏನಾರು ಇದೆಯಾ? 85 ಇಯರ್ ಆಗ್ಬೇಕು ಹೇಳಿ. ಅದೇ ಸ್ಟೇಟ್ ಹೇಗೇನೆ ಸ್ಟೇಟ್ ಅಲ್ಲ ಅವತ್ತ 8th of April. ಏನಾರು ಎರಡು ಸೈಡ್ ಇದ್ದು NI ಆಕ್ಟ್ ಯಾರು ಇದ್ರೆ ಸಬ್ಮಿಷನ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ 8th of April. 8th of April. ಡಬಲ್ ಫಿಗರ್ ಗೊತ್ತಾಗ ಹಂಗ್ ಮಾಡಿದ್ರು. ರೆಗ್ಯುಲರ್ ಬರ್ತದೆ. ನಮಗೆ ಬಂದಿರೋ ಚೆಕ್ ಮಾಡಿ ನೋಡಿದ್ರು ನೀವು? ನಮಗೆ ಬರುತ್ತಲ್ಲ ಕಂಪ್ಯೂಟರ್ ಚೆಕ್ ಮಾಡಿ ಗೊತ್ತಾಗುತ್ತೆ. ಡೈಲಿ ಡಿಸ್ಪೋಸಲ್ಸ್
ನಾವು ಏನ್ ಮಾಡಿದ್ವಿ?
ಡೈಲಿ ಡಿಸ್ಪೋಸಲ್ಸ್ ಕೊಡೋದು ಬೇಸ್ಡ್ ಆನ್ ಯುವರ್ ಡೀಟೇಲ್ಸ್.
ಅಂತ ಹೇಳಿದೀನಿ ಅವತ್ತು ಕೂಡ ಕೊಟ್ಟಿದ್ದೀನಿ ಕೇಂದ್ರದಲ್ಲಿ.
ಹತ್ರ ಇದೆ 89.
Court officer. Court officer. Court officer.
ಹೇಳಿ.
ನಮ್ 8th ಏಪ್ರಿಲ್ ಅರ್ಜನ್ ಆಗಿದೆಯಲ್ಲ? 8th ಏಪ್ರಿಲ್ ಅರ್ಜನ್ ಆಯ್ತಾ?
ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ್ದು?
83 ಮ್ಯಾಮ್.
ಹೌದು
8th ಏಪ್ರಿಲ್. ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್.
Sorry.